Tomorrow, third. Tomorrow. Bank, DRT matter. Insolvency, why would it be before this court? It's a pending matter. It will come in the regular course. Yes. Fresh matter, pending matter. When is the election? Very nice. You could move it at 2:30, no? Could, third. Yes. Hmm. 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 Within the 30 days, there was 100. Cool. Nade third. Yes. Hmm. What is the urgency? Seize the borewell activity andre? Hmm. No urgency. It will come tomorrow. Serve it on the BBMP. Yes. Let them get instruction. It will come tomorrow. Third. Hmm. You made a mistake in your petition. In the order. In the order. To move, ma'am, tomorrow. Yes. Just a moment. Hmm? 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 What function? Yen function. Hmm. During security issue during Independence Day, walk of 2.5 kilometers. Kodi. Tomorrow. But if it is one location, we can consider. Walk of 2.5 kilometers and all, we can't consider. Yes. Huh? Kodi. But, huh? Hmm. Handicapped and committed offences. There are no pending criminal proceedings. Huh. Hmm. Tomorrow. If you have any matter where compliance have been made are listed, there is no matter pending. If compliance are not made, it will go before the registry. Complied are third. Just a moment, there's somebody senior to you on the right side. Yenapa? Hmm. Tomorrow. Pending matter will come in seniority. Hmm. ನೀವು ಯಾರಿಗೆ ನಾಳೆ ತಗೊಳ್ಳಿ ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗ್ಬೇಕಷ್ಟೇ. ಹ್ಮ್.
traders of a particular business, they have started parking the two-wheeler right from morning 10 till evening, and makes it impossible to enter to the goods, that is new old circuit area.
You know, trucks can enter into the city after 8 o'clock, after 7 o'clock.
During the permissible time of entry,
Hmm.
between morning 11 to evening 4,
Hmm.
that is permissible. During that time, the trader of other
They also need parking, Mr. Kodi. There is no urgency. Yes. It will come, it's a pending matter. It will come in the regular course. Uh-huh. Hmm. There's no, it's a regular matter, no urgency. There's no urgency in it, madam, that it should be taken up. Regular court will take it up when it comes up. Here there was this. Yes. Hmm. The pending matter or fresh matter? Is outside state or within state? Tomorrow. Hmm. Police have locked the premises. So, nadethu. Wait a moment. Huh? Kodi baratte. Yes, it will come. It will come. There is no urgency, Manjunath. Yes. Huh? Hmm. 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 The fresh matter tomorrow.
matter pertains to willful default. The very issuance of show cause notice is not.
No urgency. It will come. Once you are complied, it will come. Yes.
But it's a 21 days timeline.
All fresh matter will come in 3 days if you are complied. So don't move it unless it is urgency. ಇದೇನಂತೆ ಟೋಟಲ್ 6 ಏನ್ ಮಾಡ್ಬೇಕಂತ ಹೇಳ್ಬಿಡಿ ನೀವು ಮೈಕಲ್ ಹೇಳ್ಬಿಡಿ ಏನು
Total 6 matters, serial number 1 to 66, 22 9, 66 to 132, 39, 30th September.
ಯಾವುದು ವಿಡ್ರಾವಲ್ 19 memo of withdrawal dismissed as withdrawn. Total 6 list 1. Huh? 84 ಯಾವುದಮ್ಮ
Sir, 84 or 30th September.
30th September ಅಂತ ಹೇಳಿ. That court will not be sitting for this week. He has undergone a surgery the other day, so this week he won't be sitting. Next week he'll be sitting. That is why the dates have been given that way.
Adjournments. List number 1, page number 4, serial number 26 and 27.
Serial number 25, my lords. We have settled, my lords. Another 2 weeks time may be given, my lords. We the matter is settled, my lords. We'll just report settlement, my lords.
That has been
Serial
settled.
number 25.
3 adjournments ಆಗಿದೆ.
Please, my lords, there are third party who are intervening. We are both are resolving the issue, my lords. Once that is issued, resolved, my lords, we'll file the settlement memo, my lords.
We have no objections. I'm for the respondent.
25 at the request of both the councils relist on 17th September. Take the time and close it. Every time you come with 1 week,
Please, my lords.
weeks and we are adjourning it.
My lord,
Apologies, my lords. Please.
may be posted to 20th, my lord.
He is asking for more than 2 weeks. This is the third time that we have adjourned it. So take your 1 month, settle it and then come.
Please, my lords.
If it gets settled earlier, move it.
Please.
Page number 5, serial number 28 to 31. Page number 6, serial number 32 to 35.
33, my lord. The council is not keeping well, my lord, next week, my lord.
At the request of counsel for the petitioner,
Petitioner.
released on 17th September,
32, my lord.
32. Yes.
I'm for respondent, my lord. See, counsel is not well, my lord. Kindly adjourn. Short adjournment, my lord.
Short adjournment, illa, everything will be in September. Interim order is there. You are for which respondent? Which respondent, madam?
My lord, respondent number 3.
At the request of counsel for the respondent number 3, released on 10th September, interim order earlier granted is extended till next date.
32.
Page number 7, serial number 36 to 40.
Well, serial number 40, my lord.
Yes.
I'm appearing for the respondent number 2, my lord.
Respondent number 2.
Yes, my lord. Kindly 1 week time maybe.
Have you informed everybody?
Yes, my lord. I informed the other side.
All other side, Allah. Respondent counsels, everybody you have informed? Not informed. Then don't mention it. Next.
Page
Well,
number
I
8.
filed the statement of objection, my lord. So,
Have you informed everybody is the only question that we
yes,
are
my
asking.
lord. Our senior will have informed the everybody. Kindly 1 week.
Including the respondent counsels.
Yes, my lord.
Matavle bari petitioner ಅಂತ ಹೇಳಿದ್ರಿ. 40 at the request of counsel for respondent number 2, released on 17th September.
Page number 8, serial number 41 to 46. Page number 9, serial number 47 to 50.
My lord, serial number 47, my lord.
Yes.
I am for petitioner in this case. So seeks 1 week time, my lord, sir. The counsel on record is there.
7 at the request of counsel for the petitioner, 17th September.
Page number 10, serial number 51 to 56. Page number 11, serial number 57 to 61. Page number 12, serial number 62 to 67. Page number 13, serial number 68 to 73. Page number 14, serial number 74 to 80. Page number 15, serial number 81 to 83. Page number 16, serial number 84 to 86. Page number 17, serial number 87 to 89. Page number 18, serial number 90 and 91.
Yes, madam.
My lord, my serial number is 127. I am the petitioner.
Yes.
Kindly overrule the office objection and post for final orders tomorrow. We have found an alternate solution for our PCR problem. That is through paper publication.
Sorry? You have filed amendment application. There's no objections to be overruled.
There is office objection.
You have not amended the cost title. You have not do all those things that we cannot overrule. Do that and then we'll take it up. Yes, next.
Thank you, my lord. When it will be posted, my lord?
When do you want it to be posted? By when will you do it?
Today itself I can do it.
Do it.
Tomorrow?
127, learned counsel for the petitioner. Submit, petitioner party in person. Submit that she'll carry out the necessary amendment and file amended petition. No appearances. Who is appearing for respondent number 2 in that?
My lord, it is commissioner has been impleted, my lord.
Yeah, commissioner of
Police.
police. You will accept notice. And AG accepts notice for respondent number 2. Commissioner of police then?
ಹೌದು sir.
Yes. Released on 9th September.
9th September. My
113.
lord, can it be given a short date?
No, madam. 113.
Thank you.
Certified copy ಸಿಕ್ಕಿಲ್ಲ, stay may be extended ಅಂದ್ರೆ. 113. IA 1/26 is allowed at the request of counsel for the petitioner, released on 10th September. Interim order earlier granted is extended till next date of hearing.
My lord, serial number 104.
104.
Yes, my lord. Our names appear as counsels for R4, my lords, but we have no instructions to represent R4 in this matter. It may be, our name may be deleted. Chidananda.
If you have no instructions, we can't help it that your client is not giving you instructions.
No, my lord.
You file your memo of retirement after giving a notice, then we'll consider.
Filed wakalat only.
Your standing counsel, we have issued, notice has been issued. That's all.
105, my lord. I pray for some kind indulgence. This matter, some urgency is there. We have filed an application
When
for
it reaches,
injunction
When it reaches,
may reach or may not reach ಅಂತ ಒಂದು apprehension ಅಷ್ಟೇ.
if it does not reach, it does not reach.
My lord,
No
what has happened
exception.
is tomorrow at
exception.
2:30,
Then
my
Mr.
lord,
Srinivas will make a
humble request, my lord, not
ಸೆಟ್ಲ್ ಆಗಿದೆ ಮೀಡಿಯೇಷನ್ ರಿಪೋರ್ಟ್ ಬರ್ಬೇಕು
ಯಾವುದು serial number?
ಸೀರಿಯಲ್ ನಂಬರ್ 87 ಮಿಲರ್ ಸೀನಿಯರ್ ಸಿಟಿಸನ್
that may be taken at 2:30 tomorrow, please, my lord.
Can't do it like that. 2:30 we take it up only with parted matters.
ಸೆಟಲ್ಡ್ ಮೈ ಲಾರ್ಡ್ he has to send a report now. Yesterday Friday it is settled.
ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
So ಯಾವಾಗ ಬರ್ತಾರೆ parties?
Parties my lord any day your lordship may fix a date my lord they will present.
Where are they from? Bangalore?
No my lord they are from Shimoga.
So when can they come? We'll fix it as per their convenience.
Next week any day.
87, the counsel for the petitioner submit that the dispute between the parties has been settled through mediation. He seeks for a week's time to keep the parties present for recordal of the settlement. Relist on 19th
90.
at 2:30 p.m. for reporting settlement.
But mediation report has to come by that time. That's all.
Registry is direct secure the mediation report by then.
Much.
ಇಲ್ಲ other next week ಹಾಕೋಣ.
Any day my lord.
If you-
Since it's settled any day it's okay for.
If the mediation report gets delayed and they have to come from
Yes,
Shimoga,
that is the only problem.
relist on 24th August
Much.
at 2:30 p.m. 123 and 125. Memo for withdrawal, dismissed as withdrawn.
Case number 1, fresh matter, serial number 1. Srimati Ashwini.
Appear for the petitioner in this case, my lord.
Yes, madam.
This is a motor vehicle accident case, my lord. The facts are extremely sad. My son was on a two-wheeler, my lord. It is collided with another two-wheeler. Both have passed away, my lord. Both have been taken to the hospital and both have passed away, my lord. However, what has happened is that two MVC claim petitions have been filed by the same parties, the legal heirs of the opposite side.
Same set of legal heirs have filed two proceedings.
Yes, the children.
As for clubbing of both the matters.
My lord, if I may, my lord. So one thing, I mean, there is grave discrepancy in terms of what they have put in both the claim petitions.
I think a club must, you can take advantage.
I will.
Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that from and out of the accident which took place on 6/4/24, there are two proceedings under section 163 which have, of the MVC Act which has been filed, namely MVC number 3474 of 24 and
185 of 24, my lord.
MVC
3474 is in Bangalore, my lord, and 185 is in Ramnagara, my lord.
Ramnagara and Mangalore.
And Bangalore, my lord.
Bangalore. Then if you have to transfer it, notice has to be issued.
So, I mean, I'd like to place one more fact on record, my lord. In fact, we challenged both these MVCs on the same day we filed two WPs, my lord, with the intent of clubbing them and hearing before your lordship, my lord. However, it came up, today it's coming up for the first time, Idu, my lord.
Yes, ma'am.
The Inondu WP, it came up for the first time and it was dismissed saying two claim petitions cannot be maintainable by a coordinate bench of this honorable court, my lord. But my colleague appeared in, sir.
Good.
My colleague appeared in the matter and but our point is not that two claim petitions are there, my lord. Same party, so both may be clubbed and touched, my lord.
You are saying may have been initiated, Anta. Which is the other proceeding which has been initiated? You did not give the number to the coordinate court.
No, that's what, my lord. In fact, the court did not hear us on this. In fact, I wanted to file a memo
That
for...
you can't say. The court would have heard you. But you should... Now also, where is the number in the other proceedings?
Other proceedings is 3474 of 24, my lord.
3474 you are given to the coordinate bench in the other matter.
Yes, my lord.
Which
This
is the other
185, my lord.
185, where is the...
Annexure...
Annexure G.
G, my lord.
Yes.
28, my lord.
That is Srinivas Vishruta Arsha. Where is the claim petition 3474?
I can pass on a copy right now, my lord.
They not produced it. Could he? Who are the parties in that? Vishrut Arsha Srinivas. Told.
I'm producing the other petition itself, my lord.
Bhagya and Dasappa. There are 4 of them.
So in
Gaurama
one,
and Srinivas B are so and so. Magma General Insurance, Arama,
PC Shivanegowda.
is directed to accept notice for respond number 1. Issue notice to respond number 2 to 4. Returnable by 21st September. Process fee and copies to be furnished by end of day 11th August.
Grateful, my lord. Grateful.
Serial number 2, Vijay Kumar.
Cost type.
My lord, my applying for respondent 2, my lord.
Now, the petitioner is challenging the sanction for prosecution. Petitioner is challenging the sanction for prosecution, my lord. It's similar to other identical matters that are already filed.
They're on 28th.
18th, my lord.
18th. And AGA for respond number 1, who is appearing for BL Sanjeev for respond number 2. And AGA for respond number 1 and 3, BL Sanjeev for respond number 2. Connect with WP number so and so and relist on 18th.
Yes.
Serial number 3,
I appear for the petitioner in this matter. Seeking a writ of mandamus, my lords, against respondent numbers 2 and 3. Respondent number 2, my lords, is IDFC Bank. Respondent number 3 is Yes Bank, my lords. The petitioner is a fintech company. What happens, my lords, is various transactions that happen through the course of business. There are certain liens created, my lords, with respect to accounts maintained with R2 and R3 to the tune of 1.64 crores. Now, my lords, I seek clarification as to why these liens exist.
Shri Pradeep Sauka for respond number 1. IDFC Arama.
Suresh V,
Suresh V for respond number 2. Yes Bank.
Francis Xavier.
Francis Xavier for respond number 2. Counsel for the petitioner to serve 2 sets of the petition along with annexure on the said counsel. They are direct to secure instruction, make their submission as regard the prayers sought for by next date of hearing. Relist on 9th September. Grateful.
Serial number 4, Aditya SK, General Payrolls.
General Payrolls.
And AGA for respond 19th August.
Serial number 5, Paniraj Kashyap.
Advocate for petitioner, my lords. My lords, in this matter, my lords, the extension of parole has been cancelled, my lords.
Extension of parole has been cancelled.
Yes, my lord. Rejected, my lord.
Rejected or cancelled?
Rejected, my lords.
Word of a difference between both of them.
Yes, my lord. Rejected.
And AGA for respond number 1 to 4 relist on 19th.
Serial number 6, P. Dada Kalandar.
Appearing for petitioner in this matter, my lords. I filed an application for maintainability of the surcharge petition against me before the respondent number 2 authority, my lords, on the ground that pertains to charge number 3 and 6, there is no assessment against this petitioner in the inquiry made under section 25 of the act. However, the first respondent number 2 authority has rejected the application, against which I filed this petition, my lords. Charge number 3 is concerned.
Page number?
Page number 40, my lords. Charge number 3 is concerned. This is the findings of the inquiry officer, saying that the subcommittee which is constituted for the construction of temple, the subcommittee is held responsible for the liability.
You are a member of the subcommittee?
No, I am not the member of the subcommittee. And the charge number 6 is concerned. It is liability is fixed against the general secretary and the president.
You have to make that submission in the surcharge proceedings.
Please, my lads. Specifically, there is no assessment against me. Therefore, I filed an application.
You filed an application which was rejected.
Please, my lads.
And AGA for.
My lord, it's an appealable order, my lord.
No appeals, my lads.
Surcharge
Societies Registration Act 1960 is not the.
The order of the section 1 shall be final unless it's set aside by the Karnataka appellate tribunal.
The appellate tribunal is closed.
The This proceedings is under section 26 of this Karnataka Societies Registration Act.
Societies registration.
It is not under section provisions of the Karnataka Cooperative Societies Act. In that provision, there is an alternative remedy under section 107. But for this is concerned, there is no alternative remedy.
26(2), the order of the register under subsection 1 shall be
26(2), there is an appeal to the
Final
appellate
order. Final award is concerned. It is interim order. Apply, my IA is being rejected, against which I before this court, my lords. If final orders is concerned, appeal provisions is provided. Final award of fast under section 26 of the Act.
requiring him to repay or restore the money or property. So it appears to be a final order. Interim order is not covered under subsection 1 of section 26.
I'll file my objection.
Now, and AGA for respond number 1 and 2. Who has appeared for respond number 3 in the before the registrar?
Madhu HP. Madhu HP.
ಇಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ತಾರೆ.
He may appear. He is appearing in the DRC.
Bangalore
respondent number 2.
Issue emergent notice to respond number 3, returnable by 9 September. Counsel for the petitioner is also permitted to serve. The counsel for respond number 3, who had appeared before the registrar, has also take out answers on respond number 3. The further proceedings in respect of the petitioner before the second respondent in DRB 1 of 2024-25 is stayed till the next date of hearing. Process fee and copies to be furnished by end of day 11th August, failing which the interim order will stand automatically vacated.
Serial number 7, Kiran N.
For the petitioner in this case, Manoj, the petitioners are the degree holders in execution petition filed before the trial court, Manoj, wherein the trial court has ordered for granting the police protection to execute the judgment that degree passed in the original.
Where is that order?
In page number 42, Manoj.
Yes, you have to do it.
My lords, the issue is, I admit that there is an order, my lord, but the delivery warrant has not been issued, my lord. For the execution of the order, I have to assist the court Amin, my lord. I can't go along with the DHR and get him the possession in an execution proceeding. There is no order, and also before passing this order, my lord, there is no report of the Amin as held by this Honorable High Court. Before passing for police protection, the Amin should file a report telling he has been obstructed for carrying on the judgment. On the perusal of order sheet, there is no such report filed by the Amin, my lord.
This is not for recovery of possession.
It's for recovery of possession, my lord.
This is not for recovery of possession. This is restraining interference with possession.
No, my lord.
PC 41.
The DHR is hereby allowed. Concerned jurisdiction hereby assist the DHR to get the possession of the suit.
But look at page 41. Unless and until police help is not granted by this, it's very difficult for us to restrain from illegal interference. Without police protection, we can't restrain the respondent from interfering in this application. Her DHR satisfied. The operative portion is not proper. What they are seeking for is only not to interfere. Where is your application?
Application is in page number 37, Manoj. 34.
34.
Kindly see his representation, my lord.
Where is the order in OS 57?
Manoj, in page number 26 and 28, Manoj.
Operative portion 28.
Yes, Manoj. After passing the judgment and decree in favor of the plaintiff, my lord, the petitioner herein.
I'm interfering with possession of her.
My lord, his representation only clearly says that they have taken the possession, my lord. This is page 44.
My lord, it is the grievance of the petitioner is, my lord, after passing the judgment and decree during the pendency of the execution.
ಆದ್ರೆ ದಿನಾಂಕ 21 ಎದುರುದಾರರಿಗೆಲ್ಲ ದಲಿತ ಸಂಘಟನೆ ಕಾರ್ಯಕರ್ತರು ಎನಿಸಿಕೊಂಡ ಆಸಾಮಿಗಳ ಸಹಾಯದೊಂದಿಗೆ ನಾವು ಅನುಭೋಗದಲ್ಲಿರುವ ಪಿತ್ರಾರ್ಜಿತ ಜಮೀನಿಗೆ ಅತಿಕ್ರಮಣ ಮಾಡಿ ಸುಪರ್ದಿಗೆ ಪಡೆದುಕೊಂಡಿದ್ದು ನಾವು ಅದನ್ನು ಪ್ರಶ್ನಿಸಲು ಅಟ್ರಾಸಿಟಿ ಕೇಸ್ ಹಾಕುತ್ತೇವೆ. ಮೈ ಲಾರ್ಡ್, he can take the possession in the execution, my lord. But
He can't take possession because it's only injunction restraining interference.
but in violation.
My lord,
as
the
per-
issue is, my lord, after passing the judgment and decree in favor of the petitioner, during the pendency of the execution proceedings was not initiated by the petitioner. After passing the decree, they have trespassed into my land and they have taken the position and they are threatening me for filing
Counsel,
this.
your suit was for interference with restraining interference. That is what was decreed.
Yes, my lord.
Your suit was not for taking possession.
Of course, my lord.
In execution, you again gone before the court asking for implementing the interference aspect. Now for the police, you have gone and said police protection to take over possession can't be granted.
My lord, my issue is, my lord, after passing the judgment and decree in favor of me, definitely the respondents are, defendants in the original suit are stranger to my land. They have encroached my land and they are sitting in the land and threatening us for filing an case under Atrocities Act.
Your decree is restraining interference with
Yes, my
possession.
lord.
So that is how much you can enforce, nothing more than that. Go get a possession decree from the court, then they'll enforce it.
My lord, possession was taken forcefully after passing this decree and passing the judgment
We
and
can't
decree. My lord.
advise you what you have to do. There's to be finding on that.
My lord,
The police cannot be used like that.
my lord, prior to filing the execution, the position, we were in the position, my lord. Once the decree and judgment came to the knowledge of the
Police can only assist in implementing the order passed, nothing more. That much you should know.
the order may be passed at least to that extent, my lord.
And AGA for respond number 1
That
to 4.
extent.
Petitioner is before this court seeking for the following reliefs. The petitioners had filed a suit in OS number 57 of 2016 before the second additional civil judge in JMFC at Kanakpura, which came to be decreed on 13 December 2019, restraining the defendants therein from interfering with the plaintiff's possession and enjoyment of the suit scheduled property therein. The petitioners filed an execution proceedings in execution number 6 of 2021 for implementing the said order. In the said execution proceeding, an application had been filed for seeking for police protection to implement the judgment decree passed in OS number 57 of 2016. Subsequently, the said application came to be allowed on 8/4/26. Subsequently, the petitioner had submitted a representation on 3/7/26 to the respondent police, contending that though a decree had been passed on 21/20/21, the respondents therein had taken possession of the petitioner's property and as such called upon the jurisdictional police to render police assistance in recovering the possession from the respondents stroke defendants in the said suit. Learned AGA submit that the said representation could not be considered since there is no direction directing recovery of possession. Hence, without such a direction, a police protection could not be given for recovery of possession. There is substance and merit in the submission made by learned AGA, inasmuch as the decree which had been passed in OS number 57 of 2016 was to restrain the defendant from interfering with the possession. Though the petitioner claims that after the decree was passed on 13th December 2019, the possession was taken over on 20th January 2021, the execution proceedings, the application in the execution proceedings was filed in the year 2026 after nearly 5 years. This aspect of whether possession had been taken after the decree or not would have to be ascertained in a appropriately instituted proceedings. The decree in favor of the petitioner being only to restrain the defendants from interfering with the possession, there cannot be a direction issued to police to recover possession and hand over to the petitioner. No grounds being made out, reserving liberty to the petitioner to avail of such remedies as are available under law. Petition stands dismissed.
Serial number 8, Hinduvi.
For the petitioner,
yes.
Writ of mandamus. My proceedings before the RERA for recovery, I succeed in that. Thereafter, my lords, the RERA issues a direction to the Deputy Commissioner to issue proceedings under the Karnataka Land Revenue for recovery, my lords.
41.
Please, my lords.
And AGA accepts notice for respond number 1. Notice to respond number 2 and 3 is dispensed with since they are not required to be heard in the present matter. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the petitioner having approached the Real Estate Regulatory Authority and the order having been passed in favor of the petitioner, recovery certificates under section 40(1) of the Real Estate Regulation Development Act 2016 had been issued on 12/10/25 and 12/11/2025 at Annexure B and C respectively, which the petitioner claims has not been implemented, and it is in that background that the petitioner is before this court. And AGA on instruction submits that an office of the Special Deputy Commissioner has been constituted for the purpose of implementation of all orders passed by the Real Estate Regulatory Authority and the recovery certificate which have been issued. He submitted that given 4 weeks' time, the said order would be the order in the present matter would be implemented. The said submission of learned counsel, learned AGA, answers the grievance of the petitioner, placing the said submission on record. Petition stands disposed.
Please, my lords.
Serial number 9, Prajwal P.
Your Lordship, I am appearing for petitioner. Item number 9, writ petition number 23/443/2026. My Lord, challenging illegal preventive detention of 22-year-old hotel waiter under section 136/141 BNS. No affair, no crime, 90+ day in custody, praying to quash order
Preventive
and
detention.
release on
Preventive
personal
detention
bond.
ನಮ್ಮಂದೆ ಬರುತ್ತಾ ಇಲ್ಲ division bench ಹೋಗುತ್ತಾ? Jagdish had made a submission last time that preventive detention has to go to division bench.
Just verify, my lord. Kindly pass over.
Pass over,
Clear
verify.
order, no? Clear.
That's it. Because another matter which had come Mohan had filed, it said it has to go before the division bench. Check with the SPP.
Serial number
Pass
10,
over.
Girish R.
Extension of general parole.
Extension of general parole.
Extension.
Yes, my lord. Extension of general parole, my lord.
All proper? No complaint?
Earlier he surrendered, my lord.
Seek inspection, my lord.
First time parole, huh?
But he's in custody. Yes, my lord.
You have surrendered?
Yes, my lord, surrendered, my lord.
When did you surrender?
Surrendered on 18/6/26, my lord.
Pass over.
11, Nagbhushan R.
Lordship. Rowdy sheet has been opened against me, my lord.
The SPP has to appear in this matter, my lord. SPP has to appear in this matter.
SPP has to appear.
Yes, ma'am.
ಏನಪ್ಪ ಅಷ್ಟು ದೊಡ್ಡ ಮಾಡ್ರೆ ಪಾಸ್ ಓವರ್
11,
Great.
serial number 12, B. Pradeep.
Limitation. Limitation.
limitation 12 limitation disposed.
13, Madesh VM.
This is a petition, my lords, challenging the order of the adjudicating authority. Lords, there is
Adjudicate section 8, yes.
Lords, there is an earlier writ petition, my lords, which is pending, where I had challenged the order of the provisional attachment order. That is also pending.
18/3/26 you are challenging.
Please.
Ms. Annapurna Bardala accepts notice for respondent number 1 and 2. Counsel for the petitioner is directed furnish 2 sets of the petition along with annexures on the said counsel. Relist on 25th August.
Please. Lords, your lordship, please. So list it along with WP 8397 of.
Any date in that matter?
No, ma'am. So,
Connect with WP number so on so birth code.
please.
Serial number 14,
Sir.
Basuraj VM.
Great.
Basuraju. Guess it not. Mr. Basuraju.
require some hearing, my lord. It's relating to a particular course which is not recognized while appointing surveyors. That notification is challenged saying include this particular course, my lord, which is called NCVT, National Council of Vocational Training.
Get your instruction. And AGA for respond number 1 to 5. KEA, there is a separate council, Allah.
Yes, sir. 1, 2, 3, 4, my lord, I'll take notice.
5.
5, I think there'll be a separate council.
Department of Industrial Training and Employment. Department. Commissioner Department. 5.
I'll take notice.
Karnataka Examination Authority, Allah.
NK Ramesh.
NK Ramesh for respond number 6. None appears for the petitioner. Counsel for the petitioner furnished 2 sets of the petition along with annexures on the aforesaid counsel who are granted 2 weeks time to obtain instruction make the submission. Released on 10th September.
Serial number 15. Nataraja.
Yes, Mr. Nataraj.
Lord, but petitioner, my lord, how they insert the sub-register, my lord, the sale deed in, my lord, total measurement is, my lord, 24 guntas. They made it as 35 guntas, my lord. Lordship would find it in page number 100. The encumbrance certificate speaks.
Hmm.
100 ಅಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 390/4 11 ಗುಂಟೆ 392/24 ಗುಂಟೆ ಅಂತ ಬರೀತಾರೆ. 35 ಗುಂಟೆ ಆಗದೆ ಇದು. ಆಕ್ಚುಲ್ ಆಗಿ ಇರೋದೇ 24 ಗುಂಟೆ ಇದು. May take a lordship kind attention to the sale deed.
RTC.
Sale deed dated, that is annexure B, my lord, page number 18. This is the sale deed executed, that is, which shows the exact measurement. Kindly come to page number 26, my lord. 394 11 guntas and total 23 guntas land is there.
So this is a sale deed dated 25th August.
25th July 1986.
Same entry in encumbrance certificate is.
ಆಮೇಲೆ representation is made. 5 representation ಕೊಟ್ರೆ ಕೋರ್ಟ್ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಹೋಗಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅಲ್ಲ, what they say is if there is a mistake in the document, what they say there is interpolation. They are alleging against
in the document there is no mistake. The document says
In our
12
document
guntas
there is no mistake.
and 11 guntas, 23 guntas is what you have registered. In the encumbrance certificate there is a mistake. That has to be rectified. There is not a mistake in the document. If document civil court, yes.
I will check out the instructions as to what is.
And AGA for respond number 1 to 4. The grievance of the petitioner is that the sale deed which has been executed is for sale deed dated 25/7/1986.
Two different survey numbers
for 11 guntas and survey number 391/4 and 12 guntas and survey number 392/3, totally measuring 23 guntas. However, in the encumbrance certificate, survey number 391/4 is shown to measure 11 guntas and survey number 392/3 is shown to measure 24 guntas, totally amounting to 35 guntas, which is far in excess of what was sold under the aforesaid sale deed dated 25/7/96. Is submission of learned counsel for the petitioner is that despite a request for rectification of the encumbrance certificate being made, no such rectification has been made. And AGA seeks for and is granted 10 days time to obtain instruction, make his submission, released on 25th August.
Serial number 16.
Yes.
This challenge, my lords, is to the virus of the amendment to the Banking Regulation Act.
Banking Regulation.
The corrected matters, my lords, are posted on 25th.
Since the virus of section 10A2A1 of the Banking Regulation Act 1949 has been challenged, issue notice to learned Attorney General. And ESGA accepts notice on his behalf. Ms. So-and-so accepts notice for respond number 1 to 3.
Yes.
4 Yarama, Reserve Bank, Idrali.
Manik BT.
Manik BT for respond number 4 and AGA for respond number 5 and 6. Respondents are restrained from taking any coercive steps against the petitioner till the next date of hearing. Connect with so-and-so, released on 25/8.
Obligement.
17. Devraj M.
Yes.
Petition. Minute. Millet, the petitioner as appointed by the Hindu Environment Commission, Millet.
Has been appointed as?
Peshkar, Millet.
Hmm.
In that, Millet, Annexure A is the government order, Millet.
Hmm.
Annexure, may I read it, Millet? In this, Millet, in the mid para, Millet, ಪ್ರಸ್ತುತ ಸುಮಾರು 35,000 ಅಧಿಸೂಚಿತ ಸಂಸ್ಥೆಗಳಿದ್ದು ಕರ್ನಾಟಕ ಹಿಂದೂ ಧಾರ್ಮಿಕ ಸಂಸ್ಥೆ ಮತ್ತು ಧರ್ಮದತ್ತ ನಿಯಮಗಳು 2002ರ ಅಧಿನಿಯಮ 10/4 ಹಾಗೂ ಸರ್ಕಾರದ ಆದೇಶದ ಸಂಖ್ಯೆ ಕಾಮ್ ಇ 17 ಮಸೂವೆ 2005ರ ದಿನಾಂಕ 2026/2/25ರ ಆದೇಶನ್ವಯ ಆಯುಕ್ತರು ಮಾತ್ರ ವರ್ಗಾವಣೆ ಅಧಿಕಾರವಾಗಿದ್ದು ವರ್ಗಾವಣೆ ಅನುಷ್ಠಾನ ಕಷ್ಟವಾದ ಸಾಧ್ಯತೆಗೆ ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಇಲಾಖೆ ವ್ಯಾಪ್ತಿಗೆ ಒಳಪಡುವ ಅಧಿಸೂಚಿತ ಸಂಸ್ಥೆಗಳು ಸಮರ್ಪಕ ಆಡಳಿತ ನಿರ್ವಹಣೆ ದೃಷ್ಟಿಯಿಂದ ಕರ್ನಾಟಕ ಹಿಂದೂ ಧಾರ್ಮಿಕ ಸಂಸ್ಥೆಗಳು ನಿಯಮಾನುಸಾರ ಈ ಕೆಳಗಂತೆ ಆಯುಕ್ತರಿಗೆ ಇದೆ. Millet, in this millet, ಧಾರ್ಮಿಕ ದತ್ತಿ ಆಯುಕ್ತರು A permanent. This temple comes under the A grade temple, millet. In the same second page also, the government has issued the order, millet. This ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ ಕಾಮ್ ಇ 65 ಮಸೂವೆ 2015 ದಿನಾಂಕ 20.
Transferred you now?
The petitioner, millet. The DC has transferred the petitioner, millet. But annexure D.
DC is only for class B.
Yes, millet.
Kindly tell us annexure C, my lord.
Annexure?
C.
Page?
Page 17. 26, 5/2026. ಬಂಗಾರಪೇಟೆ ತಾಲೂಕು ಟೌನ್ ರಾಮಬಾಬು ಎಲೆಮಲ್ಲಪ್ಪ ಛತ್ರದ 26-27 ಸಾಲಿನ ಆಯಾ ಶ್ರೇಣಿ ಅನುಮೋದನೆ ಬಗ್ಗೆ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿ ಬಂಗಾರಪೇಟೆ ಉಲ್ಲೇಖ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿ ಕೋರಿಕೆ ಮೇರೆಗೆ ಬಂಗಾರಪೇಟೆ ತಾಲೂಕು ಟೌನ್ ಶ್ರೀ ರಾಮಬಾಬು ಎಲೆಮಲ್ಲಪ್ಪ ಛತ್ರ ಸಮೂಹ ಬಿ ಶ್ರೇಣಿಯ ಅಧಿಸೂಚಿತ ದೇವಾಲಯಗಳಾಗುವುದರಿಂದ ಮೈ ಲಾರ್ಡ್. As of today, it's still a B grade, my lord. B ಶ್ರೇಣಿ ದೇವಾಲಯದಲ್ಲೇ ಇದೆ, grade B.
How do you say you are A grade?
Millet, annexure C, D, millet. Millet may see in this, millet. ಅಧಿಸೂಚಿತ ಸಂಸ್ಥೆಗಳು ವರ್ಗಾವಣೆ ಮತ್ತು ಅವುಗಳ ನಿಯಮಿಸಲಾದ ಪ್ರಾಧಿಕಾರಗಳು 3 millet ಅಧಿಸೂಚಿತ ಸಂಸ್ಥೆಗಳ ವರ್ಗೀಕರಣ ಅದರಲ್ಲಿ ಅಡಿಯಲ್ಲಿ ಪ್ರವರ್ಗ A 25 ಲಕ್ಷ ರೂಪಾಯಿಗಳು ಮೀರಿದ ಒಟ್ಟು ವಾರ್ಷಿಕ ವರಮಾನ ಹೊಂದಿರುವ ಅಧಿಸೂಚಿತ ಸಂಸ್ಥೆಗಳು, millet. Coming to the annexure C only, millet, page number 18, millet. It clearly says that, millet, and yearly budget is 31,95,860 rupees, millet. It will consider as an A grade temple, millet.
Has it been classified?
Yes, millet. But now what is happening, millet? Now all the classification is moving, millet.
As of today, it's not yet classified, my lord, from annexure C.
But it's clearly mentioned, millet, if it is at 25 lakh.
Has it been classified, Mr. Counsel? It may be mentioned.
No, millet.
As a you were below 25 lakhs earlier. Now you have increased to 31 lakhs.
No, millet. In the all the which has transferred me now, millet, it also below 15 lakh rupees, millet. It is in a clearly says, millet.
Be a litapa. Below 25 lakhs. Above 25 is A. So now your donations and everything have increased to more than 25
Yes, exactly, millet.
But is the classification done?
ಅಲ್ಲ millet, ಈಗ ಏನಾಗಿದೆ ಅಂದ್ರೆ from 3 years
ಇಲ್ಲ ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ
ಅಲ್ಲ from 3 years it's
ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಆಗಿದೆಯಾ
ಇಲ್ಲ ಇದರಲ್ಲಿ B grade ಅಂತ ಮೆನ್ಷನ್ ಮಾಡ್ತಾರೆ. But ಇದು additional DC, millet.
It was B grade, my lord.
You asked for the classification first and then only. Then deputy commissioner, there can't be a vacuum.
No, millet.
Until the classification.
Yes, millet. But in my appointment letter, millet, the annexure G, millet, page number 28, millet.
Yes.
In the para number 5, millet, ಈ ನೌಕರರಿಗೆ ವೇತನ ಶ್ರೇಣಿಯಲ್ಲಿ ನೀಡುವ ಬಗ್ಗೆ ಸಂಸ್ಥೆಗೆ ಆರ್ಥಿಕವಾಗಿ ತೊಂದರೆ ಕಂಡು ಬಂದಲ್ಲಿ ಅಲ್ಲಿನ ಹುದ್ದೆಯನ್ನು ಹೆಚ್ಚು ಆದಾಯವಿರುವ ದೇವಾಲಯಕ್ಕೆ ವರ್ಗಿಸಲಾಗುತ್ತದೆ. In this, millet, may pass, millet, where I have transferred, millet, may pass, millet. In this, millet, same. I have transferred to Kodaranda Swami temple, millet, in Bangarpete, millet. Now, in the Kodaranda Swami temple, millet, it is an 18,92,311 rupees, millet.
Yes.
My salary is 56,000 something, millet. If I transfer to that temple, millet, my salary will be deducted as per the budget, millet.
And AG accepts notice for respondent 1 to 3 seeks for and is granted 10 days time to obtain instruction, make a submission as regard the reason for transfer of the petitioner to a temple whose In turnover, what do you call it?
It's a
My lord,
budget, my lord. It's a budget.
same grade, my lord.
No, no.
Whose
Well,
budget?
Kodandam temple is also in grade B, my lord. This temple is also in grade B. My lord, he cannot say that if I go to some other temple, my salary will be reduced because based on the
Verify and make your submission as to whether salary is protected. That's
Please,
what. That's
please.
how much you can claim.
Please.
You get your to a temple which has lesser budget than
Yes,
the
sir.
one that he has been posted for. And AGA seeks for and is granted 10 days time to obtain instruction, make a submission as to whether there would be any reduction or otherwise in the salary of the petitioner on such transfer.
Mean-
Relist on
Meanwhile,
19
my stay may granted, my lord, because
necessary.
he's relieving my lord. They are relieving me, my lord. Please, my lord.
We'll set it aside if he is going, if he says that the
I
salary
agree, I
is
agree.
less. If he makes a submission, your salary is same thing, it doesn't matter.
Please, my lord.
Serial number 18, Nitin BM.
Here on behalf of the petitioners, my lords. Lords, you made a representation on Annexure A. They have issued an endorsement at Annexure A, my lords, stating they have quoted the Supreme Court.
Yes.
Lord, an application is made by the wife of the deceased seeking for the salary slips, my lord.
Seeking for?
My lord?
Seeking
Salary slip, my lord.
Copy of?
Copy of the salary slip. Earlier, the same copies were produced, submitted by those respondents. Now they issue an endorsement stating that as per the Supreme Court judgment, it could be. I just took out the Supreme Court judgment, my lord. It says with respect to RTI, if there's something, third party makes an application under RTI, then it cannot be. Because the E-series, if your lordship is pleased to see E-series, these salary slips are required for the petitioner to submit it in the civil court in a suit for specific performance, where they wanted to establish that her husband was working in a government institution and he was drawing.
Husband is expired.
His husband has expired. So she requires a certified copy of the salary slip. If your lordship sees the E-series, my lord, it is produced in those courts only. I have just taken out the certified copies. It is issued by them in the year 2023.
She's claiming under the husband, not adversarial to the husband like matrimonial. You have to give it.
Let me secure instruction on what basis they have not.
And AGA.
My matter is on the next week, my lord. Matter is on the next week where I need to produce this as annexures.
Let him get instruction.
Yes, my
Take
lord.
adjournment.
Maybe I request, only request is for a shorter date.
And AGA accepts notice for respond number 1 to 4. The application for issuance of copies, certified copies of the payslips of the late husband of the petitioner was made by the petitioner for purpose of being used in a pending specific performance suit.
Yes, ma'am.
The request for the certified copy of the payslip is not made for the purpose of usage against the husband who is expired, but to protect the property that she has derived title by devolution on the expiry of the husband. In that view of the matter, learned AGA is direct secure instruction make a submission as to why the copies have not been furnished when there is no adversarial interest between the petitioner and the late husband. Relist on 19th August.
Maybe in the same stage, my lord.
In preliminary hearing.
Yes, ma'am.
19, Mahendra Ji.
Petitioner hearing challenge the order passed by the second respondents under the Senior Citizens Act in part. Not insofar as the order passed against the present petitioners, I am not challenging. I am challenging the only insofar as the direction given to the fourth respondent to take care of this third respondent. The third respondent is the husband, fourth respondent is the wife. Now, my lords, the wife has filed an injunction suit against the husband. TI was not granted. Subsequently, daughter has filed the suit injunction against the father. TI granted. Now, my lords, the wife has filed a multiple complaints before the various authorities against the husband.
Wife is your mother.
Please, my lords.
Then why is
And the
saying
limited
wife?
prayer is, my lords, we are taking care of our father. We are bearing all expenditures, medical as well as, my lords, he is not agreed to stay with the sons. Then, my lords, we have admitted him to the old age as per his choice. My lords, for that expenditure also
You
we
are
are
taking
bearing.
care of him. Why should you admit him to a old age home?
But he's not agrees to come because the reports are there, my lords. I will take your honors to.
My lord, this matter, there's a connected matter, if a lordship can
Please,
kindly
Lords.
recall.
Ramakrishna Pillai.
Ramakrishna
Please,
Pillai,
Lords.
where we had the
Please,
medical
please.
board was to be constituted. The report has been sent, it is with the register.
Now the daughter is said that Shravan had appeared and
Appeared,
Please, please,
Shravan
Lords.
Bharadwaj appeared in that matter, yes, my lord.
In fact, my
was,
lords, in that matter, I
you are
moved a
not
memo.
ready to pay his medical
Yes,
expenses.
I'm ready to pay, my lords, whatever the expense.
Your sister is agreed to pay. She's been taken to KMC hospital
She was not
Please,
allowed
instead
to.
of the government hospital.
Please, my lords.
Deposit 10 lakh of rupees.
My lords, I will take your honors, my lords. May I request, my lords,
You
kindly
deposit
turn
10
to.
lakh of rupees for the medical
Legal expenses.
expenses.
My lords, my only concern is, my lords, the whatever the medical expenditures, I'm ready to bear.
Deposit.
Please, my lords, the problem is
When will
here.
you deposit?
My lords, whatever the medical bills I'm going to pay, my
When will
lords.
you deposit 10 lakhs? Estimated is 10 lakhs.
My lords, actually, we were not aware that, my lords. That is the problem here. my lords.
Aitappa, even now you are aware. When will you
Please,
deposit?
my lords. My lords, I will go to the hospital, my lords. I'll verify and pay whatever the
You
charges is
deposit
there.
here in court.
Please, my lords.
When will you deposit?
My lords, before that, my lords, I'll take your honors for one moment for the earlier discharge summons, which I have admitted him for the hospitals.
Now you are ready to pay.
Please, my lords.
So deposit.
My lords, I'm ready to everything, my lords. Only my prayer is restrict the wife and the daughter from the interference of day-to-day affairs of Ramakrishna.
That is your problem.
Please, my lords.
Deposit now.
Now, my lords,
Then we will consider. Then we will hear you.
at least some documents may be provided to me, my lords.
Nothing will be given to you. You don't deserve anything. Not even in one waste paper you deserve.
My lords, may
Are you going to the last time we are going to ask you?
Please, my lords.
Are you going to deposit or not?
Please, my lords. I will deposit.
When
my
will
lords.
you deposit?
I will take instruction on that, my lords.
And AGA for respond number 1 and 2. Shri Shravan Bharadwaj for respond number 3 to 5. Who is respond number 6?
He's the son-in-law.
Respond number 3 to 6.
He's
Connect
Ashok.
with WP number.
21751.
In fact,
So-
annex that order also, my lords, in this petition.
Page number.
In page number 74, my lords. Because I have not received any notice, Tashildar has communicated this order to me. So I have
Connect
annexed
with
this.
WP number 21751 of 26. The outdate is the
27.
counsel for the petitioner on inquiry as to whether he is ready to deposit 10 lakh of rupees. He seeks for and is granted a week's time. Yavatide?
27th August.
27 August. Seeks for a week's time to obtain instruction, make his submission. Released on 27/8.
Much obliged.
Serial number 20. Fire staff.
Yes, Faiz.
But in this case, the petitioner is seeking for mandamus.
Hmm.
Annexure T, page 175, my lord.
Hmm.
The petitioner father was the owner of this property that has been granted by the land tribunal. Land tribunal, my lord. Thereafter, his brothers,
To cancel the agreement of sale.
though there is an interim order granted by the trial court, appellate court, that has been registered in the portal of the sub-register office. Despite the same lord.
And as for a mandamus like this, Mr. Faiz, you get an order from the court.
That already order is there, my lord. By violating that order after obtaining the interim
It's
order.
only an interim order.
Yes, my lord.
So now you have to ask for cancellation there and get it.
Because during the pendency of the proceeding also, there is an interim order granted by the appellate court. Despite the same, he has done that.
Land AG for respond number 1, 2, 3. Notice to respond number 4 to 59 is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking for the following leaves. The grievance of the petitioner is that the representation which has been submitted by the petitioner to respond number 2 and 3, that is the sub-registrar Nelmangla and sub-registrar Dodbadapura on 9/1/25 at annexure T has not been considered by respond number 2 and 3. The representation which has been submitted is for cancellation of the agreement of sale executed amongst the other respondents, which is stated to be in violation of the interim order dated 28/11/24 passed in RA number 35 of 24 by the first additional senior civil judge and JMFC Nelamangla. The submission of Shri Fayaz Saab, BG Learned Counsel for the petitioner, is that the agreement of sale having been executed in violation of the interim orders and registered by respondent number 2 and 3. Once it was brought to the notice of respondent number 2 and 3
Quite
that
the
there
same
is a
here,
violation of an interim order, it was required for the sub-registrars to have cancelled the registered agreement of sale. This court is unable to accept the submission of the learned counsel for the petitioner. If there is a violation of any interim order, it is for the petitioners to have approached the appropriate court and avail appropriate remedies. Since there is since apparently, admittedly, there is a registered agreement of sale, it is for the petitioner to seek for such reliefs as are permissible, including cancellation of those registered agreement of sale. A representation to the sub-registrar cannot be the basis of cancellation of a registered agreement of sale. There is no vested interest in the petitioner seeking for such a relief. Hence, a mandamus cannot be issued to the respondent to consider such a representation. No grounds being made out.
Liberty may be given.
Adidella, ಹೇಳಿದೀವಲ್ಲ.
It
It is for the petitioner to approach the court ಅಂತ ಹೇಳಿದೀವಲ್ಲ.
21, Ashok Kumar.
Lords, appearing for petitioner in this matter. In this matter, in the previous date, I had to actually take instructions from the petitioner regarding how she obtained permission from her husband.
How did you
But
contact?
it was through mutual relatives, my lord. There is no documentary evidence to substantiate her saying related to that.
Make them a
But,
party.
my lords, I rely upon a judgment passed by Andhra Pradesh High Court, my lord, in WP. I kindly pass over.
You will direct them to consider your application and they'll reject it at annexure D.
No, my
You
lord,
want that order?
because his
Fine.
whereabouts is not known, my lord. And
Petitioner is before this court seeking for the following reliefs. The submission of the petitioner is that the petitioner is the mother of.
my lords,
What
one
are
more
their
submission,
names?
my lords. Only reason for not mentioning the name of the father in annexure D
Of
and annexure
Varun Abhilash and Kumari Diyashini. The petitioner had made an application for renewal of the said passports. Their passports, which has not been considered by the respondents. The submission of learned counsel for respondent number 1 and 2 is that the necessary declaration in annexure D
and annexure
as
C, my lord.
C and D had not been filed.
It
Counsel
was
for-
being filed, my lord, but the name of the father was mentioned and not the details, passport details of the father was not
Though the
mentioned.
name of the father had been mentioned, the appropriate details had not been mentioned. It is in that background that the petitioner is before this court seeking for a direction to dispose of the applications.
My lord, not to
If
dispose,
at
to
all
consider,
there
my
is,
lord.
that is what your prayer is. If at all there is any defect in the application submitted by the petitioner, it was for the respondent to pass necessary orders on the said defects and not keep the said applications pending. Hence, this court passes the following order. Writ petition is allowed. Respondent is number 2 is directed to consider the application of the petitioner, application submitted by the petitioner at annexure D and D1 and pass necessary orders within 15 days from the date of receipt of a copy of this order.
Doesn't want to include the father's name, my lord. That's in
Pass
accordance
orders.
with law.
That's what we tried to explain to him. He's not ready to listen.
My lord, at least may
Orders.
have a liberty, my lord. I'll amend the writ petition.
What amend?
We'll make a father as a party and try to send a notice.
Now we have disposed it.
No, my lord.
You cannot be doing like this, Mr. Counsel.
No, because his whereabouts are not known, my lords. He's not, even in spite of having,
We don't accept that. Your relatives, you married within the family.
yes, my lords, but the father is not even taking care of the child, my
That
lords.
is different. That is completely different.
True, my
But
lords.
if your client makes false submissions before this
No,
court,
my lords,
gives
the
you
client doesn't
false
want-
instruction, we won't accept.
He doesn't want to remove the surname as well. Let the father name continue as the surname, my lord. There's nowhere we have mentioned that the father name is not required in the,
Your client is misleading you, thereby misleading the court.
no, my lords.
We can't accept that she doesn't know her own relatives. There are so many relatives of us.
May I have a liberty to file a fresh petition, at least making the father as a party, my lords.
What is that? Counsel for the petitioner seeks for and is granted 2 weeks time to file necessary application to implead the father, husband of the petitioner. Released on 24th August. It is made clear that if proper details are not furnished, then and the father is not brought on record properly, the petition would be liable to be dismissed. Tell her not to do these kind of things with court.
Great. Serial number 22, Shiv
Lord,
number.
I am appearing for the petitioner, my lord. Now kindly see the order dated 28/7/26, my lord, where your lordship has ordered that government advocate accept notice for respondent number.
There is no interim order.
My lord,
earlier.
second line, my lord, interim order, if any granted, earlier is extended. First time matter is being listed, my lord, on that day. Now, what your
recreation club, alva?
Yes, ma'am. Page number 5, your lordship kindly see, my lord.
Interim order granted in.
My lord, just a minute. Page number 5, your lordship kindly see of IA. This order should have been, Lord, page number 5, 17/6/2026 passed by your lordship in petition number 27,128 of 2025, where your lordship has said, my lord.
Yes.
This
IA 1 of 26 has been filed for modification of para 3 of the order dated 28/7/26. Para 3 is directly to be substituted with the following. The interim order granted in WP number 27128 of 25 is extended. The benefit of the interim order granted in WP number 27128 of 25 is extended to the petitioner in the present matter. Connect with WP number 27128 of 25 and relist on
17th August.
17th August. IA 1 of 26 is allowed.
Sir, serial number 23. Mama Sagir Ahmad.
The last occasion, we did not.
You are not appearing only in this matter. How many times?
ನನ್ನ ಮಗ ಅವನು ಪಾರ್ಕಿಂಗ್ ಅಲ್ಲಿ ಗಾಡಿಯಲ್ಲ ಕೂತ್ಕೊಂಡಿದ್ದಾನೆ. ಪಾರ್ಕಿಂಗ್ ಅಲ್ಲಿ ಪಾರ್ಕ್ ಮಾಡಕ್ಕೆ ಆಗ್ತಾ ಇಲ್ಲ ಅಂತ ಫೋನ್ ಮಾಡ್ದ.
ಗಾಡಿ ಯೂಸ್ ಮಾಡಬೇಡಿ.
ಜಾಸ್ತಿ ಇದೆ ಸ್ವಾಮಿ.
24. Vishal Kumar.
For the petition, my lord.
I don't you appear.
My lord. It is already noticed, my lord. Second
You are
respondent.
not appearing in the matter, Mr. Counsel.
And also, I have served copy to the respondent, my lord.
Copy no serve ಮಾಡಿಲ್ಲ ನೀವು.
Sir, I have served, my lord. It is acknowledgement. It is 8/7/2026, my lord.
There is no service on the AGA.
No, no, this is the copy. I have served copy and also filed in counter, my lord.
Copy ಬಂದಿದ್ಯಾ? Give one more copy here only. And AGA accepts notice for respondent number 1 and 2. Counsel for the petitioner furnish 2 sets of the petition along with annexures on the learned AGA. Relist on today. The counsel for the petitioner has appeared. Hence relist on 25th August 26 in the stage that it is to be listed at. In the stage that it is to be listed in.
My lord, short date may begin.
Yes, next.
Serial number
You
20.
don't appear and your short date were.
25 Arjan. B group matters. Serial number 26. Pradeep Nayak.
My lord, I represent Pradeep Naik, my lord. Kindly
Appearing
grant
for
me 1 week
respondent
time.
number 1 and 2.
He is held up in other court, that is why. Next week or any day, any date.
Lord counsel for the petitioner seeks for a short adjournment. Relist on 17th September.
Serial number 27. Satish Ayers, party in person.
With the records of the entire survey number here, just pass that on. Also, my lord, the Tahsildar is present on video conference. And my lord, a letter has been sent to the deputy commissioner asking them to constitute a committee. We have not done it as of now. Since that day, since the order was passed.
Not been done.
It's not been done. Now, my lord, I had to explain to her what the implications of this were, and thereafter, my lord,
She doesn't understand the orders passed by the KIC.
Your Honor, sorry to interrupt. RTAs for what was done, not what will be done. You are not simply understanding.
nothing is done. That's my
Nothing is done. That is why
That's, they should have given in,
before we ask for action to be taken on subsection 2 of
it
section
is from
20.
2018 to till date of the submission we made, Your Honor. You are
Mr. Satish, it's very easy for a court to direct disciplinary inquiry.
They are
But it has
violating
an
all the
implication.
orders
That
with
is why,
impunity, Your Honor. 3 orders, including this honorable court's order, they are violating with impunity. They have no right to be heard, Your Honor.
very good. You can take your seat.
No. Sorry.
If you keep interrupting, please take your seat.
No.
Yes.
Rightly or wrongly, my lord, order has been passed by the petitioner, we have to comply with it. The records are here of the entire survey number. No land has been granted to them, my lord, it's here. But now, my lord, we are trying to get the deputy commissioner to constitute a committee and immediately see whether, my lord, any
You
documents
are
are
still
actually.
in the process or you are returned to the
We have
deputy?
written to the deputy commissioner.
When
my lord.
did you
That's the
write?
letter. That's the letter
When did you write?
of last week, my lord. Last week.
Last. After the matter was adjourned.
No, yes, sir.
It's already been adjudicated by 2 competent.
I told you last time also, again we are telling you, every time you keep on interrupting. Don't interrupt until you are spoken to, don't speak.
ಫೋನ್ ಮಾಡಪ್ಪ ಅವ್ರು. ಫೋನ್ ಮಾಡ ಹಸು. In fact, I've spoken to the deputy commissioner also, my lord.
We have no option but to initiate action under subsection 2 of section 20.
That I leave it to your lordship, my lord. Guilty for having sat on it for so long. She didn't understand the implications. She's a young officer.
That is why we have been given that opportunity
I understand,
3
my lord.
times.
Lordships have given a long rope.
Even then, if you don't do it, what do we do?
No.
And even today, no appearance.
No, she's there, my lord. I'm messaging her. She is on VC, but.
What's
no,
her name?
she's not.
Good afternoon, sir.
Yes, madam.
Sir, sorry I could not be present in person because of disaster time, sir. Here it's raining heavily.
Yes, madam, we are told you are a young officer who has just
Yes, sir.
joined service. But your joining service comes with a responsibility which you are not discharging.
Sir, if you permit, I'll explain it to you, sir.
Yes, please explain.
Sir, the petitioner, what the documents they're asking for in the first hand, sir, in the first hand, they were not granted anything, sir. If they're not granted any kind of land, there is no documents or records which is available, sir. Hence, it was not. Hence, they were not given any records previously, sir. It came to my notice only when the matter was listed previously, sir. That is when I went through all the documents, sir. He was not granted in the first place, sir.
There is an order passed by the Karnataka Information Commission. There is an order passed by the Appellate Authority which has been upheld by the KIC. Are you not aware of those orders?
I'm aware, sir, but others, sir, that they were not granted any land.
That is not a reason, madam. You have to comply with the orders passed
Option
by
of giving
authorities.
records.
You are not an appellate authority over them. That is what we find fault with you. Once there is an order passed, you are nobody to question it. You have to implement it.
Yes.
Tomorrow the High Court will pass an order and you'll say no.
Yes, sir. Okay, sir.
Yes.
I'll do it, sir.
And
Sir,
first time
and
that we asked you, Deputy Tahsildar. Second time you are not there. Third time again you are not there. And you have written a letter now to the Deputy Commissioner on 31/7. Because you have
told
just
about this,
joined,
sir. I'm sorry, sir.
why we did not take action immediately. But you
It
better
came to
learn.
my notice now, sir. Sorry, sir.
They don't get to know the orders passed by authorities.
There was ex parte there. And this was done in 2021. She's taken charge only last year.
Is there a methodology that these orders are available for the authority, any direction to the Tahsildar or any
Regular
direction to
notice
the
to
Assistant
As soon as
Commissioner?
an order is passed, I'm sure, my lord, it is intimated to every officer. There is, I'll
It
have to
was
verify
intimated,
what-
it goes in the file and sits there. Is
Beyond
there
that-
some mechanism?
Not done. We'll have, your lordships will have to take the initiative.
See,
As in other matters.
some other officer was there at that time. I did not know it went in.
Sorry to interrupt you, sir. Your Honor,
Yes.
pre-litigation notice was issued at the time of her tenure only, Your Honor.
Her tenure only.
Yes, Your Honor.
Orders passed in 2021.
First, but pre-litigation notice, that could have been answered, madam.
When did you join this post, madam?
Sir, August 2024, sir.
ಏನಪ್ಪ ಮಾಡೋದು ಇವ್ರಿಗೆ?
Sir, I was really not aware of this
Only-
case,
I
sir.
only request
Per
that
se,
we-
I'll take action, sir. I apologize. Sir.
Once you go to post it after 2 weeks, my lord, we'll see what progress we have done in terms of compliance with that order. my lord.
3622. KIC's order is 3622. The giver name so and so Tahsildar. Is finally appeared before this court through video conferencing. She submits that the documents could not be furnished to the petitioner since there is no grant made in favor of the petitioner. However, the order which had been passed by the Karnataka Information Commission is for rebuilding the file, recreate the file with known sources within the office and furnish information to the appellant. And further levied a fine of rupees 10,000 under subsection 1 of section 20 of the Act. Despite which, the file was not recreated nor the information furnished. The order passed by the KIC, the order was passed by the KIC on 3rd June 2022. And for a lab, and even after 4 years, there was no communication made to the Deputy Commissioner for recreation of the file. It is in that background that this court had directed the Tahsildar to be personally present before this court. The submission of Sri Satisha IS, the party in person, is that there is a deliberate disobedience of the orders passed by the KIC, and despite the above petition having been pending for last 2 years, no action has been taken by the Tahsildar. And AGA submits that the present Tahsildar has just joined services recently. It is for that reason that this court refrains from issuing a direction under subsection 2 of section 20 of the Right to Information Act. He submits that he has explained the process to the Tahsildar, in furtherance of which a letter has been issued to the Deputy Commissioner on 31/7/26 for the Constitutional Committee to recreate the file. His submission on instruction is that when will it be recreated?
But we'll run through the process will take us 2 to 3 months. Because we have to investigate into it, find out whether these documents are there or not.
So how long will you take?
3 months, my lord, is what.
Submit that given 3 months' time, the entire process of recreation of the file as per the applicable procedure would be carried out. Since the direction which had been issued by the KIC was for recreation of files, now that the file is proposed to be recreated, as soon as the file is recreated, copies thereof would have to be furnished to the petitioner in compliance with the order dated 3rd June 22, passed in appeal number KIC 16527 of 2021. The Principal Secretary, the Additional Chief Secretary and Principal Secretary Revenue Department.
ACS. ACS.
This is the Revenue Department.
ACS.
ACS and Principal Secretary, Revenue Department, is directed to look into the matter and institute an appropriate system where any orders passed by any judicial or quasi-judicial authority, including that like the Karnataka State Information Commission, would be available on the dashboard of each of the officers for the purpose of implementation, irrespective of transfers occurring in respect of that post. Since the submission which has been made in the present matter is that the order having passed in the year 2022, the present Tahsildar having taken charge in the year 2024, she was initially not aware of the said order for the purpose of implementation. The implementation of any order passed by a judicial or quasi-judicial authority is not dependent on the person holding the post, but is to be discharged by the said officer, irrespective of who is holding the post. Hence, the institutional mechanism would have to be established by respondent number 4, such that all orders passed with reference to a particular office is available to the officer occupying the said post, irrespective of who occupies the said post. A report to that effect to be filed, a report of compliance to be filed within 4 weeks from today. Relist on 16th September for the purpose of compliance of the above direction. A report also to be filed by that date as regards the status of rebuilding of the file, though the learned AG has indicated that it will take around 3 months' time. Madam, please find out what are all the other orders which are not implemented and
Yes, sir. I'll do it, sir.
because Mr. Shamant has told us that you have just taken charge, though that is 2 years ago, we are not taking any action. But
Yes.
if it repeats, we'll have to take action.
Yes, sir. Sorry. I apologize, sir. I'll comply with your directions.
Serial number 28. Shilpa
Thank you.
Rani, matter.
Yes, Mr. Lakshman.
Right to perform the puja.
There's a non-amendment of the cost title and you filed an application for additional documents. Any objections to the IA, Harish?
Amendment of cost title, I am told it's fine.
Madilla, non-amendment.
That we will carry out today.
Any objection to the application for additional documents?
Lordship, I am not opposing.
28.1 IA2 of 25 has been filed to produce certain additional documents. And Council for Respondent number 5 submit that he has no particular objection in respect of production of the said documents. IA2 of 25 is allowed. The additional document produced is taken on record. Ready?
Lordship, this is the document I filed before the commissioner, my Lordship. Therefore, I am relying on that document. Please, Lordship.
So, ಅವರೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಒಳ್ಳೇದು ಅಂತೀರ.
The right to
Where is
perform
Mr.
the-
Likith RP? Likith RP ಯಾರಪ್ಪ?
Likitar Prakash.
Mr. Likith is a contesting respondent.
Formal
Respondent number 6A to F.
Formal respondent.
In connected matter, I am contesting respondent.
6A to F formal contesting.
R4, my Lordship.
It's a formal respondent.
28.1.
R4 is Tahsildar.
Six A to F, then you have not carried out the amendment.
I'll do it.
Or copy ಕೊಟ್ಟಿದ್ದಾರಾ?
Copy ಕೊಟ್ಟಿದ್ದೀವಿ.
This is allowed on 2/12/25. counsel for the petitioner seeks for and is granted a week's time to carry out the amendment ordered on 2/12/25 in WP number 24820 of 20. He is also directed to furnish the full set of papers.
Amended cast title is filed, but we have to carry
out
out.
that. He is also directed
Today
to
we'll
furnish
carry out.
full set of the petition along with annexures on the council appearing for respond number 6A to F, released on released on 10th September.
There is some urgency.
In urgency.
Let the right to perform the puja of a temple is on the rotation basis.
Released on 25th August.
29th, GJ Sultapur.
Petitioner.
Yes.
For the direction to register an FIR, my lord. There is a cognizable offense, my lord.
What is the status of the complaint? Hmm.
They have been suspended and they have completed the term of the complaint.
So the representation has been acted.
My lord, only suspension order has been passed, my lord. That is also revoked, my lord. My lord, no legal action has been taken in a cognizable offense, my lord.
Now what they have done, you will have to, if you are not happy with it, you have to challenge that order.
My lord, the Honorable Office Court in Lalita Kumari case, my lord, when the cognizable offense, my lord, they have to register an FIR, my lord. They have not registered an FIR, relying on
Applicable
the.
for this, my lord. This is with against the police. There should be a sanction, my lord. If they, and also from the inquiry.
Only for the purpose of they
have passed an order. If you are not satisfied with that order or happy with that order, you'll have to challenge that. Now there's no question of mandamus. They have done something.
My lord, your lordship has passed an order, my lord. It's a cognizable offense, my lord.
Against a authority, we can't guide you on those things. Don't expect advice from us.
My lord, they have entered without warrant, my lord. They entered my house, my lord. I kindly peruse the
We can only tell you twice. We can't tell you later.
Annexure, my lord.
Petitioner is before this court seeking for the following leaves. A representation dated 12/2/24 at Annexure B had been filed by the petitioner seeking for action to be taken against certain police officers who have unauthorizedly entered the residence of the petitioner.
I may permit to.
This court on 11/3/24 had directed the learned AGA to inquire and make a submission as regard the status of the complaint submitted by the petitioner on 12/2/24. Learned AGA today submit that action has been taken against said police officers. Department inquiry having been initiated. Some of them had been suspended and they have also served the suspension period. The representation having been filed to take action against the said police officers. Department inquiry having been initiated. Learned counsel for the petitioner submit that a FIR had to be registered.
Yes, ma'am.
The said officers being police officers. Department inquiry having been initiated and suspension orders having been passed. If at all the petitioner is aggrieved by the actions taken, it would be for the petitioner to challenge the same. Reserving liberty to do so, petition stands disposed.
Serial number 30, Niti Niyam.
I appeal for the petitioner, my lords. My
Yes.
lords, 2 weeks time may kindly be granted, my lord, for verification insofar as the vaccination details concerned, my lords.
2 weeks time. The counsel for the petitioner
Yes,
seeks.
Let's start for some directions in regard to COVID vaccine and other vaccines. I have petitioned objections. All are available in the ministry's website. Whatever they are seeking, the direction to the ministry.
Just
to
information.
Disclose it. This is information. I have petitioned objection. Copy was served more than 2 weeks back. 10/7 itself. Does not serve for consideration. Seeking direction to consider their representation to disclose certain information and also direction to.
You are going to furnish this information.
Already done, man. I have petitioned objection. It's already available in the website of the ministry.
My
Yes,
lord,
but
the
even the-
contents have to be verified, my lord. A short accommodation may kindly be given, my lord.
Senior Ilvan.
That's okay.
Shri Heman Kumar, learned counsel for respond number 1, submit that all the details which had been sought for by the petitioner are already available on the website,
As per certain objections, what has been filed.
and printouts have been produced along with the statement of objections filed.
Statement of objections filed stating all these details are available.
In the website.
You have produced those details here also?
Yes, yes. That website address has been given.
That information you have produced along with your objection or only the website details?
Website indication, what it's available.
The details of the websites have been mentioned in the statement of objections filed. That counsel for the petitioner seeks for and is granted 2 weeks' time to verify and make a submission released on 10th September.
Problem. So voluminous documents act adike adannu madilla, but only with them.
31, yes, Vijay Kumar.
This on 7/1/2026, third respondent is directed to conduct the survey. Your Worship. There is order
7/1/26.
7/1/26. Your Worship. Worship, they are now filing a report. I will go through it.
And AG has filed the correct file ಮಾಡಿ where is it this week? ಇವತ್ತು matter ಇದೆ ಅಂದ್ರೆ that comes today only. Is not?
Allah, in this, the Tahsildar clearly held that it is a land. In spite of that, they are claiming that it is a own pathway.
Node ಹೇಳ್ತೀರಾ
They note ಹೇಳ್ತೀನಿ.
And AG has submitted that survey report has been received. Copy thereof has been furnished to the counsel for the petitioner, and that he would be filing the same in the registry in 2 days' time. That counsel for the petitioner seeks for and is granted 10 days' time to go through the same and make a submission. Relist on 2nd September.
Before that, 25th or
25th September, 25th August.
Please.
32, 33 adjourned, 34. Siddhappa Vidi. Ajay N.
Mr. Ajay. ಏನಿದು? On 23/6/26, the compromise petition filed had been rejected on the ground that it is not in the interest of the senior citizen. And the parties were directed to reconsider and come with a better proposal. No such proposal had been submitted on 15/7/26 when the matter was taken up. Today, there is no appearance on part of the petitioner. In that view of the matter, petition is dismissed for non-prosecution. All interim orders stand dissolved.
Connected matter.
Same.
35.
Same order.
35.
34 madam, sorry ma'am, please.
Dismiss ಮಾಡಿದ್ಮೇಲೆ ಬರ್ತಾರೆ.
32 ಅಂತ ನಾವು ಕೇಳ್ತಾ ಇದ್ದೀವಿ, ಸಾರಿ ಮೇಡಮ್.
Yes.
ಅಪಾಲೆಂಟ್ ಮಾಡಿ ಸೆಟ್ಲ್ಮೆಂಟ್ ಆಗಿದೆ ಮೇಡಮ್ ಪಿಟಿಷನರ್. ಇಲ್ಲಿ 1 week ಟೈಮ್ ಸರ್ ಕಾಂಪ್ರಮೈಸ್ ಡಿಗ್ರಿ ಆಗಿದೆ, ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಆಗ್ತೀನಿ ಪ್ಲೀಸ್ ಮೇಡಮ್. ಲಾಸ್ಟ್ ಟೈಮ್ ಎಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿತ್ತು ಸರ್.
ಲಾಸ್ಟ್ ಟೈಮ್ ಎಲ್ಲ ಆಗಿ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ವಿ.
ಅವ್ರ ಬ್ರದರ್ ಕಡೆಯಿಂದ ಒಂದು ಅಫಿಡೇವಿಟ್ ಹಾಕಿ ಅಂತ ಹೇಳಿದ್ರಿ ಸ್ವಾಮಿ, ಅದಕ್ಕೋಸ್ಕರ ಪ್ಲೀಸ್ ಮೇಡಮ್.
ನಾಳೆ ಹಾಕೊಂಡ್ರೆ ಕೊಡಿ. We won't be getting this adjournment like that.
ಸರಿ ಸರ್, ಅದೇ ಹಫ್ ಟುಮಾರೋ ಹಾಕಿ ಸರ್, ಬ್ರದರ್ ಬೇರೆ ಬರಬೇಕು.
Was rejected. Thereafter was posted and so on. No offer was. Better proposal had been filed. Today, Learned Counsel for the petition seeks for a day's time. Release tomorrow at 2:30 p.m.
Yes, interim order will extend.
Interim order is extended till tomorrow.
Yes, sorry.
35. Ananda KS.
Mr. Ananda. Once again, there is no appearance on part of the petitioner today. Petitioner, it appears that the petitioner is not interested in prosecuting the matter. Petition is dismissed for non-prosecution.
36, CO Dherale.
I appear for respondent number 2.
Yes.
That I week the 6 time to file objection. That affidavit has to come.
Affidavit has to come.
That's
From where?
From Mangalore, my lords, the society.
Mangalore is nearby only.
Lords, there are some inconveniences. My lords.
You could have gone in the weekend and come back.
Lords, may I have it next week anytime, lords.
Short date. The short point involved, my lord, the petitioner was working.
If you argue, we'll short, long, everything will be considered. Lord, counsel for respondent.
Number 2, my lords.
Number 2. Submit that the objections have been sent to Mangalore for purpose of signature. Given 10 days time, it will be filed. Relist on 2nd September. Interim order earlier granted is extended till next date.
37, CO Dherale.
And in this matter, my lord, I am the complainant. Complainant, my lord, is before the court, my lord. And your lordship's order, my lord, regarding the release of gold ornament. This order, my lord, lordships are aware, my lord. This is what happening in all matters.
I have only one submission to make.
They filed a writ petition, my lord.
My lord, my scope of writ petition was only for the interim custody, not for the main custody.
Page 21 is the order, my lord, which is under review.
Mike na mail ette podu.
My scope of writ petition is for the interim custody, not for the main custody.
You are the respondent. You have not filed anything. You have filed a writ petition.
He filed writ petition. And the order has been passed.
Your company will replace all the mics.
And my sincere apologies.
You have taken enough gold from everybody, so yes, with golden mics everywhere.
Gold has got weightage.
Then it won't move.
Well, page 21 is the order. We sought for review of the order. This is writ in the nature of review, without making me a party.
You had filed a writ petition.
We had filed a writ petition not to seize the gold.
What happened in that?
We were cooperating with the investigation.
Page 21. Without making the complainant a party, my lord, they sought to release the gold. My lord, the expert order has been passed. That is under review. It is the nature of review, my lord. Page 21 is the order. It is squarely covered by your lordship's direction order. We have produced that also. Annexure H. Page. And subsequent, there is one more order, my lord. By lordship's order. Put up, sir.
This was under CRPC. Now there is one under BNS also.
Yes.
Your BNS is different and third Tarapurna.
My lord, what has happened is,
IAFL, yes.
before we sanction any loan for more than 5 lakhs, our representative will visit the shop or visit the work area of the, person who is pledging the gold. After confirmation only, we are going to release more than 5 lakhs. That's on slab it.
Yavatidiyamma adu where complaints ella the direction ಕೊಟ್ಟಿದ್ದು. Review. List ಮಾಡ್ಸಿ ಅದನ್ನ. That is why we asked the state to give us all the details of how many complaints are filed.
Yes, sir.
As regard these theft of gold and how much theft the stolen gold has been pledged with you.
My lord, my only submission that I am representing this honorable court is that my scope is only for the interim custody, not for the main custody, because what is happening is we are not even considered as the complainant when it comes to the interim custody, when we go before the magistrate.
That is why we are asking you in all matters, place your due diligence on record.
That is what they are putting due diligence.
What is the due diligence you have done? Where is the KYC that you have done?
Everything we have got here. There is one due diligence.
Where are the details of verifying how this gold was secured?
Yes. We have got all these details. What has happened is, this is what we called as, this is a form in which every area head has to fill in. This is called as form MS 143. Right side al melade ide idralli.
Copy.
Before that,
where did he get the gold from?
we get the gold from the customer only.
how did that customer get the gold?
My lord, he is telling that it is from this, and my lord, if you look into this particular thing here, what do we call it as details of the family members ಅಂತ ಹೇಳಿ ಅದರಲ್ಲಿ ಅವತ್ತು ಫೋನ್ ಅಲ್ಲಿ ಕನ್ಫರ್ಮ್ ಮಾಡ್ಕೊಂಡು ಇದು ನಮ್ದೇ ಗೋಲ್ಡ್ ಸ್ವಾಮಿ ಮನೆ ಕಟ್ತಾ ಇದೀವಿ ಗೋಲ್ಡ್ ಕೊಡಿ ಅಂತ. Coincidentally, one of the customers is the relative itself.
It is always relative, friend, that only maid, driver.
But my lord, my question is,
They only steal from there.
My only this thing is, it is not theft. It is after 2 years. Now they're telling, if you look into the complaint also, see, to be on the fair side, my only submission is, my lord, I am ready to cooperate with the investigation.
You cooperate.
I will cooperate with the investigation and let the interim custody be with me, because what is happening is, my lord, my submission. Otherwise, I'll be put to great loss, because none of the gold will be safe for me. Any person can file a complaint and he can claim that he is the owner.
So long as you keep on taking gold like this,
No, this is
you're in trouble.
No, this is one
If you
particular
want to
form.
take gold, get their bills from where they purchased, have that with you, take the pictures of it, put that in place, and everything should be available.
For everything we have got, what do we call it as, pictures ತಗೊಂಡಿರ್ತೀವಿ, ಎಲ್ಲಿ the owners ಅಂತ ಕೇಳ್ತೀವಿ.
Though we had said earlier in a lighter vein, now we'll say seriously that you are the cause for theft of gold across the state or across the country.
My lord, we are
Because it is very easy for them to come and give it to you. You will give them whatever. They don't even. How many of them have repaid?
Madam, there are huge repayments.
Then you only auction it. Those matters also come up before us.
That is because when we auction it, it is because we are coming under RBI, and as per the RBI now,
Because they don't want to pay you back. They've taken the money as if it is sale.
non-payment is action ಆಗಿರೋದು ಯಾವ್ದು ಇಲ್ವೇ ಇಲ್ಲ ಇದರಲ್ಲಿ. My lord,
We have dealt with all of it in this matter.
my lord, I have got one submission in this. If you look into the complaint also partly carefully also, my lord. ಕಂಪ್ಲೇಂಟ್ ಹತ್ರ ಹೋಗಿ ನಾವು ಕಂಪ್ಲೇಂಟ್ ಅವ್ರ ಹತ್ರ ಹೋಗಿ ಅಂಗಡಿ ಹತ್ರ ಹೋಗಿ ಓನರ್ ಜೊತೆ ಕೂಡ ಫೋಟೋ ಕೂಡ ಇದೆ ಇದರಲ್ಲಿ.
ನೀವು ಸಕ್ಸೀಡ್ ಮಾಡ್ಕೊಳ್ಳಿ ಆಮೇಲೆ ನೋಡೋಣ.
My lord, please, my lord.
Petitioner is before this court.
My lord, my submission, please, my lord, please. Here in this case, I just only want to ask one thing. Gold has been in the custody and we have been cooperating with the investigation. Just let the interim custody be with me. I am ready to cooperate anything. Because what is happening is,
You have made your submission. We have heard you. We'll deal with it.
My lord.
Petitioner.
My lord.
Yes. It doesn't mean that you keep on arguing till we are with
My
you.
apologies.
Petitioner is before this court seeking for the following leaves. The respondent, number 4, on an earlier occasion had approached this court by filing WP number 31570 of 2024, challenging the notice which had been issued by the investigating officer under section 94 of the BNSS so and so, directing the petitioner to produce the gold, which is subject matter of the investigation by the investigating officer. The fourth respondent in that petition had contended that he would be cooperating with the investigation, and as such, the gold may be retained with him rather than the gold be seized by the investigating officer. The coordinate bench of this court had, while order dated 25th November 24, taking that into account, disposed the matter by recording the cooperation to be extended by respondent number 4. The petitioner, who is the complainant, on which basis they said investigation had been taken up in WP number 31, which is subject matter of 31570 of 24, is before this court in their present petition. The submission of Shri Aruna Shamlar and senior counsel appearing for the petitioner is that the petitioner who was the complainant was not made a party in WP 31570 of 24, and as such the said order had been obtained behind the back of the petitioner. Respondent number 4, knowing fully well that the investigation was happening on the basis of the complaint filed by the petitioner, who claims to be the owner of the gold jewelry na bullion na?
Gold jewelry.
Gold
because
jewelry.
There is the gold shop.
It was adike kelidu bullion na because they are shop. Jewelry na. gold jewelry. It was but required for respondent number 4 to have made the petitioner a party in those proceedings so that the petitioner could have been heard in the matter. There is substance in the submission made by the learned counsel for the petitioner. In that view of the matter, there would also be a requirement to issue general directions to the registry. In matters which are filed by gold finance companies, the Registrar Judicial is directed to instruct all concerned that if the complainant has not been made a party to the said writ petition, to raise an objection in relation thereto, so that it is brought to the notice of the court when the matter is taken up for consideration that the original complainant is not made a party. Insofar as the present matter is concerned, as has been observed by this court in several matters, the theft of the gold, on the theft of the gold, the owner lodges a complaint. Many a time, this gold is found in the possession of a gold finance company with whom the alleged accused has pledged the gold. This aspect has been considered in detail by this court in its order dated 4th February 26 in WP number 31057 of 2025. And this court has categorically held that in such situation, the gold finance company cannot retain possession of the said gold. The gold, if the gold is stolen gold, necessary PF memo would have to be drawn up and has to be in the custody of the court which is seized of the matter. The investigating officer, having called upon respondent number 4 to produce the gold for the purpose of investigation, it would be but required for respondent number 4 to produce the same before the investigating officer. And if the investigating officer was of the opinion that it is same gold which, as regards which there is allegation of theft made, then the same would have to be seized by the investigating officer and produced before the magistrate seized of the said matter. Neither the gold finance company nor the investigating officer can be in possession of the said stolen gold, but would have to be custodial ledges as held by this court in IIFL Finance Limited. In that view of the matter, this court passes the following order. Writ petition is allowed. The order dated 25/11/24, passed in WP number 31570 of 24, is recalled. The respondent number 4 is directed to produce the gold jewelry stroke articles, subject matter of crime number 220 of 2024 before the concerned investigating officer. If the investigating officer is of the opinion that it is the same gold article stroke jewelry as regard which the complaint of theft has been filed, to seize the said gold, draw up a PF memo and place it in the custody of the jurisdictional magistrate. The right of any of the parties for handover of the said gold will be subject to the result of the pending proceedings and subject to any application, orders on any application filed by the jurisdictional magistrate seized of crime number 220 of 2024. That was subject to one. Either not 31057 list better. You better revamp your.
My lord, the only thing is there has been a misrepresentation when it comes to the process that is followed by the company. It is a thorough company in which all the process have been duly followed.
You are not looking at the person. We are asking you about the gold. Subject matter is not the person, it is the gold.
Yes, madam.
There is no verification on the gold or the jewelry. Zero. ನಿಮ್ಮ ಫಾರ್ಮ್ ನೋಡಿ ಏನೂ ಇಲ್ಲ ಅದರಲ್ಲಿ.
ಅಲ್ಲ ಇದು ಒಂದು ಪಾಯಿಂಟ್ ಇದೆ, ಇನ್ನು ಮಿಕ್ಕಿದ ಫಾರ್ಮ್ ಇದೆ. I will submit it in detail. Just permit me
You incorporate something in that, otherwise
no, I'll
even genuine people will suffer.
I will submit some papers. Give me until time tomorrow. So some papers I can submit, because what is happening is, my lord, because
All of it you submit to the investigating officer.
Yes.
ಇಷ್ಟ ಆಗಿಲ್ಲ.
ಯಾವ್ದು ಮಾಡಿಸ್ತೀನಿ. ಯಾವ್ದು?
ಅದೇ ಮೇಡಮ್, ಅದೇ ಮೊನ್ನೆ 6ನೇ ತಾರೀಕಿದ್ದು ಬೆಳಗ್ಗೆ
ಅದೇ ಅವರು ಟೈಪ್ ಮಾಡುವಾಗ ಮತ್ತೆ 6ನೇ ತಾರೀಕು ಅಂತಾನೆ ಟೈಪ್ ಮಾಡಿ
ಹೋಗಿದೆ ಬೋರ್ಡ್ ಬ್ರಾಂಚ್, ನಾಳೆಗೆ ಹಾಕ್ಸ್ಬಿಡಿ.
ಹಾಕ್ತಾರೆ, ಹೇಳಿದೀನಿ ಆಲ್ರೆಡಿ ಮೆಸೇಜ್ ಬೆಳಗ್ಗೆನೆ. ಇಲ್ಲಿ ಚೆಕ್ ಮಾಡ್ತೀನಿ, ಆಮೇಲಿಂದ ಅಲ್ಲಿ ಮೆಸೇಜ್ ಹಾಕ್ತೀನಿ. ಮಧ್ಯಾಹ್ನ ಅಲ್ಲ, ರೀಚ್ ಎಷ್ಟಾಗುತ್ತೆ ಅಷ್ಟು ಆಗುತ್ತೆ. 39 ಇದೆ ಇದೆ 54 ಇದೆ, 53 ಇದೆ, 38 ಇವಾಗ ಆಗಿದ್ದು. 38 ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟ್ರು. 40 ಅರ್ಜೆಂಟ್. ಫಸ್ಟ್ ಒಂದ್ ನಿಮಿಷ, ಎಲ್ರಿಗೂ ಉತ್ತರ ಸಿಗುತ್ತೆ. ಒಂದು ಉತ್ತರ ಹೇಳಿದ್ರೆ ನಾನು ತುಂಬಾ ಜನಕ್ಕೆ ಉತ್ತರ ಸಿಗುತ್ತೆ ಅದಕ್ಕೆ. 40 ಅರ್ಜೆಂಟ್ ಅದು 17 ಸೆಪ್ಟೆಂಬರ್.
ஐட்டம் தான் இருக்கும். நெக்ஸ்ட் 2:30 நெக்ஸ்ட் 2:30 ஐட்டம் தான் இருக்கும்.
Ma'am?
30th ಸೆಪ್ಟೆಂಬರ್.
Ma'am?
2:30 item
ಫಸ್ಟ್ ಧಾರವಾಡ ಕಲಬುರಗಿ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಫಾಸ್ಟ್ ಓವರ್ಸ್ ಕಂಟಿನ್ಯೂ. ಅದಕ್ಕೆ ಉತ್ತರ ಎಲ್ರಿಗೂ ಸಿಗುತ್ತೆ ಅಂತ ಅದಕ್ಕೆ.
Thereafter only.
ನಾನು ಇಲ್ಲಿ ಬೆಳಗ್ಗೆ ಕೊಟ್ಟಿದ್ದು ಇಲ್ಲೇ ಇದೆ, ಅದನ್ನ ಆಗ್ಲೇ ಒಂದು ಫೋಟೋ ಹೊಡೆದು ಚೆಕ್ ಮಾಡಿ ಬರ್ದಿದ್ದೀನಿ ಏನೇನಾಗಿದೆ ಅನ್ನೋದು.
2:30 ಬರ್ಲಿ
ಹೇಳಿದೀನಿ ನಾನು. 2:30 ಪಾಠಡ್ ಆಗಿದ್ರೆ
ಅಲ್ಲ, ಅದು ಮೊದಲು ಕಂಟಿನ್ಯೂಸ್ 2:30 ಲಿಸ್ಟ್ ಅಲ್ಲೇ ಬಂದಿದೆ ಮೇಡಮ್.
ನೋಡ್ತಾರೆ, ಚೆಕ್
ಮೂರು
ಮಾಡಿ
ಇಯರಿಂಗ್ ಡೇಟ್ ಅಲ್ಲಿ 2:30 ಲಿಸ್ಟ್ ಅಲ್ಲೇ
ಫೈಲ್ ಚೆಕ್ ಮಾಡ್ತಾರೆ, ಅವಾಗ ಅವ್ರಿಗೆ ಗೊತ್ತಾಗುತ್ತೆ. ಬೆಳಗ್ಗೆ
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
ಫಸ್ಟ್ ಧಾರವಾಡ ಕಲಬುರಗಿ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಫಾಸ್ಟ್ ಓವರ್ಸ್, ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ.
And thereafter only 2:30.
2:30 ಅಂದ್ರೆ ಮೂವ್ ಮಾಡಿದ್ದ 2:30 ಮೂಡ್ ಬ್ಯಾಟರ್. ಅದು ಯಾವಾಗ ಬರುತ್ತೆ ಅವಾಗ 4 ಗಂಟೆಗೆ ಬರುತ್ತೆ.
Item 6 ma'am.
2:30 ಐಟಮ್ 6 ಮ್ಯಾಮ್.
2:30 item 6.
ಅದೇ ರೀಚ್ ಆಗುತ್ತೆ ಅದೆಲ್ಲ. ಲಿಸ್ಟ್ 2 ಅಲ್ವಾ?
ಹಾ.
ಲಿಸ್ಟ್ ಫಸ್ಟ್ ಧಾರವಾಡ ಕಲಬುರಗಿ ಲಿಸ್ಟ್ ಫಾಸ್ಟ್ ಓವರ್ಸ್, ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
ಟೋಟಲ್ 6 ಡೇಟ್
6 1 to 66 22nd ಸೆಪ್ಟೆಂಬರ್. 66 ಇಂದ ಲಾಸ್ಟ್ ವರ್ಗೂ 30th ಸೆಪ್ಟೆಂಬರ್.
ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ
ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್. ಮಧ್ಯಾಹ್ನ ಲಿಸ್ಟ್ ಆಗುತ್ತೆ, ಅರ್ಜೆಂಟ್ ಇದ್ರೆ ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೋದು. ಇದೊಂಚೂರು ಬರ್ಕೊಂಡು ಕೊಡಿ.
2:30 matter ಒಂದು ಮಧ್ಯಾಹ್ನದಲ್ಲಿ.
ಫಸ್ಟ್ ಧಾರವಾಡ ಸರ್, ಆಮೇಲೆ ಕಲಬುರಗಿ, ಆಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ 2:30
1 to 66 total 6.
1 to 66 22nd ಜುಲೈ.
ಜುಲೈ
ಅಲ್ಲ ಸೆಪ್ಟೆಂಬರ್. ಆಮೇಲೆ ಎಂಡ್ ವರ್ಗೂ 30th. ಧಾರವಾಡ ಕಲಬುರಗಿ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್. ಅದು ಗೊತ್ತಿಲ್ಲ ಎಷ್ಟು ರೀಚ್ ಆಗುತ್ತೆ ಅಷ್ಟೇ. ಫಸ್ಟ್ ಧಾರವಾಡ ಕಲಬುರಗಿ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಫಾಸ್ಟ್ ಓವರ್ಸ್ ಕಂಟಿನ್ಯೂ. ಥ್ಯಾಂಕ್ ಯು. ಅದು ನಾನು ಫೈಲು ಬೇರೆ ಕೊಟ್ಟೆ. ಇದು ಡಿವಿಷನ್ ಬೆಂಚ್ ಬರುತ್ತೆ ಅಂತ ಅವ್ರು ಅಂತಾರೆ. ನಿಜಾನ ಸುಳ್ಳ? ಹೋಗಿದೆ, ಅಲ್ಲಿ ಬುಕ್ ಇದೆ, ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಲಿಸ್ಟ್ ಎಲ್ಲೋಯ್ತು?
118 ಲಿಸ್ಟ್ ನಂಬರ್ 1
61 ಇದೆ ಸರ್. ಇದೆ
118.
ಹಾ ಸರ್, ಮಧ್ಯಾಹ್ನ ತಗೋತಾರೆ. 118 ಇದೆ. ಅದು ಗೊತ್ತಿಲ್ಲ, ಇದೆ ಅಷ್ಟೇ.
ಮಧ್ಯಾಹ್ನ ಸೆಷನ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು.
ಯಾರು ಹೇಳಿದ್ರು? ಅವ್ರನ್ನೇ ಕೇಳ್ಬಿಡಿ ಹೋಗಿ. ಹಂಗೆ ಮಾಡಿ. ಅವ್ರಿಗೆ ಪಿನ್ ನೋಡಕ್ ಬಿಡು ಅಂತ, ಇವ್ರಿಗೆ ಪಿನ್ ನೋಡಕ್ ಬಿಡು ಅಂತ ಹೇಳ್ರಿ. ನನಗೆ ಇಲ್ಲಿ ಸುತ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ, ನನಗೆ ಫುಲ್ ಸುತ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ, ನಾನು ಆ ಕಡೆ ಗಮನನೂ ಕೊಡಲ್ಲ. ಅಲ್ಲಿ ನಾನು ಆ ಕಡೆನೆ ಹೋಗ್ಲಿಲ್ಲ, ಕಡೆಗೆ ಹಂಗೆ 1:50 ಆಗೋಯ್ತು, ಹೊರಟ್ಬಿಟ್ಟೆ. ನೀವೇ ಒಂದ್ ಪಕ್ಷ ಎತ್ತ ಅಲ್ಲಿಗೆ ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ರು ಆಗೋಗ್ತಿತ್ತು. ನಾನು 1:50ಕ್ಕೆ ಹೋಗ್ತೀನಿ ದಿನ. ಫಾಸ್ಟ್ ಓವರ್ ಜೋಡಿಸ್ಕೋಬೇಕು ಇರುತ್ತಲ್ಲ, ಬೈ ಮಿಸ್ ಆಗಿರುತ್ತೆ. ಇಲ್ಲ ನಿಮ್ಗೆ ಹಂಗೆ ಬೇಕು ಅಂದ್ರೆ ಕ್ಲೀನ್ ಆಗಿರ್ಬೇಕು ಅಂದ್ರೆ ಎತ್ತಿಟ್ಕೊಂಬಿಡಿ ಅಷ್ಟೇ. ಇಲ್ಲ ಆಯ್ತು, ವಿಡ್ರಾ ಆಗೋಯ್ತದು.
Yes. Not end of the list, tomorrow list ಮಾಡಿ.
Serial
Inform the other side. 89 there or here? Here, 89. Yes. Hmm. No. That 89 released on 18th in preliminary hearing.
Dharwad bench matter. Gauri Shankar Moore.
Mr. Moat. Yarilva.
ಇಲ್ಲ sir.
None appears. Pre-list on 19th August. If none were to appear on that day, dismissal.
My lord, please, madam, I am from the petitioner, my lord.
ಯಾಕೆ ಯಾವಾಗಲೂ ಬರಲ್ಲ?
ಇಲ್ಲ, just now they have started, my lords, we see.
ಏನ್ ಫರ್ನಿಶ್ ಮಾಡಿದ್ರಪ್ಪ?
My lords, offense punishable under section 31 and 36 of Legal Metrology Act, my lords. So already the co-accused.
Who is appearing for the respondent?
Ashok Katti, my lords, AG.
Ashok
Katti.
Nobody is seen. Mr. Ashok Patil. Pass over really or
Please.
Kalburgi bench matter. SB Patil.
My lords.
Yes, Mr. Katimani.
So, my lords, the serial number 1, Dharwad bench, my lords.
Really.
The same accused number 2 and 3 is also
Accused number 1, 2, 3.
Accused number 1 and 2.
it is a compoundable offences, my lords. Similar accused number 2 and 3 are there. 3 and 5.
This is filed by 3 and 5.
Yes.
Yes, my lords.
You know, what has happened in other similar for other accused?
ಅದು allow ಆಗೈತೆ ಸ್ವಾಮಿ.
Where is the order?
Similar allowed.
Lords, is the page number 104, my lords.
104.
Yes,
Yes, my lord.
104 is some other parties.
No, my lords, it is accused number 1 and 2, my lords.
Accused number 1 and 2 is my lords.
Well, accused number 1 and 2 now, no?
Yes, my lord.
In this case, my lords, already they have compounded the offense, my lords. They have paid the fine in this.
Compounded it.
No, my lords, we have not compounded, my lords, in this case. We have came on merits, my lords. Already the present petitioner are the dealers, my lords. They are not the manufacturers, my lords.
So what do you want to do? You want to compound or you want to argue?
No, my lord, I want to argue, my lords, on merits, my lords.
You want to argue on?
Yes,
Mr. Katimani, you are ready on merits? They want to argue on merits. They don't
Yes,
want to
my
compound.
lord, the compoundable offense.
Or they don't want to compound it.
offense
They
is
want to argue on
compoundable.
merits.
Yes, my lord.
You are ready on merits?
I will seek time, my lords.
My lords, 3
When
times.
will you get ready on merits? ಯಾವಾಗ ರೆಡಿ
They have
ಆಗ್ತೀರಾ?
argued, my lord. They have argued, my lords.
They have not argued. When we'll take both your arguments together, ನೀವು ಯಾವಾಗ ರೆಡಿ ಆಗ್ತೀರಾ?
Yes.
We'll only
1
take-
week time, I correct.
Learned SCGP submits that the offences alleged are compoundable. Our learned counsel for the petitioner submits that the petitioners do not wish to compound the offences, but he would argue on merits. Released on 25th August at 2:30 p.m.
Please.
Both the counsels are directed to get ready and address the arguments. If they're going to rely on any particular judgment, to share the copy of the same with the other. With the other.
Much obliged.
Please.
Kalburgi bench matter. SB Patil.
Please.
Because we said that the medians
Now full set is ready, finally.
In fact, the first set that was given, in fact, would be a much better set. It's all chronologically arranged, but I'll go by whichever set. No, it will be simpler.
You give us whichever set, both of you argue from
Both
that
have
set.
got two. Both of us have got two sets. Excuse me. Please for past. Look for the assistance of the court. Look at page 730 of this compilation, which I've handed over today. I won't repeat the whole thing,
Write it
because
down.
everyone knows the matter. However, I've just culled out what could be the points for determination.
Page number 750.
730.
730.
Some of the original documents were a little illegible. That's why I said we'll refer to compilation one.
Yes.
So what are the points for determination one? Whether the petitioner is entitled to the revaluation of the lands, which vested in the government both under the provisions of 44 and 63 of the Karnataka Land Reforms Act. That's one. Whether the petitioner is entitled to be compensated for the lands which vested in the government for which no compensation was paid as per the showing of respondent number 1 themselves. Then whether the provisions of 47(4), 72(5) and 127A of the Act can be invoked by the respondent in the facts and circumstances of the present case. But 3 and 4, in fact, would be taken together because it's a 2 lakh ceiling limit.
Yes.
Where the provisions of 47,
Land Reforms Act.
5 and 127A of the Act 1961 provide for an absolute embargo on payment of compensation exceeding 2 lakhs, being the ceiling limit for the compensation payable. Whether the petitioner is entitled to interest payable on 1 and 2 above at the rate of 18% or such other rate as is Honorable Court deems fit by the respondent under 44 and 63, read with 67 of the Land Reforms Act. Whether the petitioner in his capacity as a lenient descendant of the original owner, Mr. Shankarrao Shivaling Rao Deshmukh, and the present owner is entitled to the amounts under 47, and whether the respondents approve the section under which the lands at measuring so and so acres are vested in number 1, especially since all the lands were not in possession of the tenants or occupants. Number by ancestor has been paid a sum of 431 dated 1936 of this compilation. It is that order. 6 is the order which gives that 4,31,000. Well, I unfortunately referred to the English ones because I'm hopefully.
The translations are acceptable, Mr. Vijay Kumar?
No, please.
There's no issue.
Substantially okay.
You can take your seat until Mr. Jitesh. Yes.
So 36 is the document under which I was paid 4,31,100. Now, if we turn back to page 731, the said payment appears to be for the lands which are vested in the government and as contained in annexure R1 to the compliance affidavit. R1 is, my lord, at page 109. And my lord, it's a list, a tabular list of all the lands that, according to them, have vested. But it's important to note here that the lands are supposed to have vested under section 48. My lord sees on the top, my lord.
109.
I'm sorry?
Page number is not tallied.
No, the number 2, the big one. This one, I'm reading from this.
Oh.
Yes, sorry.
The latest, thicker one.
Please. Thicker one.
Rather bulkier one.
Right. So, my lord, the lands that have vested, as per this chart, is under section 48. So that's what I see on the top. Unfortunately, it's in Kannada.
48A, yes. 48A.
Yes, my lord. But I'll go ahead. According to the government, therefore, the lands which had vested have been categorized in R1, showing not only the villages, the survey numbers, as well as the amounts paid. R1 specifies that the compensation has been fixed for the lands allegedly vested in number 1 and belonging to the petitioner's ancestors under section 57 of the Land Reforms Act. I'm sorry. The title to R1 also indicates that Shivaling Rao Shankarrao Deshmukh, the petitioner's grandfather, was declared as the holder stroke possessor of for cultivation of the lands owned under section 48A. The entire premise of the compensation being fixed under section 57, my lord, is an erroneous premise. May I for a moment point out section 57? Well, section 57, has my lord got that, my lord?
Yes.
Provisions applicable to minors persons under disability, etc. Now, I was neither a my grandfather was neither a minor, he was not under any disability. So like this. I'll come to it, but I'll come to this a little later.
You are none of these.
None of these. I don't come into 57 at all. I'm an individual landlord who owned the property. Apparently, a part of the property was occupied by tenants. So a particular section came into effect, my lord. But I am not a minor. I am not a person of any disability.
This refers 45. What is 45?
Yes, tenants to be registered as occupants of land on certain conditions. Now, well, I am not a tenant. I am the owner of the land.
But 57 itself is for tenant, not for the owner.
That's right.
Apart from minor
everything. Yes, my lord.
57 is where the tenant is.
Yes, my lord. Yes.
So your contention is 57 would not be applicable
at all
to you on any of the grounds.
Yes. No, if my lord now turns to, I'm going to the next Roman small 2. My lord, we go to R1, which my lord was just seeing just now, at 109. Upon perusal, therefore, of annexure R1 of the compliance affidavit, it is clear that all the lands mentioned in R1, the calculation sheet presumes that the land was occupied by tenants and the petitioner's grandfather was paid a compensation for the vesting of the lands in respondent number 1. Although para 4 of the compliance affidavit, now I'll come straight to compliance affidavit. The compliance affidavit starts at page 88. I'll read para 4, my lord, as my lord got at page 89.
Yes.
At page 89, it is respectfully submitted that rupees 1,54,100 in cash as compensation amount had become payable to the landowner on the date of vesting, and further an interest amount of 2,77,000 in the form of NSC, National Savings Certificate, under Karnataka Land Reforms Act 1961, Section 47, 72 and 73 was paid to the landowner by the Tahsildar Sindhgi. A copy of the calculation sheet is reproduced as R1, which I just pointed out. Now, my lord, we are therefore now coming to a different set of sections, 47, 72 and 73. Well, let's go to 42 for a moment.
42.
42. I mean, sorry, 47. Sorry,
47.
Yes. Has my lord got that, Miller?
Yes.
Save as provided in section 106, every landowner, landlord, and all other persons interested in the said land shall, for the extinguishment of their rights in the lands, vesting in the state government under subsection 6 of section 15 or section 20 or section 44. Now, my lord, once again, I'm repeating, 48 doesn't see any figure here. Be entitled to an amount determined with reference to the net annual income derivable from the land or all the lands as the case may be in accordance with the following scale. My lord, they give the scale, and my lord may go straight now to 47.4. 47.3, in fact, before that, where there are wells or other structures of a permanent nature on the land constructed by the landlord, the value thereof calculated in the prescribed manner shall also be payable.
This is for the bunds.
That's for the bunds. Then 4 is important because that's an omnibus clause which covers everything for the land and the bunds. Notwithstanding anything in subsections 1 and 3, the aggregate amount payable according to the said subsection shall not exceed rupees 2 lakhs. So, my lord, 47 says 2 lakhs is your maximum limit. But as I pointed out, my lord, for the bunds, I was paid
31,000.
Yes, I was paid 70 plus lakhs.
Even this one is 4,31,000.
Yes, and that also is 4,31,000. And my lord, I will show my lord another document. When I was paid 4,31,000, another landowner was paid 15 lakhs, and which is in the document itself. I was going to come to it because my lord
You
asked
go
that.
by how you have structured your argument.
Very well, very well. Now, my lord, next, page 733. The respondents have admitted, both in para 3 of the compliance affidavit, my lord, that is at page 89. I'll read that for a moment again. I've not read it though. In para 3, page 89, it is respectfully submitted that the petitioner is one of the sons of the late Shankar Rao Shivalingarao Deshmukh. The late so-and-so was the owner of various pieces and parcels of land scattered in villages of Sindagi Taluka, district Vijayapura, the lands of the petitioner's father to the extent of 3,118 acres vested with the government on the coming into force of under section force amended section 44 of the Karnataka Land Reforms Act. So I'm just pointing out, my lord, the total area admitted by the respondents, which was taken over by the government, was 3,118 acres. I'm coming to it because something later on follows. Now, my lord, in the written submissions, which is at page 723 of para 2 thereof, has my lord got that 723? It is submitted that the lands in question stood vested in the state government by operation of section 44 of the Karnataka Land Reforms Act. Such vesting is automatic, statutory, and takes effect on the appointed date without the requirement of any further act, consent, acquisition proceedings, or determination of market value. The material on record clearly establishes that approximately 3,118 acres of land stood vested in the state, and the land tribunal records conclusively demonstrate such vesting. The said proceedings have attained finality and cannot now be reopened. So, well, I'm just pointing out about the 3,118, that there's no dispute. My lord goes back to page 733. Fifth line from the top. If indeed the valuation of the bunds on lands belonging to the petitioner's grandfather was estimated at 59,85,691, the lands on which such bunds were erected could never have been valued at 4,31,000. Now, my lord, in this connection that referred to my lord's order of 1st October, my lord had said page 86. My lord had said it doesn't make sense. May I read that, my lord?
Yes.
At page 86, 87 is the relevant part. on the I'm reading para 3 of that order, my lord. On the face of the calculation made, to put it very simply, the calculation does not make any sense. The bunds which have been taken over are stated to, in all measure, 2,914.13 square meters, for which an amount of 57,75,691 has been awarded as compensation. And as regards the wells, sum of rupees 2,000 per well has been valued. Totally, for the bunds and the wells, the total amount valued was 59 lakhs. Due to delay in the payment when the matter was taken, mediation was resorted to as regards the interest amount which was mediated and settled at 75 lakhs. The said government order as aforesaid does not deal with the land, nor is any valuation report or calculation relating to the said land placed on record before the court. If the valuation for 2,914.13 acres is taken into consideration, for which 57,75,691 has been agreed to be made as compensation, the question of compensation at the rate of 4,31,100 in respect of 3,118 acres is concerned does not make sense. Learned HGCP directed to ensure necessary instructions, etc. Now, my lord, when my lord took cognizance of this fact, of this anomaly, a compliance affidavit was filed. I'll come to every document because everything helps me. Apart from that, their contention is irrespective of anything, you can't be paid more than 2 lakhs. That is the entire dirge in this entire saga. That you can't be paid.
Their contention was also that if it has been paid, interest is more than that. Some
no, Lord,
contention which
that is not, but very well. If that be the case, my lord, I will now show when the bund was paid, bund amount was calculated, the Tahsildar pointed out to the district commissioner, sorry, you can't pay anything more than 2 lakhs. The district commissioner said, no, as a special case, this has to be paid. The court in 3 orders of this court, my lord, said, no, this has to be paid to them. So, my lord, this 2 lakhs, the sacrosanct figure, is something which the government has taken up as a special case and paid me these amounts. And bunds also fell within that 2 lakh omnibus maximum limit. So you paid me 59 lakhs. In fact, you paid me 75 lakhs.
That is the interest component.
Interest was 1,50,000. I settled 59 plus another 15. So I settled for 75. The 15.
Yes.
So the 59 is not reduced. I compromise for the
Principal
interest.
amount of compensation remains the same.
It remains the same.
Yes.
I only compromised on the interest because I was getting the money immediately. That's why I compromised. There was a meeting held in the secretariat. I'll point that out also. Well, we go back to 733. It is there, 5. It is therefore clear that there is a complete error in arriving at the value of compensation 100 per so and so. Then I point out, my lord, in compliance with the directions of this court dated 1st October, the respondent has filed a compliance affidavit wherein they have annexed the calculation sheet R1. Now, the best part out of all this is, my lord, R1, they give specific area, specific village, and the amount. That amount also doesn't come to 431, which is what they are supposed to have paid me. It does not total to that. And I pointed
How
out.
much does that total to?
My lord, it comes to, what's the figure that we've counted? I'll just give my lord. We had counted that figure.
Yes.
I'll come to that, but I'll just give that figure. The statement of objections to the writ petition filed on July does not indicate the relevant provisions under which the sum of 431,100 was paid. They are entitled to a mandamus. Now, my lord, let's go to point 2. Point 2 was, my lord, whether the petitioner is entitled to be compensated for the lands which vested in the government for which no compensation was paid. The respondent number 1, pursuant to the order of this court, filed the compliance affidavit. To the compliance affidavit, now this is very important, my lord, 2 annexures were annexed. R1 is what I showed my lord. My lord, please go to then R4, which is at page 120. And I've made a list, I'll point that list also. 120. Has my lord got that?
Yes.
The valuation 122. 122 it starts, my lord. And 124 is the actual survey numbers and what is the area, etc., and what are the bunds. Now, my lord, the best part is R1 shows what lands are acquired or vested. R4 shows what are the bunds on the lands for which I am paid. This is what I'm paid. But there are lands in R4 which are not there in R1. So how did you pay me for bunds when my lands are not vested? Am I making myself clear?
Funds were continuous. It has to be used for the public purpose.
No, my lord.
Can't pay.
No. My lord, if my land has not vested in the government, there's no question of paying for the bunds. You will pay me for the bunds of land which are vested. Under 47, that is what it says.
That is the second leg.
Yes, and
there are certain additional lands for which you have to be paid.
Yes, my lord. And for that, my lord,
is what you had done the reconciliation.
That's correct. I've annexed that, my lord. Yes. So, as a consequence, you have paid me for the bunds, but you have not paid me for the lands on which the bunds are. So that I will give that this thing that when we have prepared that statement, give it to you. Note 2. The petitioner noticed that there were discrepancies in the two annexures, namely that there were lands shown on which bunds were constructed and for which bunds compensation was paid. The lands, however, did not feature in R1. Accordingly, on 25th March, this is what I was saying at page 340. My lord may turn, just to make it simpler for the court. I filed a further affidavit. And in my further affidavit, I annexed attachment 1 at page 344. Has my lord got that, my lord?
Yes.
Just take, for example, village Guttargi, survey number 89. What has been taken over or vested is 34.08. The area on which the bunds was 36.07. So 2 acres has been eaten up. We don't know how. And this is, I am going from their own records. This is not my records. They filed the compliance affidavit. R1, R4 was given by them. In this, these are the discrepancies, my lord.
Is there any issue about Karab land or?
No, nothing at all. And assuming there was, I have put this as far back as in 24. There's no reply to that this is Karab land. There's not land which could be considered. This is parched land or whatever land. Nothing at all. It's just probably a clerical error. I don't know what. But when my bunds were determined on certain land, that land has to feature in R1, which are vested, because otherwise you don't pay me for the bunds for lands which don't vest in the government. So, my lord, this is that number 2. And, my lord, I'll go ahead. At Roman 3, 734. In the said affidavit, the petitioner has also annexed Exhibit B, which is at 346, which showed the discrepancies in the areas of the gut numbers appear both in R1 and R4. So, my lord, if my lord sees, the areas which these are mentioned, my lord, the earlier thing was both the areas, both the lands were mentioned in both the R1 and R4, but there was a difference. In annexure 2 or attachment 2, mentioned in R4 were bunds for which I've been paid, not mentioned at all in R1. I've made myself clear.
You got more money. So
I'm sorry?
You got more money. How would that have a bearing on this? If you have been paid for bunds which are not part of the 3,118 acres, now your claim is only that you have not been paid for 3,118 acres.
Yes, Lord.
If you have been paid for the bunds which are outside of those 3,118 acres.
No. They have shown on this thing, I showed the affidavit. They are saying some 2,900 and odd acres. Though now in the affidavit they say it is 3,118. But I'll point out they are referring to 2,900 and odd or something acres. However, I have not been paid for 3,118 acres.
Yes.
Because that total nowhere comes in any of their documents.
That is why you are asking for the relief
That's
that you have
correct.
asked for.
And what I'm pointing out in Annexure B is these lands feature in R4 where bunds were there, not featuring in R1. Annexure 1 was featuring in both different scenarios.
But what is the sequitur for it?
But sequiturs, I should be paid for this. These lands, you paid me for the bunds. The bunds have been paid, that means you've taken the lands.
Correct. It remains the same. Whether the bunds are within or outside,
Yes.
your claim is for 3,118 acres that you have
Yes.
not been
So
paid.
they are not showing
Doesn't
that.
change that situation.
Right. Now, there is not a single document on record which shows that they have paid me for 3,118 acres.
That ground you already
That's
addressed.
right. So this is part of that 3,118 acres.
Yes.
Part of it. Well, then I've said I'm entitled to a writ of mandamus. Now we come, Milord, to the main crux of the cancer of the problem. The provisions of what it is at page 735. The provisions of 47(4), 72(5), and 127A deals with the maximum compensation. If indeed the maximum amount mentioned in each of these sections was a sacrosanct figure, then there is then no explanation to all the following. Now, my lord, in this connection, I'd like to point out several documents. My lord may go first to page 36, which I've shown, that is that 431 being paid. So it was over 2 lakhs. But go to page 282.
Let us see the 36 one thing, that is with interest or without interest.
Which one is that 36?
Yes.
177 is principal.
So 177 is less than 2 lakhs.
Yes, but there is interest. Now, my lord, if that be the case.
The interest would always be different. The compensation is less than 2 lakhs.
Yes.
The compensation is 1,54,000.
Yes. I'm not saying no.
Interest is 2,77,000.
Yes, but none of the 47(4) does not say that. It says the maximum to be paid. That apart, my lord, I will just show.
Both of you endeavored on your reconciliation. Mr. Vijay Kumar has, both of you have addressed enough arguments on this. His argument was that there is only interest. We have not agreed for 431. 154 is, we remember it, right? 154 is what we have paid, which is less than 2 lakhs. The rest is interest, though we have never agreed for anything more than 2 lakhs is a submission.
But may I only say two things, my lord? If that argument was to be taken forward, that would also apply to my bunds?
Bunds. That, of course, he has to explain.
Right. And my lord, I may show you one more. I'll just show one more document, my lord. I'm sorry. Two. 80. My lord, for a moment, may please turn to page 282.
282. Yes.
This is from the divisional commissioner to the revenue commissioner, revenue department, Bengaluru. I come in, my lord, 1,54,100. 2,77,000, my lord says that's interest, that's interest.
Yes.
Look at the second one, 8 lakhs and interest of 7 lakhs.
What is, this is the third party.
That other party. So this has been paid. Even assuming that my interest is, suppose my principal is 177 within the 2 lakh budget or within the 2 lakh limit, how have you paid others? 15 lakhs.
8 lakhs. Again, 7 lakhs is interest.
Maybe.
Yes.
But we don't know whether it is interest. He says by national saving this thing. We don't know whether it's interest. It doesn't say anywhere interest as far as this 8 and 7 is concerned.
Yes.
It's cash and national savings certificate. That's all. So, my lord, what I'm trying to say is that, my lord, in Article 14 itself, if somebody else is paid, I should be treated the same way. Now, my lord, we go back to the submissions. But, and as I was pointing out, my lord, let's go back to all the letters relating to this 2 lakh. Well, then 282 is what I pointed out just now for that 15 lakhs. My lord, may go to please 107.
107.
Yes, my lord. I'll read that, my lord. This is from the Tahsildar. Read so and so. Pursuant to the above mentioned matter, Karnataka Land Reforms Act, the former landlord Shivajilal so and so, his son Shankar Rao, their own lands had been declared and finalized the cases on behalf of tenants. In such cases, the landlord has to pay 54 times the amount of compensation already paid. The landlord has now gone through a request for a 200 times settlement in the form of spending 146 times asked for by them. Accordingly, read 1. The proposal has been submitted to the Deputy Commissioner Vijaypur. The Deputy Commissioner also sent proposal to the government. The government has approved this proposal for the payment of compensation to the owner so-and-so, deceased legal representative, his son so-and-so, by pay the amount of 154 and NSC of so-and-so, total 4,31,000. So this is that 4,31,000. The current landlord has paid 54 times and now has to make a 146 TRP of pending, enclosing herewith pending cases relating to compensation of landowners. That the reason the landowner has been ordered to pay compensation as follows. So-and-so has lost ownership. He explained in proposals to land to pay so-and-so by cash and so-and-so, total ordered to pay compensation. This compensation is accrued in current fiscal period amounting to so-and-so. So this will not explain that 431. Now, my lord may go to page 288. Well, this, I am pointing this out because this all deals with bunds. Only thing if I am pointing out is, my lord, the government in fact went one step ahead and said, no, you have to consider this. This has to be paid as a special case. The revenue secretary tells this. But this is the Tahsildar office writing to the respective district commissioner. As per the subject matter shown above, SS Deshmukh filed an application to receive compensation amount of fixation for value of bunds on so-and-so because the lands were ordered in favor of tenancy under the Land Reforms Act. As per their request is sent to Agriculture Sub-Director Sindhgi on 6 November, and after that they have directed to send it to Irrigation Department as per their letter so-and-so. Hence, it is required to fix the value of the bunds. Said district irrigation have fixed the value of the bunds under their letter, under which they have fixed under the letter so-and-so, dated so-and-so, and the value of the bunds is 59,35,000. Hence, under the Land Reforms Act, it is necessary to grant compensation, I'm sorry for the translation, to landowners who have got their lands, who have lost their lands. Hence, it is necessary to get permission for the government for grant of compensation amount. So, my lord, if, as I said, if that 2 lakhs was sacrosanct, there's no question of going to the government and asking for this sanction. Just one of the letters, 280. Then, my lord may go to 301. This is the same thing that is presented in relation to, as my lord got that, my lord?
Yes.
388, 301. This is the same thing that is presented in relation to the foregoing. According to the representation of Deshmukh, the Land Acquisition Act was settled by the Malki lands on behalf of the tenants in the cases amount of compensation by fixing the bunds value in the cases sanctioned on behalf of the tenants for rupees so and so for request for payment. Accordingly, they reviewed the application by the District Watershed Development Department, made verification of occasion is presented. Deshmukh has his ownership land finalized on behalf of cases on behalf of tenants are reviewed and verified. There are total 111 cases. The then Tahsildar so-and-so, the landlord is having 111 cases land compensation value on assessment 200 in some cases 54. So total 1,32,000 paid on national savings certificates to the party. In this regard, department is investigating the payment of cash in lieu of NSC. The department inquiry case is on the file of Divisional Commissioner Belgavi, and as per their letter, finished the file dated so-and-so. And then the landlords already paid the compensation, etc. Lord, may I just go to the next page? the first line. So to produce a proposal with the fact for the payment to the landowners, the proposal sent to you under letter so and so, as per their order dated 19th March, in the form of grants from the government for the payment of this amount as submitted for approval of 431 according to a release. Now the landlord is requesting for payment of 59. According to 47.4, the compensation limit does not exceed 2 lakh. As such, the Divisional Commissioner Belgaum, in letter dated so and so, in which stated there is no provision for release of compensation amount in second time. Once a relief is granted, there is no provision for compensation without review, appeal, sanction, order. Accordingly, the former landlord shall grant additional compensation unless the appellant applies for probation in this regard directed in the letter. So the applicants have filed writ petition number so and so. In a letter of the Advocate High Court has stated that the valid court has ordered on 14th August to consider the appeal by the letter dated 17th August. As per the direction, the petitioner has filed the petition seeking further action. Now, this is just showing an internal correspondence. Now, we'll go to page 316. This is Willard from the Tahsildar to the Deputy Commissioner Vijaypur. With reference to the above cited subject, as per the reference letter, already paid the maximum amount of 2 lakhs to the ex-owner regarding compensation for bunds dated so and so. According to the Karnataka Land Reforms Act, subsection 72(5), it is clearly mentioned that the compensation maximum should not exceed 2 lakhs. So the maximum compensation has been paid. To be compensated more, up to 59 lakhs, the former landlord has filed a petition in the Honorable High Court, Karnataka. The red petition finalized on 14th August. Brief details are as follows. Brief of section 72 is as follows. We reproduce 72. According to section 72, the law does not allow, and there is no provision in law for sanction of more than compensation of 2 lakhs. If the demand for compensation is granted at their request, there must be an amendment made section 72 by the government and sanction the grant of 59 lakhs by the government. This report has been deliberately submitted to give proper guidance on the matter and to the government. Order of the High Court submitting herewith for kind perusal. Now, Millard, we go to 149. I'm sorry, come back to 149. This is not in his compliance affidavit, my learned friends. 21st September 2010.
Yes.
Regarding the application submitted by J.S. Deshmukh for land compensation. With reference to the above subject, the application submitted by so-and-so residing at so-and-so is attached herewith. As directed, you are requested to review the matter mentioned in the letter as per the rules and submit a detailed report. This is the Deputy Secretary addressing this letter. Now we come now to 158. But I'm sorry, 158 is a little illegible there. That the first volume has a legible copy.
It is fine. 158 is okay. You can read this.
Yes, just a moment.
Numbers are a little illegible, but others are legible.
What is the page in this? Because I can't read it myself. And I will expect the correct to you. I'm sorry, is it legible on your side, Miller?
6/12/2010.
Yes, Miller.
Payment of compensation for S. Deshmukh with reference to above cited subject and reference.
Yes. I'm sorry, this is 70, the first compilation, 70. 70. Payment of land compensation to Deshmukh. With reference to the above cited subject and reference, a report on the payment of compensation cases as declared under has already been forwarded. The same is in reference in number 2. The compensation has already been paid to the landlord as below. 54,000 assessment of so-and-so by cash paid. Assessment of 200 pattu decided so-and-so 61,000. Compensation paid by way of 177. Compensation paid by NSC 148. From 1/3 interest. So my lord, interest, if my lord sees, is 146 and not 277. The total is 454,369. Now, this 454,369 is not even the figure, as I mentioned, in the first document.
431.
That's correct. This is their letter. My Lord may turn overleaf. Accordingly, rupees 454,369 has been paid compensation amount as per section 72(1) of the Land Reforms Act to the landlord. Only compensation for these lands have been paid. As per 73(4), the landlord requested payment for bunds. The district officer has fixed the bunds at so and so. 72 provides that the law maximum compensation is 2. Accordingly, according to section 72, the landlord is required to obtain a grant of 1,59,85,691. It must bring from the government. So this is a grant which the government has to give, despite the 2 lakhs. Now, as I said, my lord, though 159 I was entitled to, I agreed for 70.
What is the calculation for this 159?
My lord, that is with interest. It's at 59 plus interest was 159.
This is the bund. That's so over.
That's bund.
That
bund.
you settled for 75.
Right. So 75 because I agreed to 75. Now I'm just pointing out that the 2 lakhs was always pointed out, yet the government went on doing this.
So there's nothing sacrosanct about 2 lakhs is what you're saying.
That's right. That's right.
And there's no judgment to that effect.
Nothing at all. Now let's go to 161. Once again, the anomaly, they didn't know exactly what was paid to me. I may read that once again. I'm extremely sorry. Give me this. It's a little, with regard to the above lands of Sindhgi Taluka are subrogation sanctioned by the government to the tenants under so and so. So Deshmukh Vijaypur has appealed to the revenue minister and the government to grant compensation. So the letters appearing reference 1 and 2 are hereby submitted in full details in order to verify. In these cases, the landlord has already been paid 454. Now, once again, that anomaly, not 431, 454 according to them. Though the receipts that I have given is 431, not 454. As compensation for the land. About the payment of structure bunds, relief for the land as per 72(4), the writ petition has been filed before the Honorable High Court in this case. High Court has been ordered that verify the same is to be executed according to the rules and take legal action. According to the order, District Water Resources Department officer has submitted the report of the Tahsildar Sindhi. Same has been submitted to this office regarding the needful
relief of the
property of bunds in the applicant's land. The report has been submitted by watershed officers. Fixation of bund is 59, land to be paid by this so and so. They have submitted a report. If the funds are released by the government, the applicant can be compensated as the money is not in their possession. Herewith enclosing copy of the report and other documents. So with the Tahsildar, District Commissioner, all of them are saying if the government sanctions it, we have no problem. This 2 lakhs is not some sort of a direct embargo.
This is for the 59 lakhs.
Yes. Now, Miller, we go next to.
There's no calculation made for 3118 acres.
No. There is no dispute that it was 3118 acres, but they've not given how. But they have said that the total of R1 comes to some 2,800 acres. So the balance acres has not been paid for at all. But I'm not going on that. I'm only going on your own showing, which is obvious. In the bunds you paid me, that land is not included in the acquisition.
So
Pay me
R1
for
plus
the-
R4 comes to 3118.
That's correct. Now go to page 329.
Yes.
As per so-and-so, Deshmukh filed a petition before the High Court Karnataka seeking compensation of the bunds of their lands. High Court has ordered and directed Deputy Commissioner to execute the same. As per the said order, the Office of Irrigation Department, Bijapur, has reported the matter. Said report is received by Tahsildar and submitted the same, and compensation of bunds of rupees so-and-so is fixed. And report is submitted by the Irrigation Department. I'll cut all that. Let's go next. Economic Department Treasury opined that as per the order of the Honorable High Court, Administrative Department action can take action. The government has accepted the demand of the Deputy Commissioner and ordered as under. As per the details given above, the compensation of so-and-so is sanctioned and ordered to pay under its account number so-and-so other plans to landless owners at the profit and loss budget. So, my lord, this has been accepted. Said order is declared through government secretary. So, my lord, this is the government at its highest level saying government has accepted what the watershed department said. 57 lakhs got to be paid, and that has to be paid therefore.
Yes.
Now we come to 333. I'm sorry, I'm pointing all this out because this is correspondence which is on record. (333), my lord. Preamble. As per as per section 72(4) of the Karnataka Land Reforms Act, the government had submitted a report to the government on the recommendation of the Tahsildar Sindagi on the grant of relief to the landowner so-and-so. As per Read 2, Honorable Secretaries to the Government Revenue Department Land Reforms, in an order dated 3rd May 11, in which section 72(4) granted the relief of amount of 59 lakhs to release the amount to the landowners. Reallocation of grants to the Tahsildar is required. So, all that the Tahsildar has said is, if you okay it, send us the money. We don't have money in the Tahsildar's treasury. So, government will have to send it for us to pay them. Order. For the reasons described in the proposal, 72(4) of the Constitutional Land, the government has issued direction to release the compensation amount under this particular head of the government, non-accounting plan by the government, total amount of 59 lakhs 85,000 to the landowner, Shri J.S. Deshmukh of Vijaypur. The release grant has been distributed to Tahsildar. So as per Karnataka Land Reforms Acts and Rules, the landlord has been ordered to issue compensation relief to the landlord based on the opportunities under the rules. You are told to file a certificate of use. Now, this is, in my respectful submission, the government saying this amount has to be paid. Now we go, my lord, to page 338.
Where is this order of the Secretary Revenue Department dated 3/5/2011? Page 353. There's a read. 3/5/2011.
3/5.
That is 329.
329, yes.
That is 329.
I was looking at the
So that is not deputy commissioner, that's revenue secretary.
Yes.
This is revenue deputy commissioner acting as per revenue secretary direction.
Yes.
Yes.
Now, my lord may go to 338.
Yes.
But this is now, before that sum of 1 crore and odd was calculated, the interest issue came about. And what I come to the High Court saying, you can't just pay me and hold my money which you have held. I must be paid interest. High Court said, yes, you are entitled to interest and directed the government to decide that. My lord, may please see 338.
Yes.
As per the subject matter and reference above, as per writ petition number so and so order, and as per annexure, it is ordered to give 12%
Per annum.
and per annum legally. As per subject matter and reference shown, it is seen that in so and so order has been passed for so and so, and it is agreed to give 12% per annum legally. Hence, as per reference 2, 59 lakhs has already been paid. As per your letter and as per application of the original owner dated so and so, we have directed to give another application to the Honorable Secretary through your authorities. Already sum of 59 lakhs so and so is sanctioned to the original owner on 30th May. It is hereby requested government to give 12% interest as per the order of the Honorable High Court. The details are as under. As shown above already, the value of structures is so and so is paid. Interest of so and so of balance to be given to the original owners. It is hereby requested to recommend it to the government. As luck would have it, my lord, at that time probably my client was in need of funds and he agreed for 75. Otherwise, amount actually would have been 2 crores odd. However,
only interest would have been 2C.
Yes, yes, sir. Now, my lord may go to, coming back to 178. I'm sorry, this is gone up and down.
$178.
But this is all right because this is an opinion which was sought from the government pleader, and the government pleader said that you can't pay anything more than 2 lakhs. That's all. That is 182. No, then there are these orders of the High Court. I'll come to them. They're just 5 orders. I'll just tell the page numbers. It's not really relevant. So, I mean, they are relevant, but I don't point out just now. Now, let's go back to.
This is the final argument. So, whatever you want to show.
No, they're all there. They're all annexed. I'll just give the numbers. I need not because that is the order of the court. Yes. They have not gone in appeal. It has reached finality.
Yes.
Well, now, my lord, I put all this thing on record, which I've just read to my lord, all the pages. Well, coming to page 739, I have referred to the 5 orders which are passed by this court.
Yes.
The first order, 14th August 2006, page 41. Would my lord want me to point out those orders, my lord?
No,
my lord, the next one is page 46. My lord may make a note. The third order is page 68. Fourth order is page 239. And the fifth one is page 244. In all these, my lord, the High Court directed the government to consider the application and pass orders. In one of them, they didn't do. I came in contempt. The court directed that amounts to be paid. Now, my lord, we come to.
So the last of the orders in respect of 58 lakhs was 2019.
Yes.
In pursuance of which the payment was made.
Yes. Now, my lord, there is one. In fact, this was a eureka moment for me. My learned friend filed an affidavit saying, if my lord recollects on, I think a few 5 or 6 hearings earlier, that there were lands in which there were tenants, and the tenants have been paid.
Yes.
But my lord, the law requires, if the tenants have been paid, the owner has also to be paid. And the owner has not been paid. And my lord, those relevant, this thing which my learned friend annexed, I've prepared a note on that.
Which law requires both the tenant
Well,
and the landowner to be paid? It will be double compensation.
No, that's why a part is paid to the tenant, another part to the owner.
Which is the
Yes,
provision
sir.
for that?
You, after.
I will show my lords. Just a minute. Just for my lord's records, I'll just send the pages on which these documents which came thereafter. If my lord, they have given me those. You know, all those which were paid to the tenants, all those survey numbers. Yeah, yeah. Your document shows so. But my lord may turn to page 374. Show me the section. Owner has also got to be paid. It is in the orders. Say 55(1). Well, has my lord got 374?
Yes.
Well, these are all the lands, right, going from 1 up to 25. And then there were further documents also annexed, which shows that similar things were also paid. And all these documents run right up to page 593. Now, my lord, there is to this memo which my learned friend filed saying these tenants have all been paid. There is a determination by the Tahsildar. And that, my lord, the determination by the Tahsildar and under 48.
Ms. Jaikar, you'll have to show us two things. One, that the provision under which both tenant they have paid is what they are claiming. You're not disputing that the tenant has been.
No, the tenant has not been paid. What had happened was the tenant was recognized as a tenant.
He was recognized
Under the, there's a, this thing, but they registered as a tenant under 48.
Your contention is even if a tenant has been paid.
Not paid, registered. They have not been paid. The tenant had to then pay some this thing under the act, and he becomes a tenant. There is a regular assessment. There's an order passed. All those orders are annexed here. When that happens, and if a tenant is recognized as a tenant of the land, which means I am denuded of my land, I have to be paid an amount. I'll just show that section.
Till now, whatever you argued, we remember. This is a new argument from last time. Where we stopped in the argument.
Yes.
Was when Mr. Vijay Kumar had mentioned that the tenants have been paid.
That's correct.
So you wanted to have a reconciliation, look into all the papers.
Tenants have not been paid.
Get back. So now you have had the inspection of all the papers over the last 6 months, actually.
Yes. But may I only say one thing? The tenants have not been paid. May I just show one order whereby the tenant is recognized as a tenant?
What is your contention? The tenant has not been paid at all. So therefore,
no, tenant has taken over the land.
You have to be paid as landowner.
Tenant has been taken over the lands, accepted as tenant of that land, but I have not been paid.
That is why we are asking what your contention is. Number one, the tenant has not been paid. Therefore, the landlord has to be paid.
No. The
second contention is even if the tenant has been paid, landlord has to be paid.
No, my lord, I think I've made myself a little unclear. The tenant has not got to be paid. When a land is sought to be taken, there is a inquiry. In the inquiry, he comes up and says, I am the tenant. So there's an inquiry whether he's a tenant.
Which provision are you referring?
Yes, my lord. Yes, my lord. Would my lord kindly? But please see, my lord. Yeah, the 47 first for a moment.
Yes.
Every landowner, landlord, and all other persons interested in the land shall, for extinguishment of their rights, lands vesting in the state government under subsection 6 of 15, 20, or 44, be entitled to an amount determined with reference to the net annual income derivable from the land and all other land as the case may be in accordance with the following scale. Now there is a scale given. Now, my lord, please see what happens when there is a tenant.
And all other persons interested in the land.
That's correct. But the tenant is not interested to be paid anything. My lord, just see. 48A. Every person, has my lord got that?
48A.
A. Every person entitled to be registered as an occupant under section 45 may make an application to the tribunal in this behalf. Every such application shall, save as provided in this act, be made before the expiry of so and so. The tribunal shall publish and cause to be published a public notice in the village in which the land is situated, calling upon the landlord and all other persons having an interest in the land to appear before it on the date specified. Tribunal shall issue notice, etc. Form of application, manner of publishing, etc.
These are occupancy rights under 48A.
I'm sorry?
These are occupancy rights under 48A, Form 9.
Yes.
In this case, where the tenants registered having occupancy rights?
Yes.
They were.
Yes, and there's an inquiry carried out. And the consultant accepted the tenant. But when the tenant is accepted as that, the owner has to be paid.
Which provision is that?
Yes.
That you're referring to?
My lord, would my lord kindly go to?
The one that occupancy rights are granted, landlord loses all rights.
My lord may go to 48B.
48B.
So 48A talks of the Mamlatdar or the Tahsildar deciding that Mr. A is entitled to the land as a tenant. Then the Tahsildar shall, on receipt of the orders passed under subsection 4 or subsection 5 of section 48, and where an application is filed within so and so, on receipt of the application by the landlord, proceed to determine the amount payable under section 47 and prepare a statement showing the apportionment of the amount so determined among the persons entitled to it in accordance with the value of their respective interest in the land. Such statement shall contain the following particulars, etc. And B, namely, the particulars of the land, the names of the landowner, landlord, and intermediaries, if any, and other persons interested in the land, and the amount payable to each of them. Now, just as a matter of a case, may I just point out one document which my learned friend has relied upon, just to understand what I'm talking. Maybe I may be wrong, my lord. I hope I'm not. My lord, may go to page 378 for a moment. Yes, note the pages go 378 right up to some 500 and odd. They are just various villages. Form number 7, rule 19(1). Has my lord got that?
Yes.
Application under section 48A(1) for registering as an occupant under section that I think it will be there.
Under section 46.
46, yes.
46.
The tribunal Sindagi, Taluk Sindagi, name of applicant, this is that whoever was the cultivator or whatever. Golappa, Sidaramappa, Palanaput Chetty, a resident of so-and-so, 48 so-and-so. I am the tenant of the following land. Name of the landlord, Shankar Rao Shivaling Rao Deshmukh. So I as an owner am recognized by this.
Correct.
And then
he is claiming to be the tenant of 26 acres, 11 guntas.
That's correct. That's correct. There is an assessment. And my lord may go to page 380, a continuation of that document. Individual notice under 48A2. Whereas the lands mentioned below have vested in the state government under section 48 of the Act. And whereas the tribunal has to determine the person who is entitled to be considered as an occupant of the land. And therefore notice is given to Shri Golappa so and so of the applicant or other person who appear to the tribunal to be interested in the land appear before the tribunal with documentary evidence, if any. Taluk so and so description of the land. Now, my lord, English translation. Well, my lord, may go to page 383. I'm sorry, my lord, that's the English that I'm reading.
Yes.
An inquiry and discussion were conducted in respect of the present case. The applicant was present. For the reasons stated below, the inquiry was taken up and the case was disposed of. Applicant states that he has been cultivating the disputed land continuously as a tenant for the last 20 years. He has been cultivating this land earlier and continues to do so. He further states that apart from this land, he has 22 acres on jointly in common share with his brother. Further, witness so and so and so and so. Applicant has been cultivating the land. For these reasons, it is clearly established that the applicant has been cultivating the land. Therefore, the land has vested with the government with effect from so and so. The applicant is eligible to obtain occupancy rights. Hence, we unanimously order that the applicant is a lawful tenant and that the occupancy rights over so and so be given to him. So, as I made myself, I probably had misquoted myself. Nothing is paid to the tenant. Tenant is accepted as being the tenant tilling the land.
Yes.
So, well, my contention, therefore, is, my lord, as the owner, I am also entitled to the amount which these lands, which have now been given to the tenants, I should be under the act I'm entitled to. That's all, my lord. Well, then turning back to my submissions, I won't repeat over and over again, my lord. These pages of my would Lord want to make a note. 615 to 690 is that accepting the tenancy pursuant to an inquiry by the Tahsildar. 615 to 690.
Yes.
My lord, we go to points 7 and 8. This is what I was trying to tell, my lord. The compensation paid, number 2, compensation paid for lands which are vested under 44 is encapsulated in R1, which I showed, my lord, that statement to the compliance affidavit. The total area of the lands contained in R1 aggregates to 2,300 acres. And they say 3,118 acres was taken. So there is a gap between this. What happened to those lands? I agree, some of the lands were as included in that R4, but they were mentioned there, not shown in R1. You paid me for the funds, didn't pay me for the land. But the net substance is, my lord, 3,118 less 2,300 is the land which belongs to me, not acquired, has to be given to me or compensated for.
That land has to be given back to you as your.
Should be, my lord. Should be. Okay. Or, no, I understand, my lord, because it's quite a large amount, or I be compensated, my lord. I can't be out of pocket or I can't be denuded of my entitlement.
Yes.
And the difference, my lord.
Your premises, because R1 has only 2,300 acres mentioned, they have taken possession of 818 acres extra, is what you said in Roman para 4. So that has to be restored back to you.
Yes.
Yes.
But this, in my respectful submission, are my submissions, my lord.
What are the judgments?
If I may, I'm sorry.
What are these judgments that you are referring?
Well, those judgments deal with, they've all been dealt with the earlier judgments of this honorable court. Saying a person can't be taken away of his lands. If he has been, his lands have been taken, he has to be compensated. The value of the lands.
Mark out the paragraphs,
I'll give my
paragraphs that you want.
Yes, all of them. All of them.
Anything else?
That's it. Well, therefore, just to put it in a nutshell, my land should be revalued, number 1. Number 2, I should be paid for the difference in the area between R1 and R4. I must be given lands mentioned in R4, not in R1, because the lands are there, but they're not in R1. Then this brought compensation for what they are showing, the Tahsildar's inquiry, pursuant to that, where my lands have gone to the cultivators, as in by way of tenants and interest. I'm obliged.
Yes, Mr. Jikar. My lords, maybe taken up tomorrow, my lords, half an hour, I'll make my submissions. Because I can start today, my lords, but I may need some time. Because,
How much time do you?
At least 45 minutes, my lord, half an hour to 45 minutes. Because they've gone in detail with regard to the records. I'll have to explain it to my lords, that's it.
Tomorrow there are already 175 matters listed.
I'll beg for my lords.
175 matters are listed tomorrow.
Sorry. I beg for my lords.
Mr. Jaikar, you are staying back today or?
No, my lord. I'm going straight to Pune.
Going back. Pune. Can have it on 17 then,
please.
Heard. The Mohan Jaikar, learned counsel for the petitioner, for reply arguments, or learned additional advocate general, relist on 17.
Please.
Reply only to this. Both of you have argued enough.
Yes. I'll stick to
reconciliation is what.
I'll stick to only the submissions is made. Please.
Obliged.
Much obliged.
May I seek the indulgence of the court? Is it possible for my lord to take it in the morning?
Not at all. That is not going to be possible.
Very well, very well, very well.
Morning would be all the fresh man.
Very well, very well, very well.
Obliged.
230 matters. List number 2. Serial number 1. Pronouncement of order. Sudhindra Murthy.
I appear for second respondent in this matter.
The petition is dismissed. The improvement order dated 16/5/25 passed by the Assistant Commissioner Bangalore, North Subdivision, Bangalore, is upheld. In view of the fair submission made by learned counsel for respondent number 2, it is clarified that respondent number 2 has no objection to the petitioner. Mr. Kapil, this is for you. No objection to the petitioner and his family residing in the first floor of the property bearing BBMP number 15, PID number 494915, Pampamahatavi Road, Shankarpuram, and they're using one car parking space in the cellar. The petitioner is accordingly permitted to occupy the first floor and to use one car parking space in the cellar and is at liberty to carry out at his own cost such alteration to the first floor as may reasonably be necessary to make it self-contained without in any manner disturbing the peaceful possession and enjoyment of the respondent number 2 over the ground floor. Both the council will have to intervene and get this done. Otherwise, while construction is going to cause more trouble, how we are going to do this is something.
They have done it now.
Already we have made a kitchen in the first.
We have made a kitchen.
Because by way of the interim order which was granted, we have already made a kitchen and they're putting some sheets to cover up the area in the ground.
You will need to have a staircase outside. That space is available.
ಆಚೆ staircase ಹಾಕಕ್ಕೆ ಜಾಗ ಇಲ್ಲ.
ಇದೆಯಾ?
ಇಲ್ಲ ಆಚೆ ಹಾಕಕ್ಕಿಲ್ಲ ಒಳಗಡೆಯಿಂದ we are using one common staircase to reach the first floor as of now.
ಮತ್ತೆ it will result in.
No, it's a very big house, my lords. We can have a separate access. It will not disturb them in any way. So they put.
It is a big house, 4,000 and 4,000 square.
So they put some bars to the staircase also, so that they should not see us or something like that.
Going forward, take care of him properly. Probably
Absolutely,
he'll give it to you.
There's no dispute on that.
Yes.
I'm grateful.
Serial number 2. Vinay N. And connected matters.
I am the impleading applicant, my lord.
Impleading.
Fisheries tender matter.
Irrigation and fisheries department.
And the successful impleading applicant.
Where are you? This side, that side?
He has to come here.
You can't be standing in the center, definitely. So who are impleading applicants?
The impleading applicants are the successive bidder, my lord.
2.3, Mr. Ganapati Naik.
2.4 and in this case.
2.3. You have no objection to these applications?
2.3.
They are the successful bidders.
Not at finalized, they are not deposited the amount.
No, already deposited.
My lord, they've deposited.
They've deposited or not, you can't have any objection.
Some of the applicants are
IA
deposited.
2, 3 and 4 or 26, 2.3 have been filed by successful bidders.
7 and 8.
EN 7 and 8 ಅಮ್ಮ.
ಹೌದು.
EN 7 and 8.
ಹೌದು. ಅಲ್ಲ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ I have filed.
What is 7 and 8 that you are speaking of?
I think this is a respondents number.
Respond number
Impleading applicant number 7 and 8.
have been filed
Proposed respondent number 7 and 8.
by successful bidders to come on record as party respondents, considering that they have been held to be successful bidders. IA 2, 3 and 4 of 26 are allowed. The persons named therein are brought on respond IA 2 of 20 Vijay Kumar.
Please.
ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ ಅದರಲ್ಲಿ?
Only one sole
brought on record as respond number. The applicant in IA 2 of 26 is brought on record as respond number 4.
Please. Respondent number
4. 5. The Sinchana.
Only one.
The impleading applicant in IA 3 of 26 is brought on record as respond number 6. Varalakshmi Nagraj.
I am for.
ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ?
ಇಬ್ರು 7 and 8.
Respond. Applicant in IA 4 of 26 is brought on record as brought on record as respond number 7 and 8. Learned AGA accepts notice for respond number 2. Director of Fisheries.
Please.
And Director Lake Protection and Development Corporation Limited.
We are appearing for the.
You are appearing.
Please.
For respond number 2 and 3 also. 2.4. Sinchana, how many people? 1. IA 2 of same successful bidders. Brought on record as respond number? 5. IA 3 of 26. Brought on respond. Only one, Nala Vijay Kumar?
Please, madam. Only
6.
one. Inflating.
2.5.
ಅದರಲ್ಲೂ ಕೂಡ ಒಬ್ಬರೇ.
1. ಇದರಲ್ಲಿ respond number 5.
5.
IA 2 of 26 is allowed. Yes. Ready?
Ready, miss.
Please.
Mithun, ready?
Please allow. We have shared the synopsis.
Who is going to start?
I'll start. I should take note the second matter. This
7194. 719. Yes, Manmohan.
Please. But the also turn to page 75. This is the fishing lease policy.
75. Just
75.
speak in the mic, please.
Sorry.
Some people on the VC
Please.
also.
Have the English version. Please, cool.
Yes.
But this is the fishing lease policy of 2014. But if lots permit, but I'll pass on an English version. May just pass on not an English version.
Good.
The government nore kotiradu, so for a copy koduttalre.
Inland Fisheries Policy.
Please. Not this policy provides the manner in which the fishing rights has to be given. But can I read the preamble?
Fishery right and government-owned water resources like reservoirs, tanks, rivers, creek, estuaries, and other water bodies. Yes.
But if lots would permit, I'll just quickly glance through the preamble, because preamble basically says we have so many lakes and tanks. We have to encourage various kinds of fishermen and societies and all that. That is what it provides. So I'll not trouble reading all this. But the types of disposal becomes relevant. My lords would turn to page 3.
Page 3.
Page 3, my lord.
Yes.
Para 4.
This is a translation or the actual policy?
In fact, this is what the government had relied upon in the earlier round litigation. So
we have not filed in this litigation.
Not in this litigation.
Why we are asking that is, if it is the actual policy, we don't need to bother about verification. If the translation, it is like the other matter also, there was a lot of issue about translation.
I don't think it is translation, because this is what the government had placed on record in the other matter.
Para 4 types of disposal.
Oh, types of disposal.
Worded like that.
If there's any problem, I'll rewrite to Kannada. I don't have no difficulty.
This is a translation of the actual policy.
That's the, I think it is an actual copy because the court had asked for it, not because the
Translation copy Soumya.
translated.
Actually, annexure yearly Kannada ಆಯ್ತು.
It's a translated version.
Then go to the
Right,
Kannada.
right, very well.
ಕನ್ನಡ annexure.
But can I request now, please turn to page 77. Just before not the order, just before the order, not the last paragraph. I mean, I think second paragraph from the top.
ಆದುದರಿಂದ
ಹೌದು, ಆದುದರಿಂದ ರಾಜ್ಯದ ಸರ್ಕಾರಿ ಸೌಮ್ಯದ ಎಲ್ಲ ಒಳನಾಡು ಜಲಸಂಪನ್ಮೂಲಗಳಲ್ಲಿ ಮೀನು ಉತ್ಪಾದವನ್ನು ಗರಿಷ್ಠ ಪ್ರಮಾಣಕ್ಕಿರುವ ಮೀನು ಕೃಷಿಯನ್ನು ಜೀವನಾವಧಿಯಾಗಿ ಅವಲಂಬಿಸಿರುವ ಒಳನಾಡು ಮೀನುಗಾರಿಕೆ ಸ್ವಯಂ ಉದ್ಯೋಗವನ್ನು ಕಲ್ಪಿಸಿಕೊಡುವ ಮುಖಾಂತರ ಅವರ ಸಾಮಾಜಿಕ ಮತ್ತು ಆರ್ಥಿಕ ಸಬಲೀಕರಣಕ್ಕೆ ಮತ್ತು ಒತ್ತು ನೀಡುವ ಹಾಗೂ ಚಾಲ್ತಿಯಲ್ಲಿರುವ ಗುತ್ತಿಗೆ ನಿಯಮಾನುಸಾರಗಳಲ್ಲಿ ನ್ಯೂನತೆಗಳನ್ನು ಸರಿಪಡಿಸಿ ಮತ್ತು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ತೀರ್ಮಾನ ಅಂಶಗಳನ್ನು ಅಳವಡಿಸಿಕೊಂಡು ಸಮಗ್ರವಾದ ಒಳನಾಡು ಜನಸಂಪನ್ಮೂಲ ಮೀನು ಪಶುವಾರ ಹಕ್ಕಿನ ವಿಲೇವಾರಿ ನಿಯಮವನ್ನು ರೂಪಿಸಿ ನಿರ್ಧರಿಸಿ ಈ ಕೆಳಗಿನಂತೆ ಆದೇಶಿಸಿರುತ್ತದೆ. Then let's please turn to page 79.
ಖಂಡಿಕೆ 4.
ಹೌದು, ಖಂಡಿಕೆ 4 ವಿಲೇವಾರಿ ವಿಧಾನಗಳು. I'll not spend much time with this note. I will only point out what it is because I don't think I need to emphasize on this. They say the first priority should be given to a society within whose jurisdiction not the lakes are situated. After which not it can be given to others. There is also not an option of giving it by way of tender, which is at page 80. If there is no one not available, then it can be given. That is Guttige Korada Jalasampurmuna Vinu Pashwar Hakkanu, not through tender. That is what not the policy of 2014 provided. Now, lords, there was a change in 2018, which is at page 127. This policy was sought to be amended at page 127. Not the only distinction that 2018, no, that is 9/3/2018.
Page 75 is 2014.
14.
Now you want us to see page?
This is page 127.
127. Yes.
The type copy is 120. Now this only says that ಏತ ನೀರಾವರಿ ಯೋಜನೆಯಡಿ ಬರುವ ಎಲ್ಲಾ ಕೆರೆಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮೀನುಗಾರಿಕೆ ಹಕ್ಕುಗಳನ್ನು ಫಿಶಿಂಗ್ ರೈಟ್ಸ್ ಹರಾಜು ಮುಖಾಂತರವೇ ನೀಡಬೇಕೆಂದು ಹಾಗೂ ಈ ಹರಾಜಿನಿಂದ ಬಂದ ಹಣವನ್ನು ವಿದ್ಯುತ್ ಬಿಲ್ ಪಾವತಿಗಾಗಿ ಉಪಯೋಗಿಸುವುದು. This amendment
ಏತ ನೀರಾವರಿ is lift irrigation.
Lift irrigation. No, this is an amendment to clause 4, which my lord saw in the 2014 notification. So they made a distinction. There it was first priority only to societies. Then they said in 2018 we have to pay money to lift irrigation. Therefore, wherever there's lift irrigation tanks, we will only do it through auction. Now, the priority issue, according to me, was not raised in this. Then, Lord, this was challenged before this honorable court in a writ petition.
So this is not a policy, this is an amendment.
This is an amendment to the policy. Tiddupadi.
On 9/3/2018.
9/3/2018.
Lift irrigation. Offset the expenses relating to pumping the water.
Pumping of water.
Yes.
But this was challenged not in a writ petition. At page 128 is the order. Annexure F. But this was challenged by some other petitioners, but the challenge failed. The court said not that you don't have a vested right, and the government policy can be amended. Not I will only show not only one paragraph at page 137. Not say only note the number of lakes. Not I'm only pointing out at page 137, para 13. But please note not the fourth line. There are in all 362 tanks in the state filled by lift irrigation. Let's only note this number. I'm only trying to point out that this number is just being hiked from day by day.
So once the policy is done, if water is not available, it has to be lifted.
What is being done is what they did was 362 was what is mentioned. After which the number again jumps to 800. There is a complete change in the numbers. Way it is being done is rain-fed tanks are slowly being taken away from these societies and given to outsiders. Now the entire concept.
Last time you were mentioning this, we asked you a simple question subject to them. Now, if water is not pumped, if your
I got
contention
one,
were to be
that's the same.
accepted and they stop pumping the water, it will dry up.
True.
So then you should not insist on water being there.
But if water is actually pumped is a different issue. But many instances, of course, I will not get into nitty-gritties, but they just affix a pipe, they say water is pumped. If they pump water once, it will not become lift irrigation. But it cannot be like today, I pumped, let us say 100 gallons of water. That means it becomes lift irrigation. It cannot be that so.
And that way, we'll ask Mr. Mithun to give us the details of how much has been pumped, because the policy requires only the cost of electricity to be offset.
Yes. But I'll also point out
They'll have
that
to have the meter records for the cost of pumping.
that also I'll point out what the expense according to the government that they incur for this is about 300 crores. But lot of these fishermen are dependent on this. Of course, I cannot go too much into this because we have lost this case. In the other matter, it was lost pending writ appeal. But it's a heartburn. The government should take into consideration the livelihood of these fishermen.
Yes, correct. But if they don't spend money on that pumping, then there won't be any livelihood. There won't be any water for livelihood.
That is what happening. If it is, let's say it's lift irrigation, then it's out of the hands of many of these fishermen. They'll not be able to afford. I'll point out the price also.
Yes.
Then please turn to page 141. Para 24 of that order. I'm only requesting number to be noted.
Thanks. At 141.
141, para 24. Page numbers.
Yes.
Specific contention of the state is out of 3,895 tanks and 82 reservoirs, 362 of them are being fed with water by lift irrigation. This entails cost in the form of power charges. On this ground, the state have sought to justify the amendment of 2018. But ultimately, the writ is dismissed. Then a writ appeal is filed. It is pending. I will not trouble my lords with that also.
Any stay order passed?
So there is no interim order, but the appeal is admitted. But I am not a party there. Be that as it may not. Then please turn to annexure H, page 146. It starts. Can I request lords turn to page 151? But this is the meeting where the Honorable Chief Minister had held. That is pointed out page 146. This says Melkand Visheke Sambit Sande.
Lake Development Authority, Conservation and Development Authority.
There, in the presence of the Honorable Chief Minister, the meeting is held at page 151, bottom, serial number 7. Para 7 at page 151.
Yes.
ಕೆರೆಗಳನ್ನು ಮೀನುಗಾರಿಕೆ ಚಟುವಟಿಕೆಗಳಿಂದ ಗಳಿಸಬೇಕಾಗಬಹುದಾದ ಆದಾಯ ಕುರಿತು ಮೀನುಗಾರರ ಸಂಘಕ್ಕೆ ಮೀನು ಪಶುವಾರ ಹಕ್ಕು ನೀಡುತ್ತಿರುವ 4044 ಕೆರೆಗಳನ್ನು ಹೊರತುಪಡಿಸಿ ಉಳಿದ ಎಲ್ಲಾ ಕೆರೆಗಳಿಗೆ ಈ ಟೆಂಡರ್ ಮೂಲಕ ವಿಲೇವಾರಿ ಮಾಡಲು ಸಭೆಯಲ್ಲಿ ತೀರ್ಮಾನಿಸಲಾಯಿತು. ಏತ ನೀರಾವರಿ ಕೆರೆಗಳಿಗೆ ಈ ಟೆಂಡರ್ ಮೂಲಕ ಗಳಿಸುವ ಆದಾಯದಲ್ಲಿ 50% ಉಸ್ತುವಾರಿ ಇಲಾಖೆ ಸೋವಂಸೋ ಕ್ರಮಗಳಾಗುವುದು. Here, the decision was, insofar as where the societies are there, you have to exclude it from e-tender. Rest of it, you can go ahead. Now, this is again followed by a tippani which is at page 163.
ಏತ ನೀರಾವರಿ ಕೆರೆಗಳ ಈ ಟೆಂಡರ್ ಮೂಲಕ ಗಳಿಸುವ ಆದಾಯದಲ್ಲಿ 50% ಉಸ್ತುವಾರಿ ಇಲಾಖೆ KTCDಗೆ ನೀಡಲು ಅಷ್ಟೇ.
That may not be much of relevance.
Exclusion of the society.
So the first portion says ಮೀನುಗಾರರ ಸಹಕಾರ ಸಂಘಕ್ಕೆ ಮೀನು ಪಶುವರ ಹಕ್ಕು ನೀಡುತ್ತಿರುವ 4044 ಕೆರೆಗಳನ್ನು ಹೊರತುಪಡಿಸಿ ಉಳಿದ ಎಲ್ಲಾ ಕೆರೆಗಳಿಗೆ ಈ ಟೆಂಡರ್ ಮೂಲಕ ವಿಲೇವಾರಿ ಮಾಡಲು ಸಭೆಯಲ್ಲಿ ತೀರ್ಮಾನಿಸಲಾಯಿತು.
But this 4044 is different from 3895 mentioned.
Yes, it is. It is different.
So 4044 has to be for the society according to you.
No, that's what the government has said. Government says exclude them and proceed with tender. Insofar as not only the lift irrigation. Now, let's then please turn to Tippani, which is at page 163.
68.
Let's turn to page 164, the second paragraph.
Yes.
ಕೆರೆಗಳಲ್ಲಿ ಮೀನುಗಾರಿಕೆ ಚಟುವಟಿಕೆ ಕುರಿತು ಚರ್ಚಿಸಲಾಗಿ ಮೀನುಗಾರ ಸಂಘಗಳಿಗೆ ಮೀನು ಪಶುವರ ಹಕ್ಕು ನೀಡುತ್ತಿರುವ ಕೆರೆಗಳನ್ನು ಹೊರತುಪಡಿಸಿ ಉಳಿದ ಎಲ್ಲಾ ಕೆರೆಗಳಿಗೆ ಈ ಟೆಂಡರ್ ಮೂಲಕ ವಿಲೇವಾರಿ ಮಾಡಲು ಸೂಚಿಸಿರುತ್ತಾರೆ. This is the letter of the Chief Secretary.
Yes.
Not after this, there was an order at page 165. But this is dated 2/6/2025. But I've prepared a list of dates and events.
Tippani is prior to the meeting of 8/5. Annexure J is prior to Annexure H.
How?
Yes. After this, the meeting took place.
CM on Chief Minister meeting is 22/4. Tippani is 5/5/25.
Meeting is when? 22/4.
22/4.
This is the covering letter.
Covering letter is 8/5.
Meeting is 22/4. Yes.
But page 165, I will not read this. This already been quashed by the Honorable Court. But wherein various these lakes were referred to at page 165, the last paragraph. Number of lakes that is not sought to be notified for e-tender, and fixation of price which is at page 166. They increased the rate from 300 to 1,500 rupees.
So 569 lakes.
Please. 569 lakes ಕೆರೆಗಳಿದ್ದು ಹಿಂದಿನ ಸಾಲುಗಳಲ್ಲಿ 219 ಕೆರೆಗಳನ್ನು ವಿಲೇವಾರಿ ಮಾಡಲಾಗಿದ್ದು ಪ್ರಸ್ತುತ ವಿಲೇವಾರಿಗೆ 350 ಕೆರೆಗಳು ಲಭ್ಯವಿರುತ್ತದೆ. In this context, they mention it. Then, at page 166, the price is mentioned. Base price per hectare.
300 rupees.
300. It's increased from 300 to 1,500. But there is no basis or calculation for this as to how this increase has been arrived at. On this basis, tenders were notified. And there's at page 168, during the pendency of the writ petition, the earlier round of litigation, the Honorable Court asked them, see, the Chief Minister has said that you should exclude the lakes insofar as societies are concerned. And in this circular which I just pointed out, they've included not even those lakes or tanks. There is no clarity on what you're saying. So issue a proper circular pointing out what is that you're trying to say. But in that context, page 168, on 9/7/25, a circular is issued. We'll also turn to page 170.
Yes.
The third paragraph. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಒಳನಾಡು ಮೀನುಗಾರಿಕೆ ಕಾರ್ಯನೀತಿ 2014ರ ಕಾರ್ಯನೀತಿಯನ್ನು ಕಾಲಕಾಲಕ್ಕೆ ತಂದಿರುವ ತಿದ್ದುಪಡಿ ಮಾರ್ಪಡಿಗಳ ಹೆಸರ ರಾಜ್ಯದ ಮೀನುಗಾರ ಇಲಾಖೆ ವ್ಯಾಪ್ತಿಗೆ ಬರುವ 40 ಹೆಕ್ಟೇರ್ ಹೆಚ್ಚು ಅಚ್ಚುಕಟ್ಟು ಹೊಂದಿರುವ ಜಲಸಂಪನ್ಮೂಲಗಳ ಏತ ನೀರಾವರಿ ಕೆರೆಗಳನ್ನು ಹೊರತುಪಡಿಸಿ ಮೀನು ಪಶುವಾರ ಹಕ್ಕಿನ ವಿಲೇವಾರಿ ಸಂಬಂಧಿಸಿದಂತೆ ಈ ಕೆಳಗಿನ ಕಾರ್ಯಾನುಷ್ಠಾನ ಕ್ರಮಗಳನ್ನು ನಿಗದಿಪಡಿಸಿ ಸ್ಪಷ್ಟೀಕರಣ ನೀಡಲಾಗಿದೆ. ಫಸ್ಟ್ ಒನ್, ರಾಜ್ಯದ ಮೀನುಗಾರಿಕೆ ಇಲಾಖೆ ವ್ಯಾಪ್ತಿಗೆ ಬರುವ 40 ಹೆಕ್ಟೇರ್ ಹೆಚ್ಚು ಅಚ್ಚುಕಟ್ಟು ಹೊಂದಿರುವ ಜಲಸಂಪನ್ಮೂಲ ಏತ ನೀರಾವರಿ ಕೆರೆಗಳನ್ನು ಹೊರತುಪಡಿಸಿ ಮೀನು ಪಶುವಾರ ಹಕ್ಕನ್ನು ಮೊದಲ ಆದ್ಯತೆಯಲ್ಲಿ ಮೀನುಗಾರರ ಸಹಕಾರ ಸಂಘಗಳಿಗೆ ತದನಂತರ ರೈತ ಮೀನು ಉತ್ಪಾದನಾ ಸಂಸ್ಥೆಗಳಿಗೆ ನಿಯಮಾನುಸಾರ ಗುತ್ತಿಗೆ ನೀಡಿ ಗುತ್ತಿಗೆಗೆ ಕೋರದ ಉಳಿದ ಕೆರೆಗಳನ್ನು ಈ ಟೆಂಡರ್ ಮೂಲಕ ವಿಲೇವಾರಿ ಮಾಡುವುದು ಹಾಗೂ ಈ ಟೆಂಡರ್ನಲ್ಲಿ ವಿಲೆಯಾಗದ ಕೆರೆಗಳನ್ನು ಪರವಾನಗಿ ನೀಡುವ ಮೂಲಕ ಮೀನು ಹಿಡಿಯುವ ಅವಕಾಶ ನೀಡುವುದು. This is the clarification that gave. But then not with regard to rate, not they said in so far as not the price, they said 50% ಅಥವಾ 1500 rupees ನಿಗದಿಪಡಿಸಲಾಗಿದೆ. Then not please see not the statement of objections that was filed by the state at page 170.
This would apply to lakes which are more than 40 hectares. So less than 40 hectares, it won't apply.
It won't apply.
40 hectares is roughly around 100 acres plus.
Yes.
Yes.
But then please turn to the statement of objections not that is filed by the state in that writ petition. Not it starts at 171. I only request not the court turn to page 179.
This circular was challenged in this writ petition.
Yes, it was challenged there. Not the circular, not circular was issued during pendency, not the previous order which my lord saw, that is 26/2025.
Annexure K.
Yes, Annexure K was challenged and not certain auction notifications. Correct.
Yes.
But page 179, not the last two sentences at para 11, but they only say that in this regard it is required to noted that the petitioner's rights are not affected in any manner, that they are eligible to part in the tender process. Also, and the said tenders only with respect to lift irrigation, as the same consumes high energy electricity due to pumping, lifting of water. So they said it is only applicable for lift irrigation. Then not para 12, not last sentence in para 12 of that same page. Fishermen belonging to scheduled caste and scheduled tribe are accorded priority in the e-tendering of fishery rights for all tanks, including lift irrigation tanks, through a system of reservation.
That is under KTTP.
Under KTTP. Now, Lord, let's may only note this because Lord, now what is being done is, despite this, there was an order, Lord, I will take notes of that as well. The impugned Lord order, what they did is they have included even Lord rain-fed tanks in this.
As regards this reservation under KTTP for MSME, SC/ST, that's a statutory reservation.
But Lord, when it comes to the lift irrigation tanks, Lord, whether that priority is provided, Lord, they have to clarify.
Whether it's implemented,
yes,
according to it's not being implemented.
Not because some of the members, petitioners here are lift irrigation, Lord, I mean, they are SC/STs, associations or societies.
Association will not be. Individuals is what is considered there.
No, Lord, there are
MSME and persons belonging to.
No, Lord, what happens is fishing rights not will usually be given to societies. Societies, Lord, will consist of
KTTP Act only.
Not only KTTP Act, not when refers to their own state.
Mentioned here in para 12 is KTTP Act. E-tendering in strict conformity with the KTTP Act is enacted to enroll transfer so and so. That is what they've said. It's a qualified statement.
The first portion doesn't say, second portion.
Second portion.
As instituted e-tendering.
That is why we are asking you. In terms of KTTP Act is what they've said.
They have, and of course, that is the next sentence, but according to me, that's not what they're trying to say. Let them clarify, Lord, because according to me, the first portion is distinct of the second one. They're saying we are proceeding as per KTTP.
They can't have a separate thing apart from KTTP. The entire para has to be read together.
Very well, very well.
Is there any person belonging to scheduled caste, scheduled tribes who is discriminated? Is there anything that you want to place on record, or you are speaking of the society?
Their societies, because individually, there cannot be any fishermen who can go ahead and carry on
It is
fishing.
of no use, is what you are saying.
Very well. Because the society will, there are in fact petition number 2 is Parishishta Jati Chalavadi Meenugara Sahakara Sangha.
KTP Act
Consists of only scheduled caste. Because not government itself,
but the act, does it recognize society or
I think
individuals?
The policy taken.
Among tenderers belonging to scheduled caste category and such number of works, we tendered only among tenderers belonging to so and so.
But anyway, I don't think I'll.
Persons belonging to scheduled caste. That's what we thought.
Please.
Persons belonging to scheduled caste or scheduled tribes. Yes.
Please. But then can I request now turn to page 188, which is the order of the Sawmill Court. That is where it starts. I will request to turn to page 235.
Yes.
The number of lakes, etc., is mentioned there in para 11.8 and 11.9. I'll not trouble reading all this. But at page 240, the court holds against me, saying that there is no arbitrariness at page 240.
11.8, what do you want to refer?
But I know I just pointed out to show the court refers to number of lakes, etc. Just note it. I don't want to read through it. The court says the various numbers of lakes.
The lift irrigation.
Is because there's confusion, because at one juncture they say a different number, in order they say a different number, before court they said a different number.
Now it becomes 41,875 tanks.
Yes, that is what because if I'll just read para 11.8, but first portion the court notes 362 tanks is what is mentioned in the earlier round.
Do you want clarity on how many tanks?
How many tanks are there? How many subject matter of lift irrigation? How many are subject matter of rain-fed tanks?
Yes.
Because they suddenly jumped from the order which was impugned there. The number they had mentioned was 569. But when it mattered come up for preliminary hearing, it was just about a month or two. The number had jumped to 800. So there was no clarity. That's why the court.
Even the number of tanks has jumped from 4,000 to 41,000.
Yes. That is the total number they take into consideration. They say some of the tanks are with the panchayat, some are with the municipality, etc. That is what they try to point out. Now, at page 240, this portion is against me. At page 240, this court, in the circumstances discussed, is the considered opinion that there is no arbitration in the state government revising its fishing policy of 2014, and petitioners cannot succeed in the present petition on the ground that they have inviolable right to be granted fishing rights in the tanks of the state under the policy of 2014, or that there is arbitrary state government revising this policy to issue e-tenders for those tanks that have lift irrigation facilities.
Yes.
But this portion has attained finality. But then at page 243, but however, the court quashes the order that was impugned there and the tender notification. At page 243, para 12.2. After this contradicting government order dated 2/6/2025 and circular dated 4/6/2025, the concerned assistant director, the district director of fisheries, have issued the impugned notifications calling for tender for grant of fishing rights. These notifications are issued for tanks with different spread and different command areas without indicating whether there is any application by the Fishermen's Cooperative Society, and irrespective of the parameters mentioned in this government order bar circular. This court of the considered view that the government order dated 2/6/25 and the circular dated 4/6/25 are in themselves not not only contradictory, but also opposed to the last revision in the fishing policy of 2014, and the impugned tender notifications arbitrary cannot be sustained. The writ petition number so and so allowed, part quashing, the government order dated so and so, and the circular dated so and so issued by Director of Fisheries, and a tender notification, these petitions, but without prejudice to the state government to issue orders for inviting tenders for grant of fishing rights in tanks that have lift irrigation facilities. Now, my lord, this was the order, after which, my lord, the impugned circular is issued, which is at page 245.
Yes.
Now, my lord, they say this order is passed, and this basis, my lord, the impugned notification is issued. Now, my lord, at page 245, now please see the first paragraph. ಕರ್ನಾಟಕ ರಾಜ್ಯ ಸಣ್ಣ ನೀರಾವರಿ ಮತ್ತು ಅಂತರ್ಜಲ ಅಭಿವೃದ್ಧಿ ಇಲಾಖೆಯ ಆಡಳಿತ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಒಟ್ಟು 3764 ಕೆರೆಗಳು ಹಾಗೂ ಇತರ ಜಲ ಸಂಪನ್ಮೂಲಗಳಿಂದ ಪ್ರಸ್ತುತ ಒಟ್ಟು ಸುಮಾರು 1.50 ಲಕ್ಷ ಹೆಕ್ಟೇರ್ ಜಲ ಸಂಪನ್ಮೂಲಗಳು ಪ್ರದೇಶಗಳಿರುತ್ತದೆ. ರಾಜ್ಯದಲ್ಲಿರುವ ಬಹುಪಾಲು ಕೆರೆಗಳು ನೀರಿಗಾಗಿ ಮಳೆಯನ್ನೇ ಅವಲಂಬಿಸಿದ್ದು, ಕೃಷಿ ಮತ್ತು ಅಂತರ್ಜಲ ಅಭಿವೃದ್ಧಿಗಾಗಿ ಕೆರೆಗಳನ್ನು ವರ್ಷವಿಡೀ ನೀರು ತುಂಬಿಸುವ ಏತ ನೀರಾವರಿ ಯೋಜನೆ ರೂಪಿಸಲಾಗಿರುತ್ತದೆ. ಪ್ರಸ್ತುತ ಏತ ನೀರಾವರಿ ಮತ್ತು ಕೆರೆ ತುಂಬಿಸುವ ಯೋಜನೆಗಳ ಮುಖಾಂತರ ಕೆರೆಗಳಿಗೆ ನೀರು ತುಂಬಿಸುವ ಕ್ರಮ ವಹಿಸಲಾಗುತ್ತದೆ. ಸದರಿ ಯೋಜನೆಯಲ್ಲಿ ನಿರ್ವಹಣೆಗೆ ವಾರ್ಷಿಕ ರೂಪಾಯಿ 300 ಕೋಟಿ ಅಗತ್ಯ ಇರುತ್ತದೆ. ರಾಜ್ಯದ skip the next paragraph thereafter. ಕೆರೆ ಸಂರಕ್ಷಣೆ ಮತ್ತು ಅಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ ಅಧಿನಿಯಮ ಸೋವನ್ಸೋ ಹಾಗೂ ಕೆರೆ ಸಂರಕ್ಷಣೆ ಮತ್ತು ಅಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ ಮತ್ತು ಕೆಲವು ಇತರ ಕಾನೂನು ತಿದ್ದುಪಡಿ ನಿಯಮ ಸೋವನ್ಸೋ 5.1 ಕೆರೆಗಳ ಒತ್ತುವರಿ ಪ್ರದೇಶ. that also not skip the next paragraph. ಕರ್ನಾಟಕ ರಾಜ್ಯದಲ್ಲಿ ಸುಮಾರು 5 ಲಕ್ಷಕ್ಕೂ ಹೆಚ್ಚು ಒಳನಾಡು ಮೀನುಗಾರರಿದ್ದು, ಇದರಲ್ಲಿ ಸುಮಾರು 2 ಲಕ್ಷಕ್ಕೂ ಹೆಚ್ಚು ಮೀನುಗಾರ ಸಕ್ರಿಯವಾಗಿ ಮೀನುಗಾರಿಕೆಯಲ್ಲಿ ತೊಡಗೊಂಡಿರುತ್ತಾರೆ. ಮೀನು ಪಶುವಾರು ಗುತ್ತಿಗೆ ಆದೇಶ ಗುತ್ತಿಗೆದಾರರಿಗೆ ಸೂಕ್ತ ಸಮಯದಲ್ಲಿ ಒದಗಿಸುವುದು ಮುಖ್ಯವಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಒಳನಾಡು ಜಲಸಂಪನ್ಮೂಲಗಳಿಗೆ ಗುತ್ತಿಗೆ ಪಡೆಯುವ ಕಾರ್ಯವಿಧಾನಗಳನ್ನು ಸ್ಥಳೀಕರಿಸಿ ಗುತ್ತಿಗೆ ನೀಡುವ ಅಧಿಕಾರಿಗಳನ್ನು ವಿಕೇಂದ್ರೀಕರಿಸಿ ಮೀನು ಪಶುವಾರು ಹಕ್ಕನ್ನು ಸಕಾಲದಲ್ಲಿ ಗುತ್ತಿಗೆದಾರರಿಗೆ ಈ ಟೆಂಡರ್ ಮುಖಾಂತರ ವಿಲೆ ಮಾಡುವುದರಿಂದ ಒಳನಾಡು ಮೀನುಗಾರ ಸ್ವಯಂ ಉದ್ಯೋಗವನ್ನು ಕಲ್ಪಿಸಿಕೊಡುವುದು ಮುಖಾಂತರ ಅವರ ಸಾಮಾಜಿಕ ಮತ್ತು ಆರ್ಥಿಕ ಸಬಲೀಕರಣಕ್ಕೆ ಒತ್ತು ನೀಡುವ ಜೊತೆಗೆ ಸಣ್ಣ ನೀರಾವರಿ ಇಲಾಖೆ ಯೋಜನೆ ನಿರ್ವಹಣೆ ಹೆಚ್ಚುವರಿ ಭರಿಸಲು ಅನುಕೂಲವಾಗುವ ನಿಟ್ಟಿನಲ್ಲಿ ಈ ಟೆಂಡರ್ ಮುಖಾಂತರ ಕೆರೆಗಳನ್ನು ಮೀನು ಪಶುವಾರ ಹಕ್ಕನ್ನು ಗುತ್ತಿಗೆದಾರರಿಗೆ ವಿಲೆ ಮಾಡಲು ಕೆಳಗಿಂತ ಷರತ್ತುಗಳೊಟ್ಟಿಗೆ ಅನುಮತಿ ನೀಡಲಾಗಿರುತ್ತದೆ. ಫಸ್ಟ್ ನಾಟ್ ದೇ ಸೇ ದಿ ಫಸ್ಟ್ ಗುತ್ತಿಗೆ ಅವಧಿ ಮತ್ತು ಸೋವನ್ಸೋ ಟೆಂಡರ್ ಅರ್ಜಿಯನ್ನು ನಮೂದಿಸಿದ ಅತಿ ಹೆಚ್ಚಿನ ಮೊತ್ತವನ್ನು ಪ್ರಥಮ ವರ್ಷ ಸೋವನ್ಸೋ. I'm not relying on this. Not at para 3 also not they refer to the pricing, but this also becomes relevant as to how not it is totally illogical. Not kindly see, if they say if the tank is filled, 50% will be taken into consideration. Not that is the language that is there. 3.1 page 246.
Yes.
3.1 ಹೊಸದಾಗಿ ಮೀನು ಪಶುವಾರ ಹಕ್ಕನ್ನು ಗುತ್ತಿಗೆಗೆ ನೀಡಲಾಗಿರುವ ಜಲಸಂಪನ್ಮೂಲಗಳನ್ನು ಏತ ನೀರಾವರಿ ಕೆರೆ ಕೆರೆ ತುಂಬಿಸುವ ಯೋಜನೆಗಳಿಂದ ನೀರು ತುಂಬಿಸುವ ಕೆರೆಗಳಿಗೆ ಒಟ್ಟು ಜಲ ವಿಸ್ತೀರ್ಣ 90% ಜಲ ವಿಸ್ತೀರ್ಣವನ್ನು ಉಪಯುಕ್ತ ಜಲವಿಸ್ತೀರ್ಣ ಪ್ರದೇಶವೆಂದು ಎಫೆಕ್ಟಿವ್ ವಾಟರ್ ಸ್ಪ್ರೆಡ್ ಏರಿಯಾ ಹಾಗೂ ಮಳೆಯಾಶ್ರಿತ ಕೆರೆಗಳಲ್ಲಿ ಲೆಟ್ಸ್ ಮೈ ಆಲ್ಸೋ ನೋಟ್ ದಿಸ್ ಮಳೆಯಾಶ್ರಿತ could have never come here. rain fed ಕೆರೆಗಳಲ್ಲಿ ಶೇಖರೀಕರಣವಾಗಿರುವ ನೀರಿನಲ್ಲಿ 50% ಜಲವಿಸ್ತೀರ್ಣವನ್ನು ಉಪಯುಕ್ತ ಜಲವಿಸ್ತೀರ್ಣ ಪ್ರದೇಶವೆಂದು ಗಣನೆಗೆ ತೆಗೆದುಕೊಂಡು ಈ ರೀತಿ ಗಣನೆಗೆ ತೆಗೆದುಕೊಂಡು ಉಪಯುಕ್ತ ಜಲವಿಸ್ತೀರ್ಣಕ್ಕೆ ಮೊದಲನೇ ವರ್ಷ ಪ್ರತಿ ಹೆಕ್ಟೇರ್ಗೆ ರೂಪಾಯಿ 1500ಗಳಂತೆ ಬರುವ ಮೊತ್ತವನ್ನು ಕನಿಷ್ಠ ಗುತ್ತಿಗೆ ಮೊತ್ತದಿಂದ ನಿಗದಿಪಡಿಸತಕ್ಕದ್ದು. ಜುಲೈ ತಿಂಗಳಲ್ಲಿ ಶೇಖರೀಕರಣಗೊಳ್ಳುವ ನೀರಿನ ಪ್ರಮಾಣ ಅಂದಾಜಿ ಪರಿಗಣಿಸಿ ತೆಗೆದುಕೊಳ್ಳಲಾಗುವುದು. ಈ ರೀತಿ ನಿಗದಿಪಡಿಸಿರುವ ಗುತ್ತಿಗೆ ಮೊತ್ತವನ್ನು ಉಳಿದ 4 ಗುತ್ತಿಗೆ ಅವಧಿಯಲ್ಲಿ ಪ್ರತಿ ವರ್ಷ ಹಿಂದಿನ ವರ್ಷದ ಗುತ್ತಿಗೆ ಮೊತ್ತಕ್ಕೆ 10% ಹೆಚ್ಚಿಗೆ ಮೊತ್ತವನ್ನು ನಿಗದಿಪಡಿಸತಕ್ಕದ್ದು. ಪ್ಲೀಸ್ 90% ಜಲ ವಿಸ್ತೀರ್ಣ
for lift irrigation.
For lift irrigation.
Your contention is as regards ಮಳೆ ಆಶ್ರಿತ ಕೆರೆಗಳು, the rainfed
It cannot
could
be
not have been
included at
part
all. That is one. Not in addition to that, even lift irrigation, not my submission is, please see not 90%, not let us assume not the tank is filled with water. But basic common sense would tell us if the water is filled 90% today, but after 15 days it will not be 90%. There will be no water will seep down in the soil. There will be no bore wells dug all over not near the place. Water will seep away. But for the purpose of calculation, they are calculating at the rate of 90% of the water that is not
Can we
infused.
get into the policy, Mr. Manmohan?
No, but I am only on the
Nitty-gritties of it.
irrationality.
You can only argue on the decision-making process.
True.
Insofar as ಮಳೆ ಆಶ್ರಿತ ಕೆರೆಗಳು, you can make your submission. But lift irrigation, how much, all those things, you can't get into nitty-gritties in a writ jurisdiction.
True, Lord. I'm only saying arbitrariness, not from 300 rupees per hectare, it has jumped to 1,500.
Where there are people willing to bid for it. There's so many 4, 5, 6, 7 have come on record as successful
They have
bidders.
come on record, Lord. But the courts have held, Lord, because for us, Lord, in fact, not the other petition, one of the presidents of this society, Lord, was compelled to participate in the tender process. Because, Lord, we have no other source of income. It is a compulsion. If I don't participate, Lord, we have no work. It's our livelihood. So we have compelled to participate, Lord, in all these processes. But I'm only trying to point out, if the government, Lord, is jumping from 300 to 1,500, but there has to be some basis for it. Not because the courts have also held not fixation of price, you have power, no doubt about it. But how did you arrive at that figure? What is the basis for you? Because ultimately, you know, this is being given to people who are fishermen, who are earning out their livelihood there. But I cannot not survive without these tanks. And not government itself encouraged. You establish fishing societies. But if 2014 policy, not I did not read the entire thing, but not the 2014 policy itself says government wants to encourage.
Preamble says.
Yes, Lord. And not even not under the direct to state policy, not government has an obligation to encourage societies.
Cooperative societies.
Cooperative societies. We are all cooperative societies.
After the amendment.
After the amendment. Now, Lord, we are being thrown out. Third-party businessmen want to come in. We are asked to compete with them. Now, that is very unfair. The government is to say, all right, on what basis did you arrive at 1,500 rupees per hectare? And is it not logical for them to fix 3 times or 5 times that price, from 300 to 1,500?
That is only as regards the depend. The whole basis is the amounts expended on lifting the water. That is
They've also done a test case for an hectare of tank, how much produce that arises from the lift, and also from the cost, and also what's the production.
We'll come, let him finish. Otherwise it will be ping pong.
Not finish. On a lighter note, I don't know whether I should say this, but not 300 crores for the government, but is not a huge amount. But for us, not it is livelihood. But I'm only trying to bring an analogy. When the government can give lots of schemes, money is given to lot of people, free, everything is given. Why not for us fishermen? We belong to scheduled caste, scheduled tribe. There are minorities, we are societies. For us, for livelihood, we are not getting anything.
Can we say anything about that?
No, I'm only trying to say illogical and arbitrariness. It smacks of this. Only to that extent.
To what they say about it.
Very well. Only to that extent. But then, there are 2 documents which are tenders that are issued. I will not, because subsequent to this, tenders are issued.
Your argument on this is basically twofold. Number one, that the increase from 300 to 1,500 is arbitrary and illogical. 2 is the rain-fed lakes cannot be included here because that is not part of the policy.
Yes. Page 255, my lord should turn to. But annexure S is the tender notification. I will not trouble reading it. That is also impugned here because they have included the rain-fed tanks. But at page 255, this is the letter which is issued by the 3rd respondent. But this is of some relevance. Please turn to page 257.
Yes.
But the 3rd paragraph. ಮೀನುಗಾರಿಕೆ ಇಲಾಖಾ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ 4,041 ಕೆರೆ, ಜಲಾಶಯ ಮತ್ತು ನದಿ ಭಾಗಗಳು ಇದ್ದು ಅವುಗಳು ಪೈಕಿ ಸಣ್ಣ ನೀರಾವರಿ ಇಲಾಖೆ 3,828 ಕೆರೆ ಜಲಾಶಯಗಳು ಪೈಕಿ 1,897 ವಿಲೇವಾರಿ ಮಾಡಲಾಗಿದೆ ಹಾಗೂ 1,931 ಕೆರೆಗಳನ್ನು ವಿಲೇವಾರಿಯಾಗದ ಕೆರೆಗಳು ಇರುತ್ತದೆ. ಅವುಗಳು ಜಿಲ್ಲಾವಾರು ಮಾಹಿತಿಯನ್ನು ಈ ಪತ್ರದಲ್ಲಿ ಸಲ್ಲಿಸಲಾಗಿದೆ. ಮುಂದುವರೆದು ತಮ್ಮ ಸುತ್ತೋಲೆಯಲ್ಲಿ ಈ ಕೆಳಗಂಡ ಅಂಶಗಳನ್ನು ಅಳವಡಿಸಿಕೊಳ್ಳುವ ಕೋರಲಾಗಿದೆ. ಸಣ್ಣ ನೀರಾವರಿ ಇಲಾಖೆಯಿಂದ ಏತ ನೀರಾವರಿ ಕೆರೆಗಳನ್ನು ಮಾತ್ರ ಈ ಟೆಂಡರ್ ಮಾಡುವುದು, ಉಳಿದ ಏತ ನೀರಾವರಿಯಲ್ಲದ ಮಳೆಯಾಶ್ರಿತ ಕೆರೆಗಳನ್ನು ನೋಂದಾಯಿತ ಮೀನುಗಾರ ಸಹಕಾರ ಸಂಘಗಳಿಗೆ ಗುತ್ತಿಗೆ ನೀಡುವುದು. Because fisheries department, we are all dependent on this. The fisheries department says only where there's lift irrigation you give it, otherwise you don't give it. Not page 258, the last but one paragraph. ಮುಂದುವರೆದು ಮೀನುಗಾರಿಕೆ ಇಲಾಖೆ ಒಳನಾಡು ಗುತ್ತಿಗೆ ಕಾರ್ಯನೀತಿ 2014 ಅನ್ನು ಸಚಿವ ಸಂಪುಟ ಅನುಮೋದನೆ ಪಡೆದ ಆದೇಶವಾಗಿದ್ದು, ತಾವು ಹೊರಡಿಸುವ ಸುತ್ತೋಲೆಯ ಬದಲು ಅಗತ್ಯವಿರುವ ಅನುಮೋದನೆ ಪಡೆದು ಸರ್ಕಾರದ ಆದೇಶ ಹೊರಡಿಸಿರುವ ಸೂಕ್ತವಾಗಿರುವುದು ಎಂದು ಅಭಿಪ್ರಾಯಲಾಗಿದೆ. ಇದಲ್ಲದೆ ಮೀನುಗಾರ ಸಹಕಾರ ಸಂಘಗಳು ಪುನಃ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ದಾವೆ ಹೂಡುವ ಸಂಭವವಿರುತ್ತದೆ. Saying you just follow 2014 policy. But 2014 policy is a policy which is prepared by the government, that is by the cabinet. But it is a decision taken by the cabinet. Now these subsequent orders, none of them are by the cabinet. These are all not orders. 2018 is an amendment. But of course I will not get into it. I cannot get into it.
It's already been upheld.
It has been upheld. But these orders are not by the cabinet. They're all issued. One is by this impugned order circular is issued by the second respondent. Therefore, he cannot tinker with the policy of 2014. He cannot say something contrary to it. The transaction of business rules also not categorically point out what decisions can be taken. But if need be, I'll point out that as well.
If need be, whatever you want to argue, please argue.
Because I don't want to make it a lengthy submissions, because according to me, all that I'm saying
what you have submitted.
Yes. What I'm submitting as of now is, insofar as this rain-fed tanks, please exclude it. Don't include it in the notification. Now, one fact, please note, there was an interim order that was granted before by the Honorable Court in the writ petition. But the government filed a memo initially. They said these are the tanks, etc. Then, we pointed out that there is complete incorrect statements in those details furnished. Then, the Honorable Court passes an interim order saying that strictly it shall be in accordance with the order dated 25/3/2026.
In which matter was that?
In the second matter. 7194
order sheet. Order dated?
No, order dated 25/3/2026.
Yes.
In light of the submission made by the learned Additional Advocate General on instructions that learned Government Advocate, and upon perusal of the memo filed today indicating that 119 water tanks stand exclusively excluded for allotment to fishery societies, learned counsel for the petitioner submits the state be directed to place in record a specific undertaking by an affidavit affirming that the remaining 471 water tanks are supported by lift irrigation. Taking note of the said submission, this court deems it appropriate to direct the secretary to the Department of Minor Irrigation to file an affidavit within a week, with a period of 1 week, placing on record and affirming the correctness of the particulars furnished in the tabular statement annexed to the memo. Further, on perusal of the table furnished by the state, it is noticed that the same includes 99 water tanks categorized as rain-fed tanks. But they filed a memo saying that all this will be taken forward, but there we noticed 99 of those tanks were rain-fed tanks. This court is of the considered view that the respondent department cannot, under the guise of classifying tanks as being supported by lift irrigation proceed to auction such rain-fed tanks, particularly pending consideration of the present petition. Accordingly, is directed that the authority shall ensure that any process of auction of water tanks shall be strictly confined only to those tanks which are demonstrably supported by lift irrigation and shall not include 99 rain-fed tanks until further order of this court. Now, in this context, they filed an affidavit. That was filed on 22/4/2026.
Filed on?
Not 22/4/2026.
Yes.
But here, not para 6, they say not the total number of tanks not at 3,764. One place, not one number. Across all districts of Karnataka belong to minor irrigation department. Out of these, 925 tanks are filled through lift irrigation bar tank filling schemes and 2,839 tanks are filled by rainfall. I state that along with the memo details the list of tanks through the lift irrigation were enclosed. Page para 7 note, there is a chart. Mentioning the
difference is only a one tank.
There not the difference only one tank. No, but the total number not changes. Some place it is said is different, here it is different.
Now that the secretary has filed it, this is the final number that we'll have to take into consideration. There's no other person that we can ask better than the secretary to file.
True.
So this, if it's taken as final, 3,764 tanks across all districts, 925 are lift irrigation. And 2,839 are rain-fed. So 2,839 cannot be auctioned.
2,839 cannot be auctioned.
Yes. Now this 2,839 you have applied for, your societies have applied for any
in the connected writ petition, connected writ petition, one of the president of not the association has filed in his individual capacity, where not after there also not he applied, because that is the only way he could not save not the tank from being going anywhere else. Not in that not the other relief that he has sought for is here not the tender was called for. This honorable court stayed insofar as rain-fed tanks are concerned. But what not they did there was, despite him being the successful bidder, not they said we are not giving you the tank.
That was for lift or rain-fed?
Not, it included about 2 rain-fed and 5 not which were lift irrigation. I'll give the exact number. Correct.
Now, do we have the names of the tanks which are lift irrigated and rain-fed?
But in the affidavit that is filed by them, the government which
will only given the number. The details of the tanks are not available.
Tank name is there, not serial number 6. What not they have filed?
So there is a
document number. I think it's page 13.
No, this is not giving page 13. Yes.
I think serial number 6, not on the column 6 rather. Column 6 at page 13 of their objections. They mention the tank name.
These are 590 tanks.
Yes, lots are right. These were not subject matter of the tender notification.
These are these are tanks tendered for disposal of fishing rights.
Yes, but because
590 tanks were tendered.
590 tanks were tendered. That is when we again came before this honorable court in this writ petition, pointing out you have again violated the court order.
Do we have the list of, have they
filed total blood? No. Total to my knowledge.
2,930 which are rain-fed.
To my knowledge, it's not.
And the 925 which are lift irrigated.
No.
Is it web hosted somewhere? Is there any data available as regard?
Not to my knowledge.
Not to.
In fact, the fisheries department may have not tanks which they are not giving on lease. And lift irrigation will have tanks not which they are giving on lease or not where they are filled. Those details only they will be able to give us.
But all the tanks come with the mine within the purview of the minor irrigation department.
No, fishing department, what they do is the tanks which come under the jurisdiction of fisheries department, those will be given only by the fisheries department.
Is
Now,
the fisheries department also a party to this petition?
Yes, Lord, I think respondent number
is, again, from what you're saying, the wording is important. Para 6 is very clear. 3764 tanks belong to minor irrigation. So this particular para 6 is only referring to minor irrigation, not to fisheries department.
Yes, it is.
Between these two departments, all tanks are taken care of across the state.
They'll have to clarify because according to me, but this I'll just take instructions, right? But I'll seek instructions and make a statement because I'm told, Lord, that the fisheries department will deal with certain tanks which are given to it, and all these auction and everything comes under them. Now, because of the amendment which came in 2018, lift irrigation, Lord, the seclusion was made insofar as lift irrigation tanks are concerned.
Okay. Anyway, we'll ask those
but I don't want to
questions
make an incorrect statement.
We'll ask.
I'll also seek instructions on that. But only Lord, one judgment, Lord, which Lord should see with regard to fixation of price. But in
the scope of interference.
Yes. But para.
Just one. Yes.
But para 21, not
Prakash Dalmi, 21. Yes.
But after the judgment is extracted, just above para 22. These observations make it clear that the High Court has jurisdiction to satisfy itself on the material on record that the authority has not acted in an arbitrary or erratic manner. In our opinion, High Court in the present case has not acted beyond such jurisdiction. Mrs. Suri then relied upon on so and so. In the aforesaid case, this court reiterated jurisdiction of the High Court to satisfy itself with regard to material on record to justify escalation of cost of a house bar flat. But I'll not trouble my lords with that. Then para 23.
Yes.
The board being a state within Article 12 of the Constitution of India is required to act fairly, reasonably and not arbitrarily or whimsically. The guarantee of equality before law or equal protection of the law under Article 14 embraces within its realm exercise of discretion powers by the state. The High Court examined the entire issue on the touchstone of Article 14 of the Constitution of India. It has been observed that fixation of price by the board has violated Article 14 of the Constitution of India. It is correctly observed that though Clause 7b permits the board to fix the final price of the demised premises, it cannot be said where the board arbitrarily or irrationally fixes the final price of the site without any basis. Such fixation of price could bind the lessee. In such circumstances, court will have the jurisdiction to annul the decision upon declaring the same to be void and non-est. Even para 25, Lord, the court deals with, even though the clause gives the board an undefined power to fix the final price, it would have to be exercised in accordance with the principle of rationality and reasonableness. The board can and is entitled to take into account the final cost of the demised premises in the event of it incurring extra expenditure after allotment of site. But on the garb of exercising power to fix the final price, it cannot be permitted to saddle the earlier allottee with the liability of sharing the burden of expenditure by the board in developing some other sites subsequent allotment of site to the respondents. So only to this limited extent, not because there is no calculation that they were based on record to say how they have arrived at this figure. Then not the only last submission is not Article 39, 41, 43B and 46. Not all these provisions or articles not require the
Articles
state to
39.
do. Not Article 39.
You give us the article numbers, that's it.
Article 39, 41, 43B and 46.
DPSP have to be followed. Though not justiciable, but it should be followed.
Because they have to encourage societies and not SC/STs. Please.
Anybody
But
else?
the other matter not is where the first matter, but that is where not the tender is notified and the petitioner had participated in the tender and declared not as a successful or the highest bidder. But after which not the government says
18949.
please 1894. But I just briefly pointed only the facts. I will not get into other nitty-gritties. The issue is only they have not have sought for a mandamus saying that you declared me of the highest bidder. Now they say not because the interim order in the second matter, they're saying the entire thing we are going to cancel.
So 18949 is lift irrigation or rain fed?
But I'm only asking in respect of lift irrigation.
18949 is
Yes.
lift irrigation.
Yes, the tender was for the entire thing, consisting of two other not rain fed. We are not asking for that because we don't want that. It should go to the society. But at least where I've declared as a successful bidder,
5 lakes, 3 of them are lift irrigation.
not a total not are 7, out of which not 5 not are lift irrigation. Only for 5 not I'm asking now.
7 lakes, 5 lift irrigation.
Please.
2 are rain fed.
Rain fed. But they cannot be.
So this has to go back to society.
Yes.
Yes.
But under the garb of the interim order that was granted, they are saying no, I have to give it back. That is all. Please.
3, 4, 5 are lift irrigation or rain fed? Rain fed. 14660 of 26. 16546 of 26. 16687. 20815 of 26. All these are rain fed.
We are seeking reservation as per the government circular dated 18/2006.
8997 Srinivasa.
Please.
I
I am the Melad. I am the successive bidder in the tender process, Melad.
First to lift rain fed first adi helಬೇಕು ನೀವು. Is this a rain fed tank or is it a lift irrigation? 8997. 8997 of 26. ತಾನೇ ನೀವು ಅಪಿಯರ್ ಆಗ್ತಾ ಇರೋದು.
2.2.
ಇಲ್ಲ
2.2.
ಮತ್ತೆ ಅದಕ್ಕೆ ಹೇಳಿದ್ರೆ ನೀವು Mr. Srinivasa. We'll come to that. 2.2 ಯಾರಿದ್ದಾರೆ? Nobody. 2.2 none appears. Yes. 2.6 Ajay R.
Malats, I'm appearing for the petitioner, Malats.
Yes.
Rain fed, Malats. My tender was extended for the period of 2 years.
19019 is rain fed.
Yes, Malats.
Mithun, you'll have to make your submission on that. 2.6 is rain fed. Yes, Sriram, tell us.
Malats,
what's your submission?
Malats, what has happened is
We can't hear you.
Malats, am I audible, Malats, now?
Yes, you are. You are.
Yes,
We can
Malats.
hear you.
So 2 years, my tenure had been extended by the fisheries department, Malats. Then, after I pay the money, whatever the bid amount they had told me, after receipt of that, suddenly one tender has been called for by minor irrigation, Malats. I challenged that.
Yes.
Now they say last hearing date they had filed a memo saying that this particular order has been revoked. Even when there was a stay operating, they had filed it in the last date dated 14/7/2026. ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮೀನುಗಾರಿಕೆ ಉಪನಿರ್ದೇಶಕರು ಕೋಲಾರ ಜಿಲ್ಲೆಯವರು ಸಣ್ಣ ನೀರಾವರಿ ಮತ್ತು ಅಂತರ್ಜಲ ಅಭಿವೃದ್ಧಿ ವಿಭಾಗ ಕೋಲಾರರವರಿಗೆ ಸದರಿ ಕೆರೆಯು ದಿನಾಂಕ 30/6/20ಕ್ಕೆ ಅಂತ್ಯವಾಗುತ್ತದೆ ಎಂದು ದೃಢೀಕರಣ ನೀಡಿರುವುದರಿಂದ ಸಣ್ಣ ನೀರಾವರಿ ಮತ್ತು ಅಂತರ್ಜಲ ಅಭಿವೃದ್ಧಿ ವಿಭಾಗ ಕೋಲಾರರವರು ಸದರಿ ಕೆರೆಯನ್ನು ಟೆಂಡರ್ ಕರೆದಿದ್ದು ಹಾಗೂ ಸದರಿ ಕೆರೆಯ ಟೆಂಡರ್ ವಿಚಾರವಾಗಿ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ರಿಟ್ ಅರ್ಜಿ ಸಂಖ್ಯೆ 19019/26 ರಲ್ಲಿ ಪ್ರಕರಣ ದಾಖಲಾಗಿರುವುದರಿಂದ ಹಾಗೂ ಸಣ್ಣ ನೀರಾವರಿ ಮತ್ತು ಅಂತರ್ಜಲ ಅಭಿವೃದ್ಧಿ ಇಲಾಖೆ ಸರ್ಕಾರದ ಸಚಿವಾಲಯ ಬೆಂಗಳೂರು ಪತ್ರ ಸೋ ದಿನಾಂಕ 23/6/2026 ರಲ್ಲಿ ಮೀನುಗಾರಿಕೆ ಇಲಾಖೆಯಿಂದ ಈಗಾಗಲೇ ಗುತ್ತಿಗೆ ಈ ಟೆಂಡರ್ ಪರವಾನಗಿ ನೀಡಿದ್ದು ಜೂನ್ 26ಕ್ಕೆ ಅಂತ್ಯಕ್ಕೆ ಹಾಗೂ ತದನಂತರದಲ್ಲಿ ಗುತ್ತಿಗೆ ಅವಧಿಯು ಮುಕ್ತಾಯಗೊಳ್ಳುತ್ತಿರುವ ಕೆರೆಗಳಲ್ಲಿ ಮೀನುಗಾರಿಕೆ ಗುತ್ತಿಗೆಯನ್ನು ವಿಸ್ತರಿಸದಂತೆ ನವೀಕರಿಸದಂತೆ ಹಾಗೂ ಏತ ನೀರಾವರಿ ಕೆರೆ ತುಂಬಿಸುವ ಯೋಜನೆಗಳಿಂದ ನೀರು ತುಂಬಿಸುತ್ತಿರುವ ಸಣ್ಣ ನೀರಾವರಿ ಇಲಾಖೆ ಕೆರೆಗಳಲ್ಲಿ ಮೀನುಗಾರಿಕೆ ನಡೆಸಲು ಯಾವುದೇ ಹೊಸ ಗುತ್ತಿಗೆಯನ್ನು ನೀಡಬಾರದೆಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಉಲ್ಲೇಖದಲ್ಲಿ ನಮೂದಿಸಿರುವ ಗುತ್ತಿಗೆ ಆದೇಶವನ್ನು ತಕ್ಷಣದಿಂದ ಜಾರಿಗೆ ಬರುವಂತೆ ರದ್ದುಪಡಿಸಿ ಆದೇಶಿಸಿದೆ. ಗುತ್ತಿಗೆದಾರರು ಪಾವತಿಸಿರುವ ಮೊತ್ತವನ್ನು ಹಿಂದಿರುಗಿಸಲು ಆದೇಶಿಸಿದೆ. ಏತ ನೀರಾವರಿ, what they are saying, it is not at all concerned to me. And they have received the money also. They have confirmed my tender for the further period of 2 years because of no rainfall in that region.
Yes.
And even when there is a stay operating against them, they issue such kind of an order which has been placed before this honorable court, Malaj.
Yes. 2.7 Sandesh. Rain fed. You have participated in the tender? You have participated in the tender?
This is new now.
2.9 Ramesh Kehar. We will get those details from them. 2.9 Ramesh Kehar Ilva. So additional question, what we'll require is the full list of tanks of irrigation department, fisheries department, which other departments is handling tanks?
Please.
All the departments. Don't try to only bring it under irrigation. You classify it, but the total, because as Mr. Manmohan said, there's a large difference in each order that you have issued, circular you have issued, order you have passed, government orders that you have passed, there's difference. One of them even goes up to 41,000.
Understood.
Then it comes down to 4,000. So where is this going from?
Irrespective of the department, the whole list of tanks. I understood.
Then what we need is, what is the, which of them are lift irrigation tanks? And how much of money have you spent for the last, from the time that it has been made amenable to lift irrigation, from the time it was made amenable to lift irrigation, year on year? Then what is the, we'll dictate the order. What is the cost that you have incurred, and what is the basis of this calculation of 1,500? Third, though an earlier affidavit has been filed by the Principal Secretary, Minor Irrigation Department, there are still various Essentially, the claim made by the petitioners is that not only lakes which are fed by lift irrigation, but naturally rain-fed lakes have also been included in the tendering process. By referring to the 2014 fisheries policy, it is contended that initially all the lakes had to be made available to the fishing societies and there could be no tendering process in respect thereto. Subsequently, in the year 2018, on account of an amendment made to para 4 of the fisheries policies 2014, the concept of tendering of fishing rights in lakes which were lift irrigated was brought in. Though the same had been challenged, the challenge was rejected by this court. In that view of the matter, it is clear that insofar as lakes which are fed by lift irrigation, on the lakes filled by lift irrigation, so as to ascertain the quantum of monies which have been spent, since in terms of the amendment made in the year 2018 to the fisheries policy 2014, it is only the amounts which have been expended for lift irrigation which could be recovered by way of the tendering process. Hence, next para. Apart from the above, from the various circulars which have been issued, from our government orders which have been passed, and the submissions which have been made before this court in various proceedings, it is not clear as to how many lakes are there in the state of Karnataka, how many lakes, which of those lakes stroke tanks, and which of them come under the administrative jurisdiction of which authority. Hence, the respondents are directed to file an respond number. Chief Secretary is a party?
No, that's what I was looking at.
Since there are multiple departments which are involved, and it's not clear as to which department owns, is the administrative, under which department has administrative supervision of the lakes, and more so when a consolidated report is to be filed. This court is of the constitution that the state of Karnataka, represented by its chief secretary, is required to be brought on record. And as such, the state of Karnataka, represented by chief secretary, is brought on record as respond number 7 in WP number 7194 of 2026. Counsel for the petitioner to carry out necessary amendment and file amended cost act. Learned AG accepts notice for the impleted chief secretary respond number 7. The Chief Secretary, Government of Karnataka, is directed to file a detailed affidavit indicating the following. 1. Total number of lakes stroke tanks in the state of Karnataka. 2. Out of the aforesaid lakes, to clearly delineate and demarcate which lakes come under the administrative supervision of which department, be it the minor irrigation department, the fisheries department, the
Panchayat and
animal fisheries department in there.
But local bodies.
Local bodies, municipal bodies, development authorities, and or the like. each of the departments is directed to web host all the lakes stroke tanks which come under the purview of each particular department. While so web hosting the names of the lakes, all the details of the said lake, including the area of the lake, location, survey number, geotagging details, would also have to be uploaded. Correct. In the event of any of the lakes being fed by lift irrigation, the details of such lift irrigation, firstly, it should be classified as a lift irrigation fed lake. Secondly, the details of the manner of feeding the said lake by lift irrigation from the inception, declaring the date of it being lift irrigation fed to be included. These details would have to the details would also have to include the quantum of water which has been lifted for the purpose of filling this particular lake, the amount of expenses incurred in terms of the electricity and or any other aspect relating to said lift irrigation feeding of that particular lake. Amile?
The other thing is not for arriving at this 1,500.
These expenses are there.
Now, they will try to justify it because still not have
They'll
not
have
done it.
to have those details. They can't. They have to pay BESCOM. They have to pay JESCOM. Everybody they have to pay. It's not easy for them to do that.
Some lakes we have some lakes we have already we have to collect the fish. We have to not actually put it for growing. Now because of these issues, we're not even able to catch
So
the fish.
this one, the details as regards, though there's a statement made that reservation is made for persons belonging to scheduled castes and scheduled tribes as per the KDTP Act. It would also have to be explained as to whether that reservation is for persons belonging to scheduled castes and scheduled tribes, or would it also be available for association of persons of scheduled caste and scheduled tribes. The said affidavit to be filed within 10 days time from now.
Lots is asked for each tank. Lots. I request the.
Every detail should be available with you.
Lake Siratna, I request to substitute tanks.
Lake stroke tanks.
Though.
Stroke water bodies.
I was just asking how long they would take. But I think they only have minor irrigation department and they have fisheries. But then we'll have to check with each and every local.
You have everything.
At least I think 2 weeks is required. But we
Can I
also
make
have
one request? Can it be only in respect of lift irrigation and fisheries? So that otherwise it will only enlarge. They will
immediately for the immediate purpose. The lakes coming under the jurisdiction of the irrigation department and fisheries department to be furnished by 24th August 26, released on 24th August. Interim order earlier granted is extended till next.
But within that time, the other
25th minutes.
Only for irrigation fisheries right now.
I think
can go on upload.
Minutes 25th or 23rd minutes, please.
23rd, you will only have to come. We won't come.
Minutes 25th.
You are welcome to come.
Minutes 25th minutes, please. I am not available on 24th. Please, minutes.
25th.
What I've been told, I'm sorry. What I've been told, the fisheries department and the irrigation department, the issue is this: the feeding season for the fisheries, for the tanks, is only now, June, July. Now, because the continuation of the interim orders, at least the Lordship may look at the fact if at least lift irrigation could be allowed, tenders.
Lift irrigation, they want to participate also. The question is 300 to 1,000.
But they'll be subject to outcome of the writ petition, whatever they pay.
They don't need to pay if you say.
Lift irrigation,
and everybody will
they have no objection per se to the lift irrigation. What they're saying is the tender should not extend to rain-fed tanks. That may be put on hold a lot. At least a lot may permit the tenders for lift irrigation tanks.
Even the rain-fed has to be given so that they can start showing they have to drop the eggs and all
Lots
those
that
things. they have to
lease,
do.
lots for now, lease can be pursued a lot until the Lordships decides on the matter whether the tender also extends to rain-fed tanks. But for now, I think the other side has no objection towards.
Or we'll have it next week. You make your submission as to what the rain-fed are. So that rain-fed, if we record your submission, that it will be given to the societies.
Please, lots.
That should take
Then the
care of
Lordship may
most
have
of
it
their
on Monday, or at least little bit of relief.
So there
in
are
this
thousands
case.
of people who are going
Please.
to be affected by this.
Please.
That is the reason why this matter.
Please, Lordship may have it on Monday.
Monday.
Please.
Relist on Monday.
At least.
Which are rain-fed if you do that. And that can be, that can go immediately to the society.
Please, lots. And at least the lift tanks can, at least the tender can continue with those things.
Lift, you will have to give us the details. Your details which had been asked for are not clear.
I'll see to what extent I can try and assist your Lordship by Monday, lots.
Whenever you are ready, we are.
Tuesday, man. Tuesday, 2:30.
Tuesday, 2:30.
Please.
Wait, please. 2:30 matter. I can see some 2:30 matter.
Can't take up anything.
Serial
End of the list.
My lord. Siddharth Suman.
So Siddharth Suman.
Yes.
What is this?
This pertains to elections, which was conducted today, Manoj, at 3 o'clock. The manner in which the elections were also conducted, the urgency was this, Manoj. It was sent on a private group. The calendar, no calendar of events, nothing, Manoj. It was sent on a private group.
We'll have to file a suit in the society.
May I just try to persuade why? Because as far as the bylaws are concerned, yes, this pertains to back then KAB, but today BESCOM, BESCOM SC/ST Welfare Association. What happens is, there are 3 calendars of events. So it's elections pertaining to first is the delegate delegation.
Writ court has no jurisdiction over this, Mr. Suman.
Yes.
Full bench of the Madras High Court, Supreme Court, our 3 coordinate benches have also held it.
Yes.
Society we don't have except for limited 25.
Please.
And 27A. That's the only jurisdiction.
Please.
Not election. File a suit. That's how much we can say.
Then I'll just.
Petitioner is before this court seeking for the following reliefs. Notice to respondents is dispensed with in view of the proposed order to be passed. In view of the decision of the full bench of the Honorable Madras High Court in so-and-so, as approved by the Honorable Apex Court in so-and-so, election dispute relating to a society registered in Societies Registration Act cannot be a subject matter of a writ petition, reserving liberty to the petitioner to avail such civil remedies as are available. Petition
Some judgments, with all due respect, some judgments would say, if it's flouting the bylaws, then I could still come on a writ.
All civil suit.
My lords, with your lordship's kind leave, my lord.
All interim orders will be extended.
My lord, with your lordship's kind leave, my lord.
Second list.
Madam, pass over ಆಗಿದೆ.
ಹೇಳ್ತೀನಿ ಒಂದು 6 7 ನಾಳೆ ಅಂದ್ರೆ ಪಾರ್ಟೀಸ್ ಬರ್ತಾರಾ? ಹೌದಾ? 237 ಸೀರಿಯಲ್ ನಂಬರ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 11 ಪಾಸ್
ಈಗ ಫಾಸ್ಟ್ ಓವರ್ಸ್ ಎಲ್ಲ ನಾಳೆ. ಫಾಸ್ಟ್ ಓವರ್ಸ್ ನಾಳೆ. ಒಂದ್ ನಿಮಿಷ ಲಿಸ್ಟ್ 1 ರಿಮೈನಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಫಸ್ಟ್ ಸೆಪ್ಟೆಂಬರ್. ಲಿಸ್ಟ್ ನಂಬರ್
ಮೇಡಮ್ ನಮ್ದು ಸ್ವಲ್ಪ ಅರ್ಜೆನ್ಸಿ ಇತ್ತು ಮೇಡಮ್. ಎನಿ ಡೇಟ್ ಇನ್ ದಿಸ್ ಮಂತ್.
ಫಾಸ್ಟ್ ಓವರ್ಸ್ ಮಾತ್ರ ನಾಳೆ.
ಅಲ್ಲ ಮೇಡಮ್ ಅವರೇ,
ಪೇಜ್ ವೈಸ್ ಬರ್ತೀನಿ. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಕಮ್ಮಿ ಇರ್ತಾರೆ, ಕಳಿಸ್ಬಿಡೋಣ ಅವ್ರನ್ನ. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 3 14 ಪರ್ಸನ್. ಅವ್ರು ಕೇಳೋ ಡೇಟ್ 14 ಪರ್ಸನ್ ಯಾವತ್ತು? ನಾಳೆನಾ? ಎಂಟ್ರಿ ಮಾಡಿದ್ರ ಆಗಲ್ವೇ? ಸೀರಿಯಲ್ ನಂಬರ್ 4 98. ಹೇಳಿ ಡೇಟ್ ಹೇಳಿ ನೀವೇ. 3.1 ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರ? 4 ಡೇಟ್ ಹೇಳ್ಬೇಕು. 19/8 ಇಲ್ಲ ಅಂದ್ರೆ ಹ? ಅಲ್ಲ ಅಷ್ಟೊಂದು ಬೇಡ. ಫರ್ದರ್ ಇಯರಿಂಗ್ ಅಲ್ವಾ ಎಲ್ಲ ಪಾರ್ಟೆಡ್ ಮ್ಯಾಟ್ರು. ಸ್ವಲ್ಪ 19/8 ಸೀರಿಯಲ್ ನಂಬರ್ 5 ಯಾವತ್ತು? ಡೇಟ್ ಮಾತ್ರ ಹೇಳಿ ಅಷ್ಟೇ. ಸೀರಿಯಲ್ ನಂಬರ್ 6 19/8 7 ನಾಳೆ 8 9 ಇಬ್ರು ಸೇರಿ ಒಂದೇ ಡೇಟ್ ಹೇಳ್ಬೇಕು. ಒಂದೇ ಒಂದ್ ಡೇಟ್ ಹೇಳಿ. ನಾಳೆ ಬೇಕಾ ಬೇಡ? ಯಾವುದು?
ಯಾವ್ದೋ ಒಂದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಎರಡರಲ್ಲಿ ಅವ್ರು ಗಂಡ ವಿಡ್ರಾ ಮಾಡ್ತೀನಿ ಅಂತ
ಸದ್ಯಕ್ಕೆ ನಾಳೆನೇ ಇರ್ಲಾ?
ನಾಳೆನೇ ಇದೆ.
ಆಯ್ತು. 10 ಇಲ್ಲ ನಾಳೆ ಅಂತಿದ. ಇಬ್ರು ಸೇರಿ ಒನ್ ಡೇಟ್ ಹೇಳಿ ಅಷ್ಟೇ. ಇಬ್ರು ಸೇರಿ ಇಲ್ಲಾಂದ್ರೆ ಇರಿ, ನಾನು ಹೋಗಿ ಸಾಹೇಬ್ರ ಹತ್ರ ಕೇಳ್ಕೊಂಡ್ ಬರ್ತೀನಿ. ಇದೆಲ್ಲ ಮುಗಿದ್ಮೇಲೆ ಹೋಗ್ತೀನಿ. ಯಾವತ್ ಹೇಳ್ಬಿಡಿ. ಡೇಟ್ ಹೇಳ್ಬೇಕಷ್ಟೇ. ಎಂಟ್ರಿ ಮಾಡ್ರಿದೆ 2 ದಿನಕ್ಕೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಲ್ಲ, ಹೋಗ್ಬಿಡುತ್ತೆ. ಇನ್ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ತಗೊಳ್ಳಿ. ಲಿಸ್ಟ್ 1 ಬರ್ತೀನಿ. ಲಿಸ್ಟ್ 1 ಅಲ್ಲ ಪೇಜ್ ವೈಸ್ ಬರ್ತೀನಿ. ಪೇಜ್ ಹಿಂಗೆ ತಿರ್ಗಿಸ್ತಾ ಇರ್ಬೇಕು. ಅದಕ್ಕೆ ಲಿಸ್ಟ್ 6 ಈಗಷ್ಟೇ ಕೊಟ್ಟೆ ಎಲ್ಲ. ಮತ್ತೆ 5 ಡೇಟ್ ಹೇಳಿಲ್ಲ. ಲಿಸ್ಟ್ 19 ಯಾವತ್ತು? ಸೆಕೆಂಡ್ ಸೀರಿಯಲ್ ನಂಬರ್ 5 ಯಾವತ್ತು ಸರ್? ಒಬ್ಬೊಬ್ರು ಒಂದೊಂದು ಹೇಳ್ತಾರೆ. ಕನೆಕ್ಟೆಡ್ ಇದೆ ತುಂಬಾ. ನಾನು ಹಾಕ್ತೀನಿ ಬಿಡಿ ಆಮೇಲಿಂದ. ಪೇಜ್ ವೈಸ್ ಬರ್ತೀನಿ. ಪೇಜ್ ವೈಸ್ ಲಿಸ್ಟ್ 1 ಸೀರಿಯಲ್ ಪೇಜ್ ನಂಬರ್ 8 41 to 46 ಯಾವತ್ತು? ಪೇಜ್ 9 48 to 50 49 ಯಾವತ್ತು? ಆಯ್ತು, ನಾಳೆ ಎಲ್ಲ ನಾಳೆ. ಹಿಂದಕ್ಕೆ ಹೋಗ್ತೀರಾ? ಫಾಸ್ಟ್ ಅವರ್ ನಾಳೆ. ಫಾಸ್ಟ್ ಅವರ್ ಅಲ್ವಾ? ಅದು ಯಾವತ್ತು ಬೇಕು? ಫಾಸ್ಟ್ ಅವರ್ ಎಲ್ಲ ನಾಳೆ ಬೇಡ. ನಾಳೆ 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 ಫಾಸ್ಟ್ ಅವರ್ ಎಲ್ಲ ನಾಳೆನೆ. ಪೇಜ್ ವೈಸ್ ಬರ್ತಾ ಇದ್ದೀನಿ, ಮತ್ತೆ ಡಿಸ್ಟರ್ಬ್ ಮಾಡ್ತೀರಾ. ಪೇಜ್ 10 ಸೀರಿಯಲ್ ನಂಬರ್ 51 to 56 ಬಿಟ್ಬಿಟ್ನಾ? 40 44 ಯಾವತ್ತು? ರೀಚ್ ಆಗಲ್ಲ, ನಾಳೆನೂ ರೀಚ್ ಆಗಲ್ಲ. ಪೇಜ್ ವೈಸ್ ಬರ್ತಾ ಇದ್ದೀನಿ ಸರ್. 51 to 56 51 ಯಾವತ್ತು ಸರ್? 2 weeks ಅಂತಂದ್ರೆ 1st February. ಅಯ್ಯೋ, 1st Februaryಗೆ ಹೋಗ್ತಾ ಇದ್ದೀನಿ. ಸೆಪ್ಟೆಂಬರ್ ಇದೊಂದು ತೆಗೆದ್ಬಿಡೋಣ, ಮ್ಯೂಟ್ ಮಾಡ್ಬಿಡೋಣ.